Well, good morning and thank you for joining us. Today is day 5 in the trial of former Grand Rapids Police Officer Christopher Schurr, who's charged with second-degree murder in the killing of Patrick Lyoya. We have crews live across downtown Grand Rapids, both inside and outside the courthouse, ready to bring you updates as they happen. 13 on your sides, Kyle Lichter and Riley Mack are inside the courthouse viewing the trial live and updating our live blog on 13onyourside.com. We also want to bring your attention to something we've been talking about this whole trial. We're delivering you the live stream of the trial on a court-mandated 30-minute delay. 13 on Your Side was instructed by the judge to stream the trial on this delay so that any sensitive information that is not supposed to be broadcasted, like personal details, can be redacted before it's put on air. There are no other modifications to how we are delivering you this trial, and we will remind you of this delay throughout the day. I want to bring in Emily and Tanner. Again, a very tense day in the courthouse.
Yeah, definitely. Hearing more witnesses for the defense. Of course, the rest of the witnesses that we'll be hearing from will be on behalf of the defense. In the little bit of time that I was listening in yesterday, it seemed that sort of one of the main focuses of their arguments yesterday circled around this totality of the situation. Of course, there's the question of, was this shooting justified? Did Christopher Schurr have a reason to fear for his life or great danger or bodily harm? And while the prosecution, of course, is saying, no, this shooting was not justified, the defense bringing on witnesses, now speaking specifically to Grand Rapids policy. And that was something that I heard repeated from several of the witnesses yesterday. There's not necessarily, as they said, a black and white answer as to when it is okay to pull out your weapon to shoot someone and cause fatal injuries. But in this case, many of the witnesses for the defense, again, saying it's really about the totality of the situation. There's not necessarily one right or wrong answer.
And the totality stemming from that use of force issue that we've been hearing about for the 5 days of the trial. Not only that, the use of the taser, another situation that keeps getting brought up again and again, day after day. And you were talking about the black and white situation of, it's not necessarily one side or the other in terms of how they go about this sort of decision making. It is in kind of a gray area. And I want to say it was that GRPD Captain Chad McCursey that brought up specifically in his testimony, quoting that, saying that this is an entire gray area. So interesting testimony as we start to get into the actual GRPD policies and procedures that were in place at the time that this all took place.
Because of course that was a big question with many of the witnesses coming in for the prosecution. The defense anyway bringing up, taking issue with the fact that these experts per se were speaking more so to general policing practices, not specifically those here in Grand Rapids.
And I think one thing that also stuck out, especially to attorney experts we've been speaking this whole entire trial, is the fact that technically, as prosecutor of Kent County, Chris Becker should know these policies. So they said it was very interesting to see him cross-examine people that he has actually probably worked with these policies and knows these policies. And they're not saying that he doesn't know these policies, right? Like he probably does, and he's asking questions. He already knows the answers too. But it was an interesting display that maybe some of the jurors don't even know that he already knows these policies.
I thought about that same thing.
Yeah.
The prosecutor perhaps being in a really difficult situation. I'm sure Chris Becker and the Grand Rapids Police Department often work very closely together. So with many of the witnesses, many of them in uniform, I would imagine it's a tough dynamic for all sides.
Yeah.
I want to point out, we did hear from 6 people. That sixth person, I guess I should say, we've heard from before, of course, that being Robert McFarland, the forensic video analyst that was there in one of the first days of the defense calling witnesses. We had him back on the stand yesterday, and again, with all of those experts from GRPD, we're talking 2 GRPD captains and GRPD firearms trainer Jason Gady as well. We also heard from a biomedical scientist and a taser expert, Mark William Kroll, on the stand, all of which some, of course, going against some of the testimony we heard earlier in the week from the prosecution's witnesses as well.
And I think those people were interesting because it almost kind of seemed like the defense was harping on the fact that prosecution didn't have anyone from Grand Rapids, and then you see them bring in people from Grand Rapids and then kind of switch it back to not having someone from Grand Rapids. Not to say that their testimonies didn't help or hurt either way, but I just thought it was interesting that they were like, oh, they're not from Grand Rapids, but then they bring witnesses that are not from our area.
Well, and of course, when the prosecution was calling those witnesses, we heard the defense object multiple times to those experts, the two experts specifically at the tail end of the prosecution's case. And then, of course, on the defense side, we heard just probably as equally the amount of objections on the prosecution side as the defense was making their case with their witnesses over the last couple of days. Of course, a couple objections coming out yesterday during trial as well.
Yeah, we also heard some juror questions during questioning yesterday. And, you know, hopefully I got all this right, because we've heard this from some of our viewers as well. I believe we saw an email with people, you know, showing concern about the fact that it's hard to hear everything that's happening. And we should maybe point out that not all of that is in our control. Now, we've already talked about there are strict orders in place with how we're able to show you the trial. And for us too, we're not able to clearly hear everything, at least as we're listening in. We've got ears all over the courthouse, but we did hear some complaints about that. There was one moment where I believe the judge was mentioning a question from a juror that she said she was not going to include because she didn't feel it was relevant, where I believe a juror was asking, would it be GRPS policy or a different policy that we will have to be basing whether or not this was the correct decision? If I heard correctly, the judge was saying that she didn't feel that question was necessary to be presented in the court because, as we've been mentioning, it'll be up to her rules and her instructions that they'll need to go off of the policy to make their decision.
Well, it's also based on the jury itself. You know, they're the ones that have to decide. So I think one thing that was interesting that Andrew Rodenhouse, who we spoke to yesterday, said, you know, it kind of shows the confusion that some of these jurors may have when you're throwing so much at them. They're sometimes, some of them are asking questions that they have to answer themselves. And so because they're already asking these questions, it may show it's a little confusing.
I want to point out that at 8:37, we do see the judge in her seat. Of course, we're looking at an off-camera feed of things in real time in the courtroom. You will be seeing that feed in about 30 minutes. So at about 9:07, you'll see what we're seeing. And at this point, it looks like they are kind of doing some back and forth between the judge. It looks like the defense side might have maybe a question, or maybe there's some I really can't tell what's going on, but as soon as we get that, we'll have that for you. I know we have Riley Mack in the courtroom on a live blog that you can look at right now as we're speaking. She's updating that on 13onyourside.com. And so again, here in a few minutes, I'm going to pull up our live blog to see if she's posted anything so we could learn more about what's going on inside the courtroom. Again, it does kind of look like, I wouldn't say a heated exchange, but there is some sort of exchange happening right at the tail end of court here this morning.
Definitely showing the life of this case. You know, these two sides, we've talked to these attorneys that have said these are two very talented groups of attorneys that are presenting cases, and you can see how educated they are in their fields because they're really bringing the heat.
But another interesting point with Tanya, one of the experts that we've been chatting with throughout this case, she pointed out that this really isn't a complex case in its nature when you think about the fact that many of those initial questions when you think about this type of criminal trial have already been answered in terms of who caused Patrick Lyoya's death, how his death was caused. There's really just that one underlying question in terms of, was the shooting justified? So I thought that was an interesting point in terms of how quickly some may have perceived the prosecution's case to have been presented and what we see with the remaining trial.
Of course, the defense here for Christopher Schurr, they need to prove that it was justified. On the other side here, the prosecutor, Chris Becker, of course, brought those charges because, of course, he believed that there was some legal standing there to say that that shooting was not justified in the moment. A little more live reporting, too, this morning. Of course, we were chatting with our photographer, Doug Grevious. He's our chief photographer here at WZZM. He was outside the courtroom this morning, and before court got started, there seemed to be two groups of protesters out there in front of the courthouse. We know that there was about a dozen supporters of Christopher Schurr supporters outside of the courthouse before day 5, holding posters and Blue Lives Matter flags. We also know that there was a handful of Justice for Patrick Lyoya demonstrators outside as well. So we do know that on this Friday, as we start day 5, protesters and demonstrators are still engaged with the case and protesting on either side.
That is interesting because we mentioned yesterday seeing some of that interest not as high. You know, we remember the first day they were certainly out there. Now here we are ending out the week on Friday. And again, we were hearing that they were out there as well. To be clear, we know they've been out there every single day.
Absolutely.
What's been the difference is just how early they're showing up. Of course, we are on in the mornings, and we are there outside the courthouse sometimes as early as I think 4:30 in the morning. The point that I'm trying to make is on the first day of the trial, and now here as we end out the week, that's when we're seeing that heavy interest early on in the morning. We know that we've seen support on both sides outside of the courthouse every day of this trial.
And I wonder if maybe there's some anticipation from these demonstrators and protesters. You know, we're on day 5. We heard from a lot of people. Are people starting to get antsy and wondering, is today the day that Schurr takes a stand?
Right.
And if it is the day, should we be out there either, you know, supporting him or voicing our concerns about the case? So maybe there's something happening out, some anticipation among people.
In a little less than 30 minutes, you're going to see play out in real time the judge calling the court into session. And right off the top here, as Riley Mack is reporting, the defense is arguing for the admission of video evidence showing Schurr's exhaustion that day, going back to a lot of the arguments that we saw yesterday made from many witnesses that were giving testimony. And the prosecution argues the defense has already proved his exhaustion. The defense says this is different evidence than anything the jury has seen before. The judge says she'll look at the evidence before making a decision. So again, there was kind of, again, we're trying to characterize something that we really can't hear of right now, and you'll be able to hear that again in less than 30 minutes. But we're trying to characterize something that looked to be some sort of back and forth battle between both sides, and now we know it's about some evidence that the defense team wanted to admit into evidence there.
Well, I gotta say, I'm glad to see court underway.
Yeah.
There were a few days this week that we saw
We're like
some
9:07
delays.
and we're like,
yes,
all right,
there were
everybody.
some days this week we weren't able to start showing viewers this trial until around 9:30 in the morning. But these last couple of days, they've been starting closer to that 8:30 mark. So in accordance with that 30-minute delay that all media is having to abide by and showing this trial, it looks like we'll be able to bring that to you a little after 9 this morning.
And I'm getting word that we do have some of our experts joining us again. We're going to welcome them in. I believe, yes, it's Tanya and Andrew. Tanya and Andrew, thank you so much for joining us this morning.
Good morning.
We wanted to start off by just getting your opinion. Andrew, you're almost kind of like a psychic for us. Every time you say something that might happen, it ends up happening. Yesterday, you had mentioned that you were curious to see if they would bring in any outside people for the defense in terms of witnesses, and they did. What's your reaction to what you saw after we spoke?
Well, I'm not a psychic. I've just done it so many times. I know like what I would do, and I know that these guys are really good. So I would expect I expect certain things from him. So I'm not psychic. I just know I've been doing it long enough. My reaction is after yesterday's experts testified, I was kind of my thought was, wow, I think they're really setting this up so that Chris Schurr does not have to testify. They got in a lot of stuff that you would expect a defendant to get into through the experts, talking about the electrical circuits, like in talking about muscles, right? So, and talking about exhaustion and showing how exhausted he is to the point where he can hardly stand there. He's got his firearm in like a low guard position, and his arm is just hanging down, and he can hardly focus on anything, and the other officers are basically tapping him out of the fight. And I think that's why they're having such a big fight this morning. Based on what I've learned from you listening to your reporting, is it sounds like the defense wants to introduce even more video evidence showing his exhaustion, probably more body cam footage from the officers than when they first arrived on scene. And so I'm not sure why the prosecution is trying to say it's cumulative. Are they just going to concede then that he was exhausted? I mean, because if that's the case, then that's two big factors that go in his favor towards justification. And I want to just clarify something on the justification. The burden always stays with the prosecution. Mr. Schurr does not have to prove that he was justified. It's the prosecution that has to prove beyond a reasonable doubt that he was not justified. And that's where in self-defense cases, it's really,
And
It's
Andrew,
really,
I'm sorry, I do want to cut you off to let our viewers know that we have just learned that Schurr has actually just taken the stand. Obviously,
oh my
we
God.
cannot see this because we're on a 30-minute delay, but we are looking at our feed. He is on the stand. Andrew, you just said that you thought the defense was creating a plan to not have him take the stand, and now he is. What's your
See, I'm
reaction?
not psychic. See, I'm not psychic.
Right.
I just proved it.
Talk about what's your reaction, though, to seeing them actually have him take the stand.
I'm looking forward to listening to it. I guess we're all going to have to wait the 30-minute delay. I'm interested to hear what my good professor has to say about the two witnesses yesterday.
Yeah, Tanya, I do want to ask you about those witnesses, but first, your initial reaction to hearing that Christopher Schurr has taken the stand.
Well, as we've been saying all along, in criminal cases, it's very common to advise clients that it's probably not in their best interest to take the stand. But in self-defense cases, there's almost this sense or feeling that it's necessary for the jury to hear what the defendant was thinking at the time they acted, because that's the best evidence, right, for the defendant to tell us what they were actually thinking at the time and why they thought it was necessary to act in self-defense. So I'm not overly surprised that in this particular case, the defendant has decided to take the stand. There's always a danger when a defendant in any case takes the stand because they're going to be cross-examined by a skilled attorney. And as we've seen, Mr. Becker is quite an intense cross-examiner. So that's going to be a very interesting dynamic in this particular case. But at the end of the day, in a self-defense case, it's quite common for the defendant to take the stand.
Well, I'm curious, obviously, as we said, we can't predict what will happen, but you mentioned that there could be benefits and risks. I'm wondering if you could speak to what are the defense hoping will come out of his testimony, and then what are some of the things that could be risky in that cross-examination?
Yeah, well, as I said, I think the benefit here is that the jury is going to hear from Mr. Schurr's own mouth what he was thinking each step of the way, to the extent that he can do that. Remember, we've heard a lot of testimony about what happens physiologically when someone is under this type of stressful situation. So that goes back to what some of the other experts testified. But I do think that's the benefit. The jury is going to hear from him. They're going to hear what he was thinking to the extent that he can remember and is able to, why he did what he did. The risks are that the jury doesn't believe him. The risks could be that there's other character evidence that might come out that would not have otherwise come out if he had not taken the stand. And as I said, we've already seen in this trial, Mr. Becker is an intense prosecutor and his cross-examinations have been very intense. And so the risk is that for any witness, particularly a defendant, that you can't withstand that type of cross-examination, that it kind of manipulates the witness a little bit.
Getting Schurr on the stand here, of course, this is obviously a monumental move in the trial since it started 5 days ago. I'm curious from the jury's point of view, what does hearing directly from him do for the jury? And what do you think the defense team is kind of thinking about putting him on the stand for the jury to hear?
Well, I think it personalizes him. And so until now, the jury just sees him on the other side of the courtroom, surrounded by lawyers and legal team, and they so far he hasn't been humanized. They've seen a lot of video of him in an isolated context. They don't know anything about him. They don't know what are his hobbies or anything. And so just to have him on the stand as a human, and then if he gets emotional about it, that's how you get a connection to a jury, is you present something emotionally that they can reach out and touch and feel, and you can bring them to the scene through your words. And so it's now no longer just on camera, it's now the jury's experiencing it with you. And I'd expect they're going to walk him through the entire fight and what were you thinking, and now the jury can actually hear and have that emotional connection. The biggest risk is, you got to remember one big thing. Unlike a normal layperson, somebody who has to use lawful deadly force and then defend themselves in court, they're not required to make any statement to the police. And so they can take the stand and testify and not have any prior statements used against them. But Mr. Schurr, being a law enforcement officer, is required to make what's known as a Garrity statement. And so his Garrity statement can now, if he testifies differently to what he initially said, can be used to impeach him. Plus, his entire police record can now be scrutinized. And if he's got anything in his file or any complaints about him, any excessive force complaints, all that stuff is now going to be at least what I would consider fair game. And so, and the prosecutor has all that information. And so, and like the professor said, Mr. Becker is an intense cross-examiner, and if he's not prepared for that, he could potentially wither right in front of the jury. And I've seen it happen where a defendant does decide to take the stand and then under cross-examination just folds like a cheap suit.
Wow. Well, we've been talking this morning about just sort of the intense dynamic with the fact that we know Chris Becker likely works pretty closely with the Grand Rapids Police Department, is now part of some intense cross-examinations of GRPD officers in uniform. But we, of course, know that these departments work independently as well. I'm interested in having both of you perhaps speak to the dynamic of this in the courtroom.
Andrew, we'll start with you.
I'm sorry, so I missed the tail end of that question.
Yeah, could you just speak to the dynamic of Chris Becker having to go through some pretty intense cross-examination of GRPD members when I'm sure their departments work pretty closely together, albeit independently?
Yeah, and you know, I mean, you got to understand, Mr. Becker is only, he's the head, okay? And Kent County is a fairly large county, and so he's got a lot of assistant prosecutors that work underneath him, and those prosecutors have to deal with these law enforcement agencies. Specifically, the Grand Rapids Police Department is the largest law enforcement agency in the county. I don't know how they compare to the sheriff's department, but in any event, they've got to work with these people also, and so it has to create some type of friction between them. And so I think that maybe internally there might be some struggle coming down the road that may manifest itself in ways that the public might not see.
And Tanya, we'd love to hear your opinion on this as well.
Well, I agree with Andy. I mean, it's pretty clear that there is tension between Mr. Becker and at least the officers that testified when they were called by the defense. I mean, it's pretty clear that there was tension there. Going forward, it will be interesting to see if Mr. Becker and his assistant prosecutors, as well as the Grand Rapids Police Department, will be professional and put this aside. But one of the things that's interesting to me as this dynamic has played out before our eyes is there seems to have been not a lot of communication between the prosecutor's office preparing, I shouldn't say preparing, but approaching the beginning of this trial. And Mr. Becker seemed a little bit surprised by what some of these officers were saying. And one, of course, I think it was Officer Gady, who did not speak with the state trooper investigating this case. So there's some really interesting tension that led up to the trial, and then we saw it play out in the courtroom. So that is something they're going to have to overcome going forward for the benefit of the people who live in Kent County.
On day one, we spoke to you, Andrew, I guess, or maybe it was day two, when we were talking about laying the groundwork and kind of telling the slow burn tale of the entire case and the events of how it played out. Right now, as Christopher Schurr is on the stand, we know from our live reporter in the courtroom that he's being asked things about his history here at Grand Rapids. He's being asked about his education. He's being asked about his marriage and asked about how he grew up. Even. These are all questions that the defense team is asking, even drawing an objection from Chris Becker early on, asking the relevance of all of this. All of that to say is that still kind of that slow burn storytelling we're doing in the courtroom right now, or is this just some sort of strategy to humanize him, or is it all of the above?
It's all of the above. And so one of the things you're allowed to do with a witness is to provide their relevant background because it establishes somebody's credibility. And so it's odd that it would draw an objection because it kind of ends up highlighting what the person's testimony is. And so, like, if the jurors weren't paying attention before, they're paying attention now. And so they're allowed to develop him as a person, and so that the jury can be fully informed into how credible he is as a witness. And so the jury's going to be instructed on witness credibility. They're going to be told, you can believe all of their testimony, you can believe some of their testimony, or you can believe none of their testimony. I've had cases where I've talked to jurors afterwards, and they've talked about the testimony of an alleged victim, where they said, we didn't believe a single thing that came out of that person's mouth. And it was simply because the jury, taking everything into consideration, said that we just didn't believe her. And it was a matter of like how she was acting on the witness stand. It made it so that she wasn't believable. But in Mr. Schurr's case, I mean, this whole thing is about how did he feel that day? What was he considering? I mean, if they're talking about, I would presume they're going to talk about his family and how he was thinking about, I need to make it home to my wife and kids. I'd be surprised if he doesn't say something along those lines.
Well, Tanya, I want to ask because, you know, it seems like now the crux of this trial is how Schurr was feeling in that moment. I just wonder if he does, we don't know what he'll say, but if he does say, I was fearing for my life, I was thinking about my family, I did what I felt like I had to do, does that just kind of like throw away everything that we've already seen in this case? Or how does his testimony play into everything that we've already seen?
Well, I want to kind of loop back to the storytelling aspect of putting a trial together. And I think the defense has been very methodical in how each witness was a building block, right? We started from the defense side with the officers who responded and what they observed Mr. Schurr's physical state was, right? So laying that foundation that he was exhausted. And then we start bringing in the experts. We see the experts brought in from the Grand Rapids Police Department about the training and the taser and the use of force. And then the last two experts that we saw yesterday talking specifically, right, about exhaustion, exertion, and then the biophysical aspect of tasers. All of this leading up was a way to support the credibility of what I anticipate Mr. Schurr is going to testify to, how he felt exhausted, how the exertion of that 2 minutes and 28 seconds confrontation, right, how that affected him and what he was thinking. And as Andy said, in a self-defense case, when the defendant does take the stand, what he's thinking at each step of the way is very important. And in self-defense cases that I've tried, that's how I structured the direct examination. Okay, at this point, what were you thinking? And Andy's point about usually what people say is, I thought I was going to die and I was thinking about my family. That's a very common response, at least in my experience. So I anticipate that we're going to hear that type of testimony as we listen to Mr. Schurr today.
Well, again, this question is for the both of you, starting with you, Andrew, because this kind of stems back to you mentioning the one witness you had before where you heard jurors saying that they just didn't believe her, and maybe even because of her demeanor on the stand. I'm wondering from you both, starting with you, Andrew, do you feel that it gives Christopher Schurr somewhat of a benefit testifying in that he's in law enforcement and familiar with the court system and how it works, presumably?
Well, and I don't know how often Mr. Schurr has actually testified in court, and so I wasn't aware of him being a police officer until this case arose. And I know a lot of police officers. I've just had to deal with them over the years, and so I don't know what experience he has testifying. I would imagine that his team has him prepped very well. Herein lies the problem in preparation, is that if you come across as too prepared and that you're just taking it from a script, then you lose that emotional connection to the jury. And they will look at you and say, oh, you're just saying it because you've been told you have to say these things. And so it's part of the preparation process where you don't want to over prepare the witness, but you want to have them prepared enough at least to answer questions on cross-examination.
And Tanya, your thoughts on that?
Yeah, I agree with Andy. I think that even though, let's assume that he has testified in court before, let's assume that he took a course at the academy on how to testify in court. There's a big difference testifying in your professional capacity in a case, talking about your professional duties, and when you're testifying, when your liberty is at stake, when you're the one who's been accused. So there's a big difference there. So I don't know that any preparation that he's had to testify as a police officer is necessarily going to give him an advantage in this personal accusation against him. What I think the jurors will be looking for as they watch him testify is does he come across as sincere? As Andy said, does he seem overly prepared and glossy, or is he being real and raw as he testifies on the stand? And does he show the appropriate emotion when he's talking about these circumstances? But again, going back to how the defense did the building block of their case, by presenting their expert testimony the way they did and in the order they did, they've taken away to a certain degree the prosecutor's ability to say that Schurr is just saying what he needs to say to be able to successfully argue self-defense. There is a basis established in the record now that supports what we anticipate Mr. Schurr is going to testify to.
I want to ask you guys about the Taser video that we've seen in previous days of testimony. I believe there was a video that came out with Christopher Schurr in a Taser training during his time training with GRPD. They're going through that video with him one by one, and I don't know this for sure, but I would assume that they'll probably go through other videos and evidence this morning. What does going through a video like that with the actual defendant himself do in the court?
Again, this is about getting that connection to the jury. I found it interesting. The juries in the jury selection, normally jurors, like a sitting juror, it's very common to have it be roughly 60-40 males to females. And this jury had 10 females. And so I found that interesting. I didn't know if that was part of someone's strategy or just how it worked out. But now looking back with the fact that Mr. Schurr is actually going to testify, in my experience, it's easier to get that emotional connection to a female juror than it is to a male juror. Male jurors will typically, in my opinion, and I'm basing that on all the, I don't know how many trials I've had in my career, a lot. And I typically see that male jurors, if the issue is emotional that needs to be decided, they don't decide it emotionally, they use reason. Where female jurors typically will attach to the emotion much quicker and easier. And so that was part of the defense strategy all along.
And Tanya, your thoughts?
I think Andy is right from the perspective of how lawyers may try to decide who they want to be on the jury. But with the jury that we have seated, I think it's effective to have the defendant talk about his training so that it's clear what he took away from that training and how it all fits into everything that has been testified to so far. So it makes a lot of sense that they're doing that.
Well, Tanya and Andrew, we're going to be able to actually hear Schurr in a few short minutes, but we wanted to thank you for coming on and giving us your initial reaction to hearing that Schurr has now taken the stand.
All right, we'll see you at the
Thanks.
noontime, I think.
Yes, thank you so much. So again, a very big moment in this case. There was a
Yeah.
lot of questions of whether or not Schurr was going to take the stand, and we're watching the feed. And just so viewers can know, you will see this soon. But looking right now, I can say he looks very calm. It doesn't look like he's showing, I don't want to say no emotion, but he's not overly emotional. It's almost like that neutral stance.
Yeah, it almost looks like he's anticipating the next question. Every time that he gets a new question, it looks like his face is just kind of looking at whatever attorney he is paying attention to and just kind of bracing for what the next question might be for him.
Yeah, it is interesting to see just his appearance, though. You can kind of tell his hair has been sort of combed in a way to make it look, maybe more presentable. I'm not sure exactly what he was going for, but I say that because it's hard to not mention the drastic change in his image from the pictures that we're showing you before this incident, even the videos that you're seeing him in this training. So again, his appearance did just somewhat stand out to me a bit, seeing him on the stand. You definitely see there's some effort there to make him look presentable and awake and fresh and ready to take on these questions.
I was gonna say he almost does look refreshed. I feel like when this trial first started, he looked very tired, you know, very focused, and I don't want to say he looks like a normal person because he is a normal person, but there's a clear difference.
Yes.
Yeah, absolutely. I do think that you're absolutely right in all of those things. And again, as he's taking questions, we are now just watching this back. He's been on the stand for about 15 minutes as it happens. You'll see that at home, probably in about maybe 15 minutes-ish?
Yeah, at this point,
yeah, maybe less. I gotta say, I was not expecting that to be the first thing we saw as court opened today, and it also has me wondering, well, just how much longer do we have to go?
Yeah.
How long will he be on the stand?
Well, and that's the question, right? Is we thought that there were going to be 40 witnesses on the defense side. When we first started this, that's what we were told. With Christopher Schurr, it begs the question, and maybe folks at home are wondering this as well, how many more people do they have to call after we've heard from the guy that this is all about?
Yeah, and I'm curious to see. It almost looks like now we're watching this. It almost looks like he's demonstrating something. Again, we don't know what that is just yet. We'll be able to show you soon, but clearly now he's demonstrating. So you can tell by these questions just from looking at it. It looks like the defense is going to use those building block steps that they use with the other witnesses to really build the case, to almost put the juror in the situation to kind of see for themselves the thought process that he had as this was happening.
I think it will be interesting to hear Schurr's testimony from the events of that day, as we're now hearing again about it for the first time from his mouth publicly, the events of that day and just exactly how he recounts that. Because again, he is one of two people involved in this entire situation. One and two people, I should clarify, in the physical altercation that took place.
Yeah.
But going back to what we were just hearing from our experts that we've been speaking to in this case, Tanya and Andrew, you know, they talked about, of course, what we already know. This could be really great for him, or he could be taking a really big risk that goes against him that we won't necessarily know until that cross-examination comes. And I expect we've got some time before they're turning Christopher Schurr over to the prosecution.
I was going to say, I would imagine that both sides have a lot of questions, especially the prosecution side once they get their cross in there. It'll be interesting to hear the questions that Chris Becker has for him, especially as he's obviously the one prosecuting the case, but also getting the defendant up there and having that one-on-one with him. I'm sure that there will be a lot of questions up there.
And talk about the anticipation of him taking the stand, not just from the trial aspect of this starting this week. It's been 3 years. You know, we've heard from family members and friends of Patrick Lyoya of how this has impacted them. We have not heard a lot from Schurr's side in terms of any family or himself speaking. And obviously that was probably because he was charged and they wanted to, you know, let the legal process play out. But I still think it's I think a lot of anticipation has built up to this moment because, again, we haven't heard from him at all since this has happened.
Yeah.
It was interesting to hear Andrew bring up that statement that police officers do have to give. So there is some sort of statement from Christopher Schurr on the events of that day. But again, in terms of what we've seen, or the court of public opinion, as I'm sure Andrew would call it if he were still on with us, you know, we have not heard him talk about that yet.
Yeah.
And going back to what you were saying about this being 3 years ago, how does that play into the testimony that we're hearing from these firsthand accounts from people who were there on that day, whether it was there at the time of the incident or they spent time with, you know, Patrick Lyoya or Christopher Schurr shortly before? You know, we heard that from some of the witnesses who were interacting with Patrick Lyoya that day. They were testifying on day one, but that has come up. Hey, this was 3 years ago. I don't exactly remember those fine details, and I wonder how much that will impact Christopher Schurr's testimony as well.
Just to give a little bit of painting a picture here of what's going on in court, and you will see this play out in real time here in about 5 minutes. But again, Schurr's testimony right now is largely focused around the Taser. Again, we've seen this as a central argument day in and day out since Monday. Schurr's testifying just how bad the taser hurts, using words like terrible and excruciating. Schurr's testifying that getting tased lasted about 5 seconds, during which he was quote unquote completely incapacitated. This really he's speaking about, as far as I can tell right now, about the training. So when you're being trained and you have to be tased. So
yeah, that brings me to, I remember one of the witnesses on the stand, I believe it was McCursey, who is a GRPD police captain. He is a master taser instructor, and I remember on the stand, I wrote this down just because it stuck out so much, at least for that drive stun, which we've been talking about here throughout the trial, because of course you've got the taser itself, which can activate those prongs, and then when those prongs are no longer available, they've got that drive stun that they've referenced where you can still use the taser even if those prongs aren't available. Well, that Chad McCursky on the stand yesterday compared the feeling of that drive stun to a blowtorch in terms of the amount of pain. That definitely stood out to me yesterday in yesterday's testimony.
And that's going to be really interesting to see how that compares to what we've already heard. We've heard from experts that have said this is what it feels like. You know, we've heard from some saying, oh, it doesn't incapacitate you for a long time. Others saying it does. So it's interesting to hear what he could possibly be saying, you know, in comparison to what we've heard. I'm really interested to hear about the exhaustion part. You know, that's something that the defense really honed in on yesterday. Will he, you know, I'm assuming he will say, yes, I was very tired, or, you know, whatever. But I mean, it's interesting to see everything that he says doesn't fall in line completely with what's already been said.
I want to make sure that our viewers understand what's about to happen here in about 2 minutes. We are going to be doing an on-air cut-in, so you on the live stream will see us probably open that cut-in on the air on WZZM as Christopher Schurr begins to testify.
Yeah.
Yeah, I think so much of this, we've just got a few seconds left before we turn it over to that, but so much of this case weighing on things that cannot be proven. His state of mind at the time, how afraid he was, just how exhausted he was. And so I'm really curious to see how the jury will be able to come up with a decision on things we really can't know.
Yeah, and interesting to see how the defense has prepped him. Now, we do want to go to this breaking news. Good morning, everyone. We are following breaking news at the Kent County Courthouse where the trial of Christopher Schurr is underway. Christopher Schurr has taken the stand in his own trial. Schurr is accused of killing Patrick Lyoya in April of 2022 during a traffic stop. It escalated into a foot chase, followed by a struggle with a taser. Officer Schurr eventually shot Lyoya in the back of the head. Schurr is charged with second-degree murder, punishable by up to life in prison. Now, earlier in the trial, Kent County Prosecutor Chris Becker talked with an expert witness about Schurr's response, calling into question whether he followed proper procedure and whether Lyoya's actions were truly a threat to his life. After the prosecution rested its case, the defense called multiple police officers as witnesses, those who responded to the scene the day of the shooting, and others who discussed police procedures along with training. The other experts who spoke to Schurr's exhaustion levels, let's take a listen in.
Your Honor, that's what we call Christopher Schurr.
And sir, before you take your seat, if you could raise your right hand, my clerk will swear you in.
Okay.
Do you solemnly swear that the testimony you're about to give in this matter
Thank you, Your Honor. Good morning, sir.
Morning.
Will you please state your name and spell your last name for the record?
Christopher Schurr, Schurr.
Let me just start out. Do you enjoy speaking in public?
Not particularly, no.
And throughout your life, is that something you don't particularly care for?
I'd say public speaking wasn't one of my strengths, no.
Now, you understand you have a right not to testify.
I do.
Why are you testifying?
I feel like it's important to get my side of the story out.
Now, we're going to go into several topics, obviously related to this case here, but just backing up a little bit in regards to your background and education. How old are you?
Currently 34,
How old were you in April of 2022?
31,
Where were you born?
Grand Rapids,
And where were you raised?
southeast side of Grand Rapids.
Do your parents reside in West Michigan here?
They do.
Are they in court here today?
Yeah.
Do you have any siblings?
Yes.
Are they also present in court?
Yes.
Are you married?
Yes.
How long have you been married?
10 years.
And where did you meet your wife?
High school.
So-
Bucket Center. Yep.
Have you been together since high school?
Yes.
So essentially high school sweethearts?
Yes.
Now, where were you and your wife married?
We were married in Kenya.
And what brought you to Kenya?
We were there on a mission trip
Guess
a
I
couple
got to
years.
object. We're getting a little bit far afield, Your Honor, in terms of who cares whether they're married.
I think it goes to some of his experiences in life, Your Honor. I think it's relevant.
I'll sustain the objection because I do believe that particular question is just going a little bit deeper than relevant.
Now, does your wife work?
Yes.
What field does she work in?
Mental health.
And you yourself, did you go into public service as a police officer?
I did.
Fair to say both you and your wife went into fields to help others.
Yes.
Did you attend high school here in West Michigan?
Yes.
And did you graduate high school?
I did.
After high school, what did you do?
I went to college at Siena Heights University.
Did you graduate college?
I did.
What year would that have been, approximately?
2014.
What was your major or focused area of study in college?
I majored in business with a focus in accounting and a minor in criminal justice.
Did you receive any scholarships in college?
Originally, I had an athletic scholarship and later gotten both athletic and academic scholarships.
Pretty good grades?
Yes,
What was your GPA you graduated with?
a 3.8.
Okay. Now, as far as athletics go, what sport did you participate in college?
Track and field.
And were you a short distance or a long distance?
I was a sprinter.
Okay. After college, what did you do?
After college, I gotten a job in the private sector as an entry-level accountant.
And at some point, did you go back to school for continued career education?
Yes.
What did you do next?
I went to Lansing Community College for their police academy.
And why did you join the police academy?
I just wanted to do a job that was more fulfilling.
And what were your feelings on police work? Why police work?
It was a fulfilling job.
Sure is testifying. I can't. Well, where's Michaela?
Voices, I don't know where that's coming from.
Sounded like you, yeah.
No, it was your person, Sarah Lynch.
Very sorry.
Go ahead. Mr. Fudge.
Thank you. Why did you pick police work?
It's never the same thing every day. To me, it was more fulfilling than working in an office, and got to help people.
Now, what year approximately was that you attended the police academy?
2015.
And you mentioned LCC, Lansing Community College.
Yes.
Is that academy what's called an MCOLS accredited academy?
It is.
MCOL's Michigan Commission of Law Enforcement Standards. Is that your understanding?
Yes.
And I'm sure we could spend hours talking about the MCOL's Academy and the different topics, but just in general, what did your MCOL's Academy prepare you for?
I would say it gives you a foundation to continue training as a police officer.
And is your understanding that the basic standards trained at LCC is consistent with all other MCOL's accredited academies across the state?
That's my understanding.
How long was the academy at LCC?
Approximately 4 months.
Full time?
Yes.
And what's full time?
It's 40 plus hours a week.
Are there a variety of topics covered?
Yes.
Approximately how many?
There's probably over 100 different topics.
And you give just a sampling of some of the basic topics covered at the LCC Academy.
I'd say the main ones are criminal law, investigations, use of force, first aid.
Now, use of force, that's a topic that's discussed going all the way back to your initial MCOL's Academy.
Correct.
And does MCOL's train you that you need to use force at times upon subjects?
Yes.
And do they give you instructions on how and perhaps when to use certain levels of command or force?
Yes.
At MCOL's, do they discuss some of the realities that police may encounter out in the field?
Yes.
Is that always predictable?
No.
Can you explain?
I'd say most of what we do out in the field is not predictable. It's a dynamic environment, and we train in a controlled setting.
Now, at the MCOL's Academy, is there always a perfect way or a best way to handle every situation or scenario?
I'd say we strive for perfection. Probably never achieved.
Does MCOL's, going all the way back, do they talk about certain circumstances that may be beyond an officer's control that might affect their performance in real life encounters?
Yes.
They talk about factors, and I'm sure there's a plethora of them, but reaction times, is that something that's discussed all the way back at MCOL's?
Yes.
What do they teach you about reaction times?
Essentially, action beats reaction.
And how do they, what's some examples of how they teach that?
One of the main ways is a 7-yard or a 21-foot rule, essentially, that someone could cover that distance and harm you before you could react.
And do they go through drills and videos and things like that as well to demonstrate this?
Yes.
So even back to MCOL's Academy, are you shown that there can be factors that put a police officer at a disadvantage?
Yes.
But even with knowledge of potential limitations, do you still need to respond to calls?
Yes.
You still need to enforce laws?
Yes.
Are the situations that police encounter, is it always safe?
Typically not.
But are you still required to march into a lot of volatile situations?
Yes.
What if you don't perform your essential functions, even going all the way back to the MCOL's Academy? What are you told if you don't perform your essential functions? What can be some of the consequences of that?
Either I or others could be injured, if not other consequences at your department, such as cowardice.
Okay. Now, going back to the MCOL's Academy, do they use scenarios and simulations?
Yes.
Is this meant, what is your understanding of why they do these scenarios and simulations?
It's just to get us used to problem solving and learning whatever they're trying to teach us at the time.
Are these run out in the real life field, or are they in a rather controlled setting?
Controlled setting.
Now, at the conclusion of the MCOL's Academy, are you given a rather lengthy and thorough examination to ascertain your knowledge on these topics?
Yes.
And are you ultimately given an examination?
Yes.
I'm sorry, are you ultimately required to attain a certain score?
Yes.
And did you pass the MCOL's Academy?
I did.
Now, after the LCC Academy, are you a fully licensed police officer?
You are not. You need to complete training at a department.
While you were in LCC, did you start to apply for jobs?
I did.
And was one of those departments GRPD?
Yes.
And was that a rather sought-after job back then?
I'd say so.
Why
yes.
is that?
The opportunities, the different departments, if you will, that you can get into.
Now, were you ultimately hired?
Yes.
What happens after you're hired into GRPD?
You go into an 8-week in-house training where you do more scenarios.
Okay. I know throughout the course of the trial, we've seen the video montage.
Yes.
What year was that video montage from?
2015.
And is that you at the 8-week GRPD Academy?
It is.
And is that full-time, the
Yes.
8-week? What's full-time for that academy?
I would say that was just 40 hours a week.
Okay. Now, are the topics covered at GRPD, are those identical to MCOLS, or how do you compare?
I would say they're more specific to Grand Rapids. Essentially, they're putting us in different scenarios and having to solve problems the way Grand Rapids wants us to solve them.
Okay. Covered some of the same topics as far as traffic stops, first aid, is that fair to say?
It's fair to say.
Now, do you cover firearms training?
Yes.
Are a lot of the concepts in firearms training similar from GRPD to MCOLS as far as the basic concepts?
The basics, yes. I think Grand Rapids probably more advanced than what the academy was.
What level of force is firearm deployment upon a human?
Deadly force.
And in GRPD, do they take you through scenarios and situations that police might encounter as is exhibited on the video there?
They do.
The same scenarios as LCC, or do they go through quite a few more?
Definitely a lot more. LCC, you're more or less laying the groundwork and probably more book work and not as many scenarios. I felt as though Grand Rapids, we did more scenarios.
How many, roughly?
Probably thousands.
We saw just a sampling on the video of some of those scenarios.
Yes.
Now, as you're instructed on those scenarios, are you trained that there's only one way to effectively perform a task?
No.
Basically, what are they showing you there?
Essentially, there's a parameter, if you will, to handle it. There's definitely preferred ways, but there's definitely no person is the same. So the way I handle something is going to be different than what someone else handles something.
Now, does the GRPD Academy, similar to MCOLS, do they try to expose you to some of the limitations that an officer may expose out in real life?
Yes.
Do they discuss topics like human reaction time?
Yes.
Now, does GRPD, do they train you on weapons, other weapons as well?
Yes.
What weapons were you trained on with GRPD?
The Taser.
Any others?
Their issued firearm and pepper spray, baton.
Okay. Now, going to the Taser. You need a drink of water? Go ahead. All right. Who instructs the Taser training?
Master Taser instructor.
And we've sat through several experts on tasers, okay? So I'm not going to ask you about all of the workings of the Taser. But your Taser training, does that go all the way back to the 8-week that they start to train you?
Yes.
Is it lectures, hands-on? How do they instruct you?
Combination. There's definitely a classroom element, scenarios, and they do a voluntary exposure.
And we'll get to that in a moment here. But if used properly by a trained person, what is the main goal of using the Taser on a subject?
To achieve neuromuscular incapacitation.
And can the Taser be effective at causing
Yes.
incapacitation? Do you know that firsthand?
Yes.
Now, your voluntary tasing, was that back at your 8-week then?
Yes.
Mr. McFarland, could you just pull up? I believe it's Defense Exhibit J. It's the voluntary tasing. Does that appear to be your voluntary tasing session?
Yes.
We've had this explained, but is it a rather controlled setting?
Yes.
Does safety seem to be paramount?
Yes.
The faces are blurred off, but what is everybody wearing on their eyes?
Everyone's wearing safety glasses.
Now, what is your understanding of why the voluntary tasing might be beneficial to recruits?
Just to know the effects of it, to know what you would potentially be doing to someone else as well.
But even though controlled, do you still have to sign a waiver?
Yes.
And essentially, what does the waiver tell you?
Essentially, that waiver, my understanding was relieving the city of any potential liability from injury or death that the device may cause.
Now, who's deploying the taser on you there?
It's a master taser instructor.
Could you please play the video, Mr. McFarland?
Taser.
How'd that feel?
Terrible.
What did it feel like?
Just essentially your muscles contract involuntary to their max capacity, and it's extremely excruciating pain.
Now, can you compare it to anything else that you'd ever experienced?
No.
Have you ever felt like anything like that before in your life?
No.
Now, after having felt the effects of the taser, would you volunteer to do it again?
No.
But prior to being tased there, did the master taser instructor give you some instructions on what was going to happen?
Yes.
What did they tell you?
They did a couple different deployments and varying spread, and he let me know how he was going to deploy it on me.
Okay.
And where.
I'm sorry, where?
Yeah.
And does that help at all with any angst that you may have?
Probably alleviated some.
Now, when you were tased there, did you feel like you had much control over your body?
No.
And we've heard this term, I think, sometimes, taking the ride. Is that what they refer to it as, is when you're under the effects of the taser?
Yes.
How long does that ride last?
5 seconds.
Do you feel during that 5 seconds that you have the ability to defend yourself?
No.
What are you trained that can mean for a police officer in the field if someone fights them for their taser and uses it on them?
They would get access to our firearm.
Now, in police training, do you discuss topics like that? Officers getting disarmed of their weapons?
Yes.
Generally, what are you trained to presume if a subject forcefully disarms an officer of their weapon?
They would use it on us.
The ride is 5 seconds?
It is.
How long do you think it would take for someone to get your firearm off your body and use it on you?
Second.
Mr. McFarland, could you please play that again?
Taser.
What were you trained back then, as far as if the user continued to hold it or continued to press the button?
Well, so it's designed to be charged for 5 seconds, but you can hold the trigger down or keep pressing the trigger to keep doing additional 5-second cycles.
In your training, are you warned not to continually hold it or have repeated trigger pulls on a
Yes.
subject? What were you warned was the risk of prolonged or continuous holds or deployments?
Can cause cardiac arrest.
And is cardiac arrest mentioned in the Axon materials that they go through with you?
Yes.
What can be the result of cardiac arrest?
Death.
Would you expect an untrained person to know that a continued or repeated ride could cause cardiac arrest?
No.
Now, how far was the master taser instructor from you approximately when it was deployed?
Probably 2 feet.
Would that have, particularly with that older model, would that have been optimal probe spread?
No.
Can you just stand up a second?
Yeah.
Where did the probes hit on you?
They hit my, I guess, right leg, just the back side of it, and they were probably only that far apart.
So that's fairly close, is that fair
I
to
would
say?
say it's really close.
But watching that video, was it only your leg that felt the effects of that?
No, I would say it was my entire lower body, but my arms are, it's more or less an involuntary response, so I didn't feel like I had control of my arms.
Do you feel like the taser did its job and was able to incapacitate you?
Yes.
Now, just going back to this topic of a closer deployment like that, after your voluntary tasing, did the GRPD, we've heard there was updates and models.
Yes.
Do you recall what model that old one was?
I don't recall the names. I know at the time of the incident that we're here for, I had the Taser 7.
Okay. And was there a new feature on the Taser 7 for close quarter situations compared to the older model there?
Yes.
And we've heard, was there a new cartridge?
Yes. I obviously don't know the exact degrees. Essentially, there is a cartridge designed with a wider angle, if you will, to achieve a greater, we'll call it NMI, at close range.
So, if in this video you would have had the newer Taser 7 model and it was deployed at that same distance, what may have been the effect though on you there?
I would assume a greater effect as probes get further apart.
Now, besides the cartridges, were you trained that the Taser has the ability to drive stun?
Yes.
And how do you activate the drive stun?
Anytime the device is activated, essentially the drive stun is activated. The drive stun's the technique. The
attorneys keep mixing it up.
It's essentially the end of the device gets activated along with the probes and wires.
And then are you taught that you can drive that activation and stun the individual?
Correct.
So it's the action is drive stunning.
Or you would get a greater NMI by doing that.
And I'd like to go into that here, because under what circumstances did GRPD train you to use the drive stun?
Every time we would use the drive stun, it would be to achieve NMI.
So was that the only time you were ever practicing the drive stun on individuals?
Correct.
So to a GRPD officer, you're only using the drive stun in association with NMI?
Correct.
Mr. McFarland, could you please go to this defense exhibit J? And this is the 8-week demonstration on the dummy. Just to confirm, is this you in the video here that
It
we'll
is.
see in a moment?
Yeah.
And was this back in the 8-week academy?
Yes.
Could you please play that? Mr. McFarland? Chris, how far from, that's a dummy, correct? It's not a live person.
Yeah.
How far were you from the dummy when you deployed the probes?
Foot.
And what did you do after you deployed the probes?
I moved the device to what would be the dummy's calf.
Were you trained that that's an acceptable distance to deploy the taser?
Yes.
You've heard throughout this trial some question of you should not deploy the taser at a closer range under some different standards. This is how you were trained, that you could use the taser in that close of quarters?
Correct.
Could you just play it again, please? I'd just like you to focus on unholstering here, please. Be able to see yourself getting the taser out of the holster.
Yeah.
And we've heard the jury's heard some testimony on this already, but does it take some action to get the device out of the taser?
Yeah.
I'm sorry, get the device out of the holster.
So this device, I would say, and holster combination was significantly easier than what I was equipped with on the day of the incident. This one was a little more loose fit, so it's easier to actually, you have a snap, which is kind of hard to undo at times, and then a hood that holds the device in. So this was a little bit looser fit, so it was a little more functional, if you will.
And when the Taser 7 came out, are you provided with new training materials on that?
Yes.
And was that a topic that was discussed in some of those materials as far as that it has a different type of holster?
Yes.
Now, let's just say on this video, what if only one probe connected or made contact even with the dummy there? What would the drive stun do there? What could the drive stun do to help cause NMI?
It would, I guess as they would say, complete the circuit to create it's always a third point of contact, but you get that another point of contact to create the NMI.
Okay. Now, prior to April 4 of 2022, did you have occasion to actually use your taser on subjects out in the field?
I did,
How many times?
just once.
And where on the body did you deploy the taser on that prior occasion?
Subject's back.
And was it a struggle with the individual, or?
Yes.
And how far away were you from the individual when you deployed?
Foot and a half.
And what did you do after that?
I believe I had to move the device to another area on the subject to achieve NMI.
And what did this assist you in the situation?
Yes.
What were you able to do from that point?
I was able to take the person into custody.
Now, I'm getting ahead of myself a little bit here, okay? But in that prior use out in the field, going to April 4 and the incident that we're here on, the proximity of you and that individual in the prior case, was that a very similar proximity as you were to Mr. Lyoya when you went to initially draw your taser?
Yes.
On that prior taser occasion, are you required to notify your department if you use force?
Yeah, any use of force, we have to notify the department.
And was anything found inappropriate about the way you used your taser on that occasion?
No.
What did the department actually do in response to your use of taser on that occasion?
So we have to object or get into another taser deployment, what the department did or anything is purely irrelevant.
Your Honor, I think it's important to go to what his training was and what his department did as far as in response. They didn't.
To a different incident?
Yeah, to solidify his training and their practices and his experiences.
So I'll sustain that objection, because I don't believe that particular question was one calling for a relevant response to the case.
What's ingrained in your head from that prior experience as far as the distance that you were from Mr. Lyoya and whether that might be appropriate?
that it was appropriate.
Now, during Taser training, are recruits and officers, when they're updates, provided with lectures and materials from Axon?
I'm sorry, can you say that?
Are you provided or gone through with materials from Axon, the manufacturer?
Yes.
And what are you warned about the Taser?
That it can cause serious bodily injury or death.
Now, are you trained on preferred target areas of the body to use the Taser?
Yes.
And how do they show you this in general? Do you recall anything in particular? I think it's in
It's
some
just,
of that.
yeah, it's just a body and it shows caution areas.
And are you trained on areas to avoid then?
Yes.
And we've heard this area is sensitive areas. Is that something that's discussed?
Yes.
What areas on the body are you trained to avoid using the Taser upon?
Essentially the head, neck, genital region,
And
and chest.
are you taught to avoid either shooting probes or using drive stun on those areas?
Yes.
What are you trained can be the risk of Taser use on the eyes?
Blindness.
Now, are you also advised that Taser use on some of these sensitive areas can just overall cause serious injury or death?
Yes.
So that's you, the officer, that's what you're being instructed directly from the manufacturer, is that fair to say?
Yes.
Now, going back to the 8-week here, after the 8-week, what are your duties?
I'm assigned to a field training officer. Essentially, we go into a FTO program that's 4 months long. You're given different training officers to grade your performance on a daily basis.
And I'm sorry, you said that's how long?
4 months.
4 months with an FTO,
Correct.
is that what they're referred to?
Yes.
And along the way, they're evaluating and critiquing you, is that right?
That's right.
And over time, do they start to give you more responsibilities?
Yes.
Do you deem the FTO, are they essentially an extension of the training unit?
They are.
Would an FTO generally be well-versed in the rules, policies, and the practices of the department?
Should be, yes.
At some point, were you an FTO down the road?
Yes.
For how long approximately?
I think 3 or 4 years.
So did you essentially train other officers in the Grand Rapids Police Department
Yes.
on practices, policies, and procedures? Is that fair to say?
Yes.
Now going to April of 2022, how long would you have been an officer with GRPD in April 2022?
Almost 7 years.
In April 2022, were you overall physically fit?
Yes.
Were you a little ways from your college athletic days, or did you maintain that for?
I think it'd be fair to say I didn't have the amount of time to dedicate to exercise like I did in my college days.
But in April 2022, what did you do to maintain fitness, just generically?
I exercise 5 or 6 days a week, whether it's cardio or weightlifting.
Okay. Anything marathons, Ironman, anything like that?
No.
How about MMA or competitive wrestling, anything along those lines?
No.
Why did you stay physically fit?
I just think it's important. We are required to back up our partners and assist people on calls, and unfortunately, part of our job is sometimes we have to go hands-on with people.
Okay. During the 6 years of service up until April 2022, do you have ongoing trainings?
Yes.
Can you just give us a little synopsis, or how often?
I'd say we have regular trainings. It started to become more regular with smaller blocks at that time, so we might have been doing training maybe a couple times a month on different topics.
Are there policy updates over the course of that time?
Yes.
And are you required to stay up to date on policy changes?
Yes.
Is that something you took seriously?
Yes.
Now, as a road patrol officer in GRPD in April of 2022, were there certain crimes that were more prevalent or perhaps more of concern for you out on the road in that time?
Yes.
What were they?
I would say in the city at that time we had to worry about gun violence, drugs, and stolen cars.
Okay. Now we're going to April 4 of 2022, all right?
Yep.
What shift were you working that day?
First shift.
What time does your first shift run?
Mine ran from 5:30 in the morning to 5:30 at night.
So you've got 12 hours that you're essentially out on the road.
Correct.
How many days a week? Generally, were you working 12-hour shifts?
Well, it kind of varies. I mean, some weeks. So one week it's Monday, Tuesday, and you have Wednesday, Thursday off, and you work Friday, Saturday, Sunday. The next week you work Wednesday, Thursday, and that's it. So
It's all over the place.
it's all over the place.
Okay.
And then overtime in between there.
All right. Now, for a 5:30 a.m. shift, what time would you have woken up on April 4 of 2022?
Between 4 and 4:30,
Any normal routine in the morning for you?
just shower, shave.
Okay. What time did you normally arrive to GRPD?
Sometime around 5.
What was your normal routine when you arrive down at the station?
Just get into uniform and then go to the room that we had line up at and go over wanted subjects, and we also had a sheet for stolen cars.
Now, what time would you actually, for a 5:30 shift, what time would you actually get out on the road?
Oh, probably closer to 6.
And it's been 3 years, okay, so I'm not asking you to remember every bit of your morning there, but do you remember in general what you had done during your shift prior to this episode here that morning?
I believe I responded to just a basic alarm at some point, and I know one of the issues I had in my service area was speeding complaints in a school zone in the area of 36 in Kalamazoo. No, I went down there and realized that it was spring break. It was pretty slow, so there wasn't many cars to stop in that area at that time.
Okay.
I know I reviewed policy here and there, and eventually ended up in the area of Kalamazoo and Fuller.
What were the weather conditions that morning?
Cold, wet, rainy, like a rain-snow mix.
Overall, was it a busy morning out around the roads, or was it slow? Or
I recall it being pretty slow.
now you mentioned Kalamazoo. You eventually found yourself over in the area of Kalamazoo Avenue and Fuller Avenue, correct?
Correct.
And is that on the southeast side of Grand Rapids?
It is.
Are you familiar with that area?
Very familiar.
Why is that?
I was assigned that area night shift for 6 years.
Okay. Now, at some point, did you observe the Nissan Altima in that area?
I did.
And can you just explain to us here as far as when you first observed that?
I was traveling south in Kalamazoo, approaching the area of Dickinson and Orville. I noticed the vehicle was traveling slowly, and as I had gotten fairly close to it, it made an abrupt right-hand turn onto, I believe, Orville. At that point, I was able to run the license plate, and I continued south on Kalamazoo.
Now, what does it mean to run a license plate?
Essentially, we have a computer right next to us, and we're able to enter the license plate information into, giving us access to LEAN, Law Enforcement Information Network, and Secretary of State information.
And running license plates, is that a common practice for you out on patrol every day?
It is.
How often would you say you run license plates?
Depending on the day, how busy I am, I could run up to 30 license plates a day.
Okay. When you ran the license plate, were you behind the vehicle then?
I I was.
Were you ever able to even see the occupants inside of the vehicle?
No.
So the vehicle, Mr. McFarland, could you please pull up the map? Chris, can I just approach you here?
Yes.
Or can I approach the witness? I just want to get a laser pointer.
You want to try that?
So what direction were both?
Identify the exhibit, please. It says Q at the corner, is it exhibit Q?
Yes, I'm sorry. This is defendant's proposed exhibit Q.
Q was already admitted.
That's stipulated, okay.
Okay, so this is exhibit Q.
Yes.
Go ahead.
So Chris, just to help us understand this a little bit, what direction were you driving and whereabouts were you when you first observed the ultimate?
In this area, and I believe it was right around here, Kalamazoo, Norville, when I'd gotten fairly close to it.
Just to confirm that north is going up and south is going downwards here on this map.
Correct.
So if I have it right, you were traveling south and the Altima was traveling south in front of you?
Correct.
The Altima turned where?
I believe it was Orville.
Alright.
So they made a right-hand turn to head west on Orville.
And as it's turning, you type in the plate, and where do you continue while you're typing in the plate?
I continued south on Kalamazoo.
And just tell me, as far as running a plate, what's the norm with this system?
You'll type it in into a little box, and you usually experience some type of delay. So depending on the Wi-Fi connection at the time.
At some point, do you get a response from that?
I did.
The search. And what does that indicate to you?
I had gotten a response indicating that the license plate that I had ran didn't match the vehicle that I had just seen, essentially.
Now, a plate that does not match a vehicle, is that a law violation?
It is.
Is it a legal justification to stop a vehicle?
It is.
So what did you do next?
Well, I had gotten the response prior to reaching Griggs. When I saw that I had gotten a response indicating an improper plate, I turned right onto Griggs and driven up to Newark, where I saw the Nissan traveling south on Newark, about mid-block or so.
What did you do next?
I went north on Newark in an attempt to just get eyes on the vehicle, verify it's the vehicle I saw, and also verify that I had the license plate information correct.
Is that something that you like to do in that situation?
Yeah, especially when it's super easy to fat finger a letter and potentially get an improper response on my own.
Okay. So now if I have it right, you're traveling north on Newark and the vehicle is traveling south towards you?
Correct.
And what happens next?
I turn right behind the vehicle as I'm passing it to check the license plate and to verify it entered it correctly, and I pull into a drive somewhere around here in an attempt to get behind this car so I can stop it.
And as you turned there, were you able to get a look at the license plate?
I was.
And what did that indicate?
That I'd ran the license plate correctly.
Now, throughout this trial, we've been watching videos, dash cam and body cam videos. When you turn into the driveway there to turn around, is this the moment that the cameras activate? All right, you're gonna correct me there.
Yeah.
And we've had people explain the
The camera, yeah, essentially
Go
we're
ahead.
on a That's where we see the camera start on all the videos that we've seen, just because of the 30-second delay. Yes.
Okay. And if we heard it right from, I believe, the Axon expert as well as Detective or Captain Cyber talked about, a lot of times the camera's always running generally, is that right?
Correct.
But there's certain triggers that start the recording mechanism.
Starts the recording mechanism, and when that starts, it brings in the 30 seconds prior to that activation point.
So you had some type of trigger later on, and then it jumped back and started recording you to the point that you were turning around there.
Correct.
And does it activate your dash cam and your body cam?
Yes.
Okay. So what did you do next after you turned around?
Well, I wanted to initiate a traffic stop on the vehicle, so as I turned around, the vehicle turns right onto Griggs from Newark, and that's essentially, then we see me starting to head this direction as well. And as I'm making this turn, the Nissan is making another right-hand turn onto Nelson.
So where did the Nissan start out up on Orville?
Somewhere in this area.
And it turned off Kalamazoo where?
Well, it turned off Kalamazoo in this area onto Orville, I believe. And that's where I lost sight of it and continued south after running the license plate.
Okay. So at this point, the Altima turned on to Orville, traveling down Newark, took a right on Griggs, is that right?
Yes.
And then took a right on Nelson?
Yes.
Is that right?
Yeah.
So essentially, the vehicle was somewhat starting to drive in a circle?
Yes.
Right? Anything about when you turn around on a vehicle immediately after passing it, start turning around and then it starts driving, making a couple of right turns, anything about that is noticeable to police?
Just seems evasive. A lot of
Okay.
times people will change their direction just based on the sight of our fully marked cruisers.
So what did you do next here, Chris?
Well, I had gotten on the radio and notified dispatch that I was making a traffic stop.
Why were you making a traffic stop?
Why? Because the license plate didn't match the vehicle.
And that's a lawful justification to stop a vehicle, is that right?
Correct.
Okay. So I think we've seen it on video, but you get on the radio and call out a traffic stop.
Yes.
What's the normal routine or expectation or common practice when a GRPD officer calls out a traffic stop? Just calling it out.
Essentially, I'm calling out the traffic stop to let my teammates know that I'm where I'm at and to head my direction.
Okay.
So that the expectation is someone should be heading that direction.
Did you request anyone to head
I
in that
didn't actually say those words, but just calling out the traffic stop itself, that it provides that expectation.
Is that the normal routine that other cars may come over and, I'm not sure the terminology, but rolled past or something along those lines?
Yes.
Okay. Now, what happens after you call out the traffic stop?
I started calling it out, and then I activated my overhead lights, which is when the cameras actually activate, and that's where we hear the sound. And then I proceed to finish calling out the traffic stop as I'm coming to a stop. At that point, the driver of the vehicle is exiting as I'm finishing my transmission.
Okay. Is the driver getting out of the vehicle when you're pulling them over, is that normal?
It's definitely, it happens quite a bit. It's just, wouldn't say it's the norm, I guess, but it does. Sometimes we do have people exit and start arguing and that type of thing.
What does that do for the police officer compared to a normal traffic stop?
It definitely raises our stress level.
Now, what are you trained to do in that situation when the driver gets out of the vehicle?
Just take control of the situation, usually just by giving authoritative, concise commands.
Now, what is the importance of trying to take command in a situation like that?
Just to keep myself and others safe.
Are there unknowns when you pull a vehicle over in a traffic stop?
Yes.
Now, when you tell the driver to get back in the car, does he follow your directions?
No.
And you talk about this take command. How are you trained to take command as far as just your voice and the directions?
It's just an authoritative voice with just simple commands of what you want someone to do.
And is right in your policies, is that what you're trained to do as far as authoritative, concise commands?
Correct.
Because on a normal traffic stop, driver not getting out of the vehicle, what's your normal approach on a traffic stop?
I just walk up and say, hey, I'm Officer Schurr with Grand Rapids Police Department. I stopped you for whatever the reason may be, and at that point I'll request their driver's license, proof of insurance, registration.
Because in this non-take command, usually you have a much different tone, is that right, on a
It's
traffic stop?
significantly different.
But here, you're trained, you need to talk authoritatively and concisely, is that right?
That's right.
Now, in this take command situation, does that do anything to your stress level as the officer?
Yeah, it definitely raises my stress.
Why?
I don't know what's going to happen.
Now, at this point, do you know who the driver is?
No,
Do you have any idea why he's getting out of the car?
I don't.
Now, you gave how many commands approximately did you give the driver to get back in the vehicle?
4 or 5.
Did he follow any of those?
No.
Now, failure to follow police officers' commands, can that in and of itself be a law violation?
Yes.
And could you technically have the authority just to place the individual under arrest right there?
Yes.
And did you do that?
No.
Why?
I just wanted to give him the benefit of the doubt.
Okay. So what did you do next as you're commanding the driver to get back in the vehicle?
I approached him and kind of had some back and forth in regards to, I believe he questioned me on the reason for why I stopped him, what the issue was. I had to repeat to him why I stopped him. At some point, he said something that I didn't quite understand, between just not understanding him and obviously he hadn't listened to any of my commands. I asked him if he spoke English.
And what was his response?
He quickly responded yes.
Is it important that you understand each other?
Yes.
And were you able to confirm that?
Yes.
So what did you do next?
I asked him for a driver's license.
Is that normal in a traffic stop to ask for a driver's license?
It is.
Are drivers required to have a valid driver's license on them?
They are.
And if a driver does not have a valid driver's license, is that a basis to place them under arrest?
Yes.
So you asked the driver for their driver's license, and what was his response?
He patted one of his pockets, I believe, initially when I asked for it, and then wanted to say that he said it was in the car, and I told him to get it.
Okay. Now, what did you do during this? What did you do at this point?
Well, I told him to get the license,
Mhm.
at which point he asked the front seat passenger for the license, and I just kind of take a step back and observe that the front seat passenger appears as though he opens the glove box and shuts it without providing any type of license to the driver.
Based on your 7 years of police experience, what are you sensing at this point?
At that point, I'm sensing he doesn't have a license.
Okay. So what happens next?
The driver shuts the door and begins to walk away from me.
And when a driver, can a driver just walk away from a police officer in this situation?
No.
Based on your experience and the circumstances that had transpired thus far, what are you feeling at this point?
Well, your stress level definitely goes up. You're going to end up going hands-on with the person. So it's a pretty stressful situation. It starts to raise your heart rate a little bit, if you will.
So what do you do next?
I grab onto him, tell
Okay.
him to put his hands on his head.
Why?
I just wanted to place him under arrest.
Okay. Had he committed violations that were arrestable offenses?
Yes.
What happens when you place hands on him?
He spins towards me and shoves me away.
Now, in your experience, when you go to place individuals under arrest, do they always want to be arrested?
I would say typically people don't want to be arrested.
But is one of your essential job functions, going all the way back to the MCOLS Academy, that you may need to effectuate arrest by using some level of force?
Yes.
Is that what you were attempting to do here?
Yes.
I believe you mentioned that the driver pushed you. Is that right?
Yes.
Was there anything else during this initial skirmish that you took as any types of aggression?
His fists were clenched.
And what does that mean if someone's fists are balled up to you?
Could lead to a physical assault on me.
So at this point, did this turn into somewhat of a tussle already initially?
It did, yes.
Under Michigan law, is it a violation, a felony violation to assault and resist a police officer?
It is.
So now what happens?
He proceeds to run away from me.
Does he get very far from you?
No, not really.
So what do you initially do?
Initially, I got on the radio just to let dispatch know that I had someone running to elicit emergency response.
What does emergency response mean?
Essentially, people will start driving with lights and sirens activated and exceeding the speed limit, in hopes to get people there quickly.
In your, maybe it was 5 years or so working in that area, when you send out a message for an emergency response, what is your normal expectation of having other officers show up on scene?
Well, I think one of the big things is that area is pretty well confined, and it's not like we're working in the city, so we have officers in a small area, if you will. Typically, when you say that over the air, you can hear the sirens just saying something like that on the radio, and I don't recall hearing them at that time. But also, I mean, cars typically get there within a minute or two.
Okay. Now, was the driver, as he started trotting away, was he moving very fast?
No.
On April 4, were you in overall good physical condition?
Yes.
And going back all the way to the MCOLS Academy, are you trained that you may need to get into foot chases?
Yes.
And are you trained that you need to often run into very volatile and unknown situations?
Yes.
Based on your experience working in the service area of Grand Rapids, why do individuals often run from police?
My experience has been that when people run, it's typically for some type of felony offense associated with what they're doing.
So, does any foot chase then, is there always some type of risk or perhaps danger to an officer in a foot chase?
Yes.
Is there a policy advising officers that they cannot foot chase?
No.
And in fact, had you and fellow officers on your team been in other foot chases in the past?
Yes.
Approximately how many?
With other teammates and that kind of thing, I've probably been involved in hundreds, 100 or so, I would say.
So is it a normal expectation to pursue on foot when you're working with GRPD?
Yes.
How many solo foot chases do you think you were in?
Probably 30 or 40.
And is that a topic that the department had recognized you for in the past, as far as?
Objection, this is like the second time they've tried to introduce stuff that's already been excluded by the court, Your Honor.
Your Honor?
Because we have already had that discussion.
Can I just build a record briefly, Your Honor? The prosecution's experts. Chris, had you gotten in similar foot chases to the foot chase here in the past?
Yes.
And did your department ever punish you for that?
No.
In those foot chases, do you draw up a detailed police report?
Yes.
Do you have a body cam?
Yes.
Where do those detailed police reports explaining what you did, where do those go?
To the police department.
And then where?
Kent County Prosecutor's Office.
Was there ever any concern in the past with your similar foot chases in the past?
No.
Your efforts in other foot chases, did you catch people that were wanted on other criminal matters?
Yes.
Were you successful in getting a lot of unlawful contraband off the streets?
Yes.
During your tenure at GRPD, had there been episodes where subjects flee from police and then unlawfully enter the property of others?
Yes.
This area here, is that a rather densely populated area?
Yes.
And are there a lot of families living in those neighborhoods?
Yes.
Now, going back to the pursuit here, where did the driver initially start trotting towards?
Towards my patrol vehicle.
And you mentioned, what do you initially do when he starts to run?
I got on the radio.
So what do you do next?
I continued to chase him, and he turned in between his car and mine, and I waited until we got to a grassy area to initiate a tackle.
As you started to pursue him, were you confident in your abilities to catch up to him?
Yes.
Was he that far ahead of you?
No.
And he had just assaulted you, is that right?
Yes.
After you tackle him, what was your intention?
My intention is just to arrest him.
In that situation there that we see, did you want the driver to get up off the ground?
No, it's definitely advantageous for us to arrest somebody on the ground at that point with just their stomach on the ground.
Were you giving any verbal commands to the driver?
Yes.
What were you saying, if you recall?
And I know I told him stop resisting, get his hands behind his back.
Did he
variety of.
Did he comply with any of the commands?
No.
As the driver's on the ground, what is he doing?
His muscles are tense. I'm trying to grab his arms and I'm not able to get control of them.
Were you able to keep the driver on the ground during this initial skirmish?
No.
Was he able to get up off the ground then?
He was.
How many times?
Well, he gets up off the ground a few times during the entire incident.
Now, are you trained on, and I think we've already talked about this with the training unit, but are you trained on some different maneuvers to try and apprehend a suspect in a situation like that, to try to apprehend them and get them in cuffs?
Yes.
Did you try some of those?
Yeah, I tried to initiate, well, I did knee strikes on the driver.
What is the main goal of the knee strike?
Essentially, I was using my right knee to strike, I believe, his right thigh against what's known as the common peroneal, which is just a nerve, and essentially it does provide some pain to them, but it is more or less a distraction, an attempt to gain control of them.
Were you trying to injure him?
No.
Is that a maneuver that tends to cause injury?
No.
Were you mad or upset at this driver?
No.
What were you trying to do?
I was just trying to arrest him.
Were the knee strikes effective?
No.
Now, in your training, how are you trained to approach the initial encounter like this, as far as how much energy or how hard you're supposed to go at the initial outset?
Well, you definitely want to go pretty much as hard as you can and attempt to gain control as quick as you can.
And do they train you as far as whether you should try to give as many knee strikes as possible right off the bat?
I would say within reason, whatever is reasonable at the time, and attempt to gain control. I wouldn't say just keep going and giving them knee strikes like a bunch, but it needs to be proportional.
All right, let's understand. Mr. McFarland, could you please go to the body camera video? I believe that's the people's exhibit. People's exhibit 2.
It is 3.
Sorry. Exhibit 3. And Mr. McFarland, could you go to 1 minute and 45 seconds? And I'm going to ask you if you could please play that to 2 minutes and 38. 2 minutes and 38 seconds. Could you please dim the light, Sue?
No, stop. Put your hands down. Stop. 1915, got one running. Stop. Stop. Okay. Stop! Stop! Good. Get your hands behind your back, okay? Hands behind your back, okay? Put your hands behind your back. 1950, 34 cars. Okay.
Start me more cars. What does that mean?
I want an emergency response. I know I already asked for one, but my intent at that point is to let people know that I'm really struggling right now. And if you weren't driving fast, you better be driving a heck of a lot faster now.
Because from the moment where you first put your hand on him at approximately 1:45 until start me more cars, are we getting close to about a minute or so there?
Yes.
45 to 30?
Yeah.
Which direction was the driver running towards?
In northeasterly direction.
And was he on the sidewalk, or did he run over onto the grass in a different direction?
He ran over on the grass.
Is it, based on your experience, is it normal that individuals start to run in towards houses?
Typically, people start to run onto others' property. That is kind of, typically people don't just run down the sidewalk. It does happen, but I think people know that it's harder for us to chase them when they're jumping over fences and that type of thing.
Okay. One of your roles to protect all of these neighborhoods?
Yes.
Now, at this point, can you start to hear anything as you watch that, as far as your breathing goes?
Yeah, I'm definitely pretty exhausted at this point.
We're about a minute in. What were you wearing? We've heard some testimony about this, but what were you wearing that morning equipment-wise?
Just standard equipment. I had bulletproof vest with a plate, gun belt that had my firearm, taser, baton, flashlight, radio, pepper spray, 2 sets of handcuffs.
Approximately how much weight does that add up to, if you know?
20 or 25 pounds.
The knee strikes, do those, we watched it some in the training montage as well, as far as you practicing those knee strikes. Do those take energy to use a knee strike?
They do, yes.
And the driver, I know he's saying, okay, but is there anything about his body actions that's different?
Nothing about his body actions are suggesting that he's trying to comply.
What's he doing?
He's continuing to resist me.
Okay. Now, up to this point, actually just backing up, we can't see it as well in that video, but you had testified that the driver had been able to get up off the ground at least maybe 2-3 times during this initial struggle.
Well, I was saying just an entire incident,
Okay.
2-3 times, but yeah, I tackle him and he's able to get up
Okay.
again pretty quick.
And were you putting your weight on top of him as he got up?
Yes.
During this situation, in these training materials, does it indicate that you should stay engaged with the individual?
Yes.
Perhaps move on to some other training to try to apprehend the individual?
Yes.
Because at this point, had you attempted several verbal commands?
Yes.
And did he comply with any of them?
No.
And had you now used several different lower levels of physical force upon the driver?
Yes.
And did those appear to have any effect on him?
No.
At this point, do you know who the driver was?
No.
Do you know why he's fighting so hard to avoid arrest?
I don't.
Does that mean anything to you?
I mean, I'm wondering why He's fighting so hard, yes.
Because what's your normal experience having a struggle like this, where you chase and tackle and deliver some strikes?
My experience with foot pursuits has been typically people run, and if you start to catch up to them, sometimes they might just give up. Or you tackle them, they give up. Sometimes, yeah, you do have to do a couple knee strikes, and then they give up, but not this kind of drawn out altercation, if you will.
So what are you thinking at this point?
I really don't know what I feel like there's something more going on. That's what I'm thinking.
Now, at this point, are you getting any type of response from other officers as far as sirens?
No.
Are other individuals around you now at this point?
Yes.
Do you know any of those people?
I do not.
I believe we've seen it already, and we'll watch it again in a moment here, but I just want to ask you first, at some point, do you and the driver move across the lawn?
We do.
What direction do you move towards?
I guess we head back south.
And was that your choice to move south?
No.
What did you attempt to do?
Well, I mean, ideally it would have been, I would get his hands behind the back of us on the ground, but he's able to get up. I'm just holding onto his arms as he's walking us across the yard, if you will.
Did you try any additional maneuvers as you get across the yard?
As we go across the yard, I tried to do another knee strike, but I felt like I couldn't even hardly pick up my legs.
Why is that?
I'm just exhausted.
Mr. McFarland, could you please play from 238 to 303 on People's Exhibit 3?
Stop! Okay. Stop resisting!
Chris, were you able to hear your breathing there towards the end?
Yeah.
And what do you hear?
It just sounds like I'm wheezing.
Okay. And what's a wheeze?
I would say a constricted exhale, if you will.
Is it cold outside that morning?
It was.
And do you recall what you were feeling physically at this point?
I'm completely exhausted at this point.
Had your attempts thus far had any effect on the driver?
No.
And under policies in this situation, would you be justified to move up to some other level of force based on the driver's resistance and aggression that he's presented thus far?
Yes.
At this point, what do you train would be the next appropriate level of force to move up to?
Well, in my mind, I've tried knee strikes and they were completely ineffective. I didn't feel as though they were, they were having any type of effect, or even it didn't seem as though he was acknowledging the fact that I was striking him. So to me, what made the most sense with my level of exhaustion and just the lack of effect with those strikes, I felt as though I needed to move to a taser just to actually interrupt the muscle function.
And were you in proximity to the driver when you initially went to draw your, where were you in proximity to the driver when you initially went to draw your taser?
I believe I'm going for my taser right now, so I'm just right behind him.
And can you see anything blue? Where is your taser located on your body?
It would be on my support side, which is my left hip. So I'd have to reach across and grab for it.
Okay. And then you talked about the holster mechanism.
Correct.
To get the taser out of the holster. This proximity to the driver there, is that similar to the prior occasion where you used your taser on the job, as far as the proximity?
Yes.
And in that situation, was the individual also struggling?
Yes.
Now, what were your intentions at this point as far as where to deploy the taser?
My intention is to deploy it on the subject's back, just because it's more of a stress-free deployment for us in the sense that I don't have to worry about injuring him.
What happens next?
It takes me a little bit to get the taser out of the holster, and with me only having one hand on him, it affords him the opportunity to turn towards me.
Okay. And what happens as the driver turns towards you, if you can explain?
Well, when he turns towards me, I am actually able to finally get the taser out of the holster. And I recognize that he's facing me and I need to adjust or pay more attention to where the probes are actually going to be deployed.
This situation where the driver turns towards you, how much time does it take for this to quickly evolve?
Split second.
And I'm sorry, I may have missed this, but as the driver turned towards you, was there a taser attempt? Was there a deployment attempt there?
Once I realized that the top probe was going to be below his diaphragm, I deploy the taser. Yes.
Okay. And what happened as you deployed the taser?
When I deploy it, the driver grabs on to the taser itself.
Now, after the driver grabs your taser, did he ever let it go?
No.
Did you tell him to let it go?
Yes.
Had anyone ever tried to take a weapon from you before on the job?
No.
And going back to your academy, to your training, is disarming a police officer, would that be a pretty serious scenario?
Yes.
And what had you been trained to presume if a subject fought for a weapon from you?
That they would use it on us.
So how are you feeling about this situation now?
Extremely stressed.
And had you ever had that feeling before on the job?
No, at this point I'm afraid that he's going to get the taser from me and use it on me.
Now, this wheezing, the struggling for air that we heard, that was prior to the taser even coming out, is that correct?
That's correct.
And had you ever been in a physical combat situation this long on the job?
No.
Throughout the course of everything up to thus far, did the driver ever really stop resisting or fighting over the course of the whole struggle?
No.
Had you ever had a situation where you'd had to fight for a live weapon from someone?
No.
Mr. McFarland, could you just please play Exhibit 3 to the end? Lights, please.
How do you do? Let go of the taser! Let go of the taser!
Please turn the light back on. Does it sound pretty chaotic right there?
Yeah.
And can you hear your breathing?
Yes.
Has it improved at all?
No.
And we've heard this talk in this time frame about a second cartridge. At some point in the struggle, did you ever notice that the taser deployed a second time?
No.
Does it sound like you're panting for air in that moment?
Yes.
And as you watch the videos now, or the cell cam video now, are there other things going around you as well that you don't remember?
Yes.
And do you remember what people were saying around you at this moment?
No.
But after the fact now, you've seen this video many times, correct?
That's correct.
And have you heard this assertion that the taser was deployed a second time?
Yes.
But Chris, as you watch this video, okay, the cell cam video of the passenger, from the moment that we can now see the taser was deployed, do you fight after that? Do you fight any less, put any less effort into trying to get the taser back after that?
No,
Why is that?
I'm afraid he's gonna use it on me.
What was your focus at this point?
I just wanna get the taser from him.
So what do you remember? Your camera's off now. We
Yeah.
heard the explanation from the expert as far as the presses that were going on.
Yeah,
Is that fairly common in physical struggles?
yeah, it happens.
Now, what do you recall remember happening next?
Somehow I ended up behind the driver. I don't know how I ended up behind him. I saw that he had full control of the taser, meaning that he was holding it like a firearm with his thumb in a position that was blocking the safety switch, the on-off switch. And I was reaching over top of him in an attempt to shut it off in hopes that he wouldn't be able to use it on me.
Okay. And what happens next during this effort?
At some point, I start to feel him turning towards me, and I feared that he was going to use it on me.
Now, based on your training and experience, was the driver close enough to deploy probes on you?
Yes.
Was he close enough to press a drive stun on you?
Yes.
Were you basically within arm's length of each other?
Yes.
And had you experienced that taser capabilities?
Yes.
What were you thinking he was going to do with it?
I believed he was going to use it on me.
And you have firsthand knowledge of the incapacitation?
Yes.
How long does the ride last?
5 seconds in an ideal environment.
How long does it take for someone to get your pistol off and use it on you?
Second.
Did you, throughout your training, throughout your career, were you trained that the taser can cause death or serious injury
Yes.
in several different ways?
Yes.
And was the driver in proximity to do that as he's turning towards you?
Yes.
During the course of this struggle, had the driver been able to get up on prior occasions in the past successfully?
Yes.
And what was your abilities at this point as far as breathing? Was it getting any better?
No, one of the main reasons why I brought the taser into it is because I had no energy left to begin with. And we then get into a struggle over it for I don't know how long. And I'm running on fumes.
What have you been trained going all the way back to the MCLS Academy as far as action versus reaction? What have you been trained?
That action beats reaction.
And what does that mean here in that scenario for you?
If I had waited for him to point it at me, it would have been too late.
And what were you fearful of?
That he was going to use it on me and I was going to die.
Now, and you were in a proximity to each other that he could do that to you
Yes.
with how you've been trained about that device.
Yes.
Under your training, Chris, are you required to wait to be seriously injured or killed before you can resort to deadly force?
No.
So what did you do next?
I shot him.
Why?
I believe that if I hadn't done it at that time, I wasn't going to go home.
And Chris, we've been watching this video, analyzing this video and screenshots throughout this week, but in reality, is it fair the way that we're watching this in screenshots throughout this past week?
I'd argue it's not. No.
Because in reality, how much time did you have to make these decisions?
Split seconds.
After the shot, what was your energy level?
I really don't know how to describe my energy level. My energy was depleted that when I got the taser out initially. I don't know how I made it through that struggle.
And the video speaks for itself, but could you even really stand up after you fired the shot?
No.
Could you breathe very well?
No.
Mr. McFarland, could you please just play the dispatch, just one short segment of the dispatch?
So exhibit number or letter H.
H, Your Honor.
Thank you.
Just the portion, one portion of the website.
It is. 1915, August, involved a shooting. Penalty grant. Thank you.
Chris, was that your first call out after this shot?
Yeah.
How many breaths did it take to even get out less than 10 words?
I don't know.
Does that pretty much sum up your condition at this time?
Yeah.
How do you sound?
I've never been that exhausted.
Chris, were you out, did you want to shoot Patrick Lyoya
No.
when you took on this traffic stop?
No.
Did you have any prior bad blood with Patrick Lyoya?
No.
Were you mad at Patrick Lyoya?
No.
Did you plead with Mr. Lyoya to drop your weapon?
I did.
To the best of your abilities, did you fight to attempt to get your weapon back after he disarmed you of it?
I did.
And Chris, just as far as police work goes, okay, your career, did you enjoy police work?
I enjoyed it, yeah.
And why?
We were afforded a unique opportunity to help people in I guess a unique way that most people are not able to.
Did you take on this job way back in 2015? Did you take on this job to help people or hurt people?
I guess I'm going to have to object, you know, we've gone over this, I think what's the relevance?
I think that was really asked and answered as well. So I'll sustain that objection.
As a police officer, were you trained that you have the right to go home at the end of your shift?
Yes.
And are you trained that you need to be seriously injured or killed before you can use deadly force?
No.
Chris, as far as gun draws, okay? On prior occasions, did you have to pull out your pistol while on the job as a police officer?
Yeah.
Roughly how many times had you drawn your gun, not at the range, but just out in the field?
A few hundred times.
And was it drawn within training and departmental policies on those prior occasions?
Yeah.
On some of those prior occasions, did you have some type of fear or some type of potential threat around you?
Yes.
But on those hundreds of other occasions, did you ever fire your weapon once?
No.
And what was different here, Chris?
I believe if I didn't do what I did when I did it, I wouldn't be here today.
Now, backup ultimately arrived, is that right?
That's correct.
Do you even recall how long it took, or would you just be going off the videos?
Just be going off video.
And do you ultimately leave the scene?
I do.
Your Honor, I would move to play defendant's proposed exhibit that we will discuss. I move for admission. I believe the court's already had the opportunity to look at that. It would be defense proposed exhibit GG.
No objection, Your Honor.
Okay, and GG is admitted and you can play it.
just checking on you, all right? You good? All right, I'm gonna get somebody to be with you here in a second. I got an ambulance coming. We'll get you checked out, and I'll get a statement from you in just a second.
Is that you in that video, Chris?
It is.
And just approximate, but would that be maybe 4 or 5 minutes after the shooting?
I believe so.
Could you just play it again, please?
You alright? Don't say anything, just checking on you, alright? You good? Alright, I'm gonna get somebody to be with you here in a second. I got an ambulance coming. We'll get you checked out, and I'll get a statement from you in just a second.
No further questions, Your Honor.
So Mr. Becker, I'm gonna allow you to cross-examine, but because of the time, I think what we'll do first is take a break before you do that for 15 minutes. So we'll come back at 10:35. So me and Laura, remember to leave your notes upside down in your chairs and not to discuss the case with each other or anyone else. And remember the restrictions against watching any or accessing any news reports in the media or on social media. And we'll see you back here in 15 minutes.
Welcome back in. If you're just joining us, we're watching day 5 in the trial of former Grand Rapids police officer Christopher Schurr, where Christopher Schurr is now on the stand in his own murder trial. As you've heard throughout this trial, Schurr pulled Patrick Lyoya over during a traffic stop in 2022 in Grand Rapids, and after a brief encounter, the two got into a struggle which ended with Schurr shooting Lyoya in the back of the head, killing him. In the 3 years since the shooting, this is the very first time Schurr has spoken publicly about this situation. Tanner, we've been watching this first part of what could be a very long testimony for Schurr. What are your initial thoughts?
Well, of course, you're saying it's long testimony, right? We have just now heard from Schurr for the better part of 2 hours, and we're just on the defense side right now. So we still have to wait for cross-examination, which will come here in about 15 minutes. Actually, we know that it's going on right now live again. If you are watching maybe over the air or watching on 13+, you're going to see that on a 30-minute delay, which is court mandated. But some key takeaways here. I was watching the trial as it was going on and watching some of the questioning. Some of the things that we have been talking about since day one, you know, we're talking about training and policy and just police training in general, that Taser training, use of force training. That's another thing that seems to have come up again here in this most recent round of questioning. Something else that we're really zeroing in on too is exhaustion and fear. Was Chris Schurr exhausted? Was he fearful that Patrick Lyoya could have harmed him in any way? And also something that we got into a little bit was the intent and mindset of of Christopher Schurr at the time. And again, he going back to saying, I wrote a couple quotes down. If I didn't want to do what I did when I did it, I wouldn't be here today. Is specifically one thing that you just heard him say a couple of minutes ago. Them obviously painting a picture of what his mindset, his intent, and also what he was thinking at the time and feeling at the time during this entire altercation. And of course, I really do think moving forward, not to offer any speculation, but I think it's pretty clear to the viewers at home that they're going to try to paint exhaustion as a major factor in this as well.
Definitely building on those building blocks that some experts have told us that the defense has been trying to do since they brought witnesses. I want to bring in 13 on your side's Callie Lichter. Callie has actually been watching this from inside the courthouse. Callie, what are your initial reaction to seeing Schurr take the stand?
I know this has been the question for the past 3 years, ever since Schurr was charged with second-degree murder. Will he take the stand in his own trial? And when it comes to trials, you know, no one can comment on how he was feeling but him if he were to take the stand. So that's why you had a lot of talk during the trial about a reasonable officer, because no one can really comment to how he was feeling, because the only person, you know, who was in that position as the officer in that incident was him. So definitely, starting off the morning with the first witness being called, him taking the stand, it was definitely a shock for all of us media who were back in our media room on the 5th floor, about 5 floors down from the courtroom. I don't know if, we were expecting this would be a possibility. I just don't think we were expecting it to be a possibility this soon. And like you guys were touching on, the defense is trying to paint this as self-defense. He was exhausted. He had no other option. He was just doing his job. So during the defense questioning, we kind of went through almost decision by decision, how was Schurr feeling after that decision was made? Is that decision per GRPD policy? It's going back to those things and what those witnesses talked about yesterday. We had the 2 GRPD captains and a GRPD officer talking about GRPD policy. You had the one witness who was talking about exhaustion. He was an expert in exercise science, and he was kind of going through, Schurr's body language, the heavy breathing. And so we saw a lot of what the defense's witnesses have been talking about over the past couple of days really come into play during this direct examination.
And Callie, I want to ask about the emotion that we maybe have seen. That's something that experts have talked about, that's what we may see is the human side of Schurr. What did you catch up on this first part of his testimony?
It's hard because I'm not a body language expert and I'm not in the courtroom, so I'm watching this through a screen. But, at the very beginning, the defense asked Schurr, do you like public speaking? And he's like, no, I do not like public speaking. So usually that signals to someone that, when they're not comfortable speaking to a large audience, there's at least probably around 60 people, I believe, in the courtroom. There's 44 seats up there, for, the general public, then about 11 for people there for Lyoya, and then 11 people there directly for Schurr. So, there's a lot of people in this courtroom. You have a whole jury box full of jurors. You have the judge, clerk, attorneys on both sides. So he's speaking to a large audience, and it was established from the get-go that he doesn't really like public speaking. And I'm sure, watching this video, and that's been a trend, You have all of these videos that have been compiled. Of course, they're going to be used as evidence. So again, today we're watching the video play out. He has to relive that day. And, the fact of the case, and that's not something that has to be proven, and that's something that, Schurr admitted during his testimony, he shot him. That's not up for debate. He's honest about it when he was on the stand. He shot him. And I'm sure, on any circumstance, it's probably an uncomfortable day to relive for anyone involved. And so I'm sure, between the anxiety that he testified to, or the anxiousness, speaking in public that he tested to, having to relive this day. I'm sure it's probably nerve-inducing. And of course, this is his trial. And it's been 3 years. He's been charged for 3 years. We've been through hearings, through motions, through preliminary exams. And this is kind of the culmination. It's the final moment. And, we don't know how many people, if the defense has any other witnesses after him, but usually, the person at the subject of a trial is usually the last one to take the stand. So again, don't know what's going to happen next, but this could be the final piece, the final witness before the defense rests and we go into those closing arguments.
Well, Callie, I know that Chris has taken the stand once again, so we're going to let you get back into the courtroom so you can watch that. We want to bring in a team of legal experts speaking to Tanya Cross-Phelan and Andrew Rodenhouse. Andrew, Tanya, what are your initial reactions of hearing Schurr take the stand?
Well, I jotted down a couple of notes. My one big takeaway I had was that he testified that he didn't know that the taser had deployed a second time. What that would mean that in his mind, that Patrick was getting a taser gun that still had another two prongs to shoot out and do the to hit him with, and so we had all this testimony from these experts about using the taser in drive stun mode. But what we learned today from Officer Schurr's testimony is that he thought that it still had another charge in it for using the prongs. And so he testified that he was trying to reach down to shut the taser off in the hopes that that now that Patrick has it, that he wouldn't be able to figure out how to use it. And when that failed is when he decided that he needed to fire the fatal shot. And so that was interesting because we've never heard that story before. We've never heard from him. And remember, the officers have to make a statement after an incident like this. And so it'll be interesting to find out whether or not he made that in the original statement, because if he didn't, then I would expect Mr. Becker to impeach him with his prior statement.
And Tanya, can you add to that? What are your initial reactions?
My initial reactions are that this was a difficult thing for Mr. Schurr to go up and testify about. I think the observation about starting off by saying he's not comfortable speaking in public sort of set the expectations for how he might come across to the jury. He was very calm, but you could tell he was uncomfortable. And then the other dynamic that's at play here is he's an officer, so he's an expert, if you will, on how to respond to these types of things. So he's talking in that capacity, but yet there's this very real human aspect on the other side of it. So that was really interesting. And to one of the points that Andy just made, you'll recall back when Mr. Bloomfield was testifying and the defense cross-examined him about this aspect of auditory exclusion. What we're going to start seeing when we get to closing arguments is how the lawyers piece together all the bits and pieces of the evidence we've heard throughout the trial to craft that closing argument. And I want to link that idea of auditory exclusion to what Andy just pointed out, that Mr. Schurr testified that he never heard that second taser being deployed and how that affected his state of mind. And we know by tying that back to the testimony about the idea of auditory exclusion, there's legitimacy, to Mr. Schurr's statement that he never heard that second shot. So I thought that was very fascinating.
Andrew, I want to bring up a point that you made about the statement on which Schurr would have had to write after this entire incident a few years ago. I can tell you right now, I'm reading the live blog that we have up on 13onyourside.com, and it's already being put in front of Schurr's face. Actually, I just watched them put documents in front of his face, and they're pointing at things as they go down through that report. What is the strategy that the prosecution is using here to go through that report like how they are on the stand?
Well, it's just simple impeachment. It happens in every trial with nearly every witness. If they have made a prior statement or they have a statement that has been used previously, you're allowed to impeach them with what's known as a prior inconsistent statement. And so oftentimes when an officer has to make these Garrity statements, they're cautioned by their because they usually will have a union representative with them or an attorney paid for by the union with them. They're oftentimes cautioned to not give specific details so that basically it gives them a little bit of a leeway in the future. And what I would expect is that after cross, Mr. Dodge, who I thought has done a great job so far walking him through his testimony, I expect that he's been instructed, don't argue with the prosecutor because that just makes you look combative. He's probably been instructed, let him have his points if he's getting a point, and then we'll come back in on redirect and then clean anything up as it pertains to any inconsistencies, and then you'll be allowed to explain away why there's an inconsistent statement.
And Tanya, we have heard both you and Andrew talk about the building blocks the defense has started to create their case. Do you think what we've seen so far from Schurr has that confirmed that the building blocks are working? Has he stayed on track? What are your thoughts on that?
From the defense perspective, yes. Again, all of the witnesses that were presented by the defense yesterday laid very specific building blocks, if you will, for aspects of the self-defense elements, right? What Mr. Schurr was thinking at the time, how certain things would have affected him physically, how it might have affected him emotionally or mentally. So all of that lays the idea that what Mr. Schurr is testifying to today is not something he's just making up to try to get out of a criminal charge. It's really plausible that what he's testifying to is true because of everything these other experts have said. And I think Mr. Becker has some strategic decisions to make with how he cross-examines Mr. Schurr. As we've talked about already, Chris Becker is an excellent prosecutor and he is a rigorous cross-examiner. And the strategy here is, do you attack Mr. Schurr in sort of a aggressive manner, or do you be pretty matter of fact with him and let the facts speak for themselves as you cross-examine him? Do you try to rile Mr. Schurr while he's testifying so that the jurors might see a different side of him? So I'm really curious to see Mr. Becker's strategy for cross-examination.
Let's talk about the exhaustion and fear aspect of all of this. Of course, that's been a major topic and a major sticking point for both sides as they try to argue their case. Can you kind of explain to us, when Schurr is up on the stand talking about how exhausted or how afraid he might have been in that scenario, what does that do for the jury? Is it just enough for him to say that, or do we need that concrete proof to show those two things?
Well, you got to remember the burden is on the prosecution again, and so he doesn't have to show anything. It's the prosecutor that would have to show that. In fact, the prosecutor would have to say that that's not true and somehow demonstrate that that's not true. And that's what I think he's going to try to do in cross-examination. But as Professor Krauss-Phelan said, you know, the defense did a really good job of drawing out of the prosecution's experts stuff that they would want to then support Mr. Schurr's position that, hey, I didn't recognize that there was a second taser deployment. He's got I heard it described once as just tunnel vision. Like, he's in this fight, all his blood is going to his muscles, his big muscle groups. So like, there's not a lot of blood operating up here in your vision space and in your hearing, because all your energy is being put into this other area, and so it's quite possible he was not aware of that. In fact, and they were able to elicit that from the prosecution's expert.
And I would love to hear your opinion on this as well, Tanya.
Yeah, I think, now remember, the two witnesses that we had yesterday, Bartel and Kroll, they each lended expertise to both the exhaustion and the biochemical type of reactions in the body to this kind of situation, as well as the taser. But so we have that testimony that the kind of physical reactions the body is going to have to this stress level and this particular type of situation. But it's not just the defense experts. You can actually hear on the tapes, on the videos, the level of his breathlessness. And it's later seen both by the responding officers and their body cameras, the level of physical exhaustion. So again, these building blocks have been laid very strategically to support what was anticipated to be Mr. Schurr's testimony. And why it all matters is because when the judge, after closing arguments, gives the jury those final jury instructions, she will instruct them that they have to look at this from his perspective at the time, right? They're told that they have to look at it from his perspective at the time. So all of this, Schurr's testimony, supported by all of the underlying testimony that came before him, supports that notion that defense will argue he was in fear of imminent death or great bodily harm, and his physical state at the time lends to that belief.
And we are getting word that we are able to start seeing that 30-minute delay that we are on Schurr not taking the stand again to be questioned by prosecutor Chris Becker. I want to know, producers, are we able to take that right now? And we are, so take a listen in.
there, it should be queued up. Their exhibit. Or computer, wrong computer.
There you go.
Okay, I kind of want to start out with this incident started. Your testimony was that you were traveling down, I believe this is Kalamazoo Avenue, correct?
Correct.
And that's when you saw Patrick's vehicle traveling too slowly.
It was traveling slowly.
It was traveling slowly?
Yep.
Nothing crazy about that, just traveling slower. What's the posted speed limit here?
It's only 25.
So it's traveling slower than 25?
Yeah, I believe so.
So then it turned on Orville,
I believe
correct?
so. Yep.
And it wasn't concerning enough that you continued to follow it?
No.
Okay, but you were close enough. How close were you to the vehicle, Patrick's vehicle? Car length?
Probably.
I mean, you had to see it. I mean, it's,
Yeah. It was hard to see, so
you
I was pretty close in order to read the license plate.
okay. So it turns right in Orville, and you continue on down Kalamazoo,
Correct.
and that's when you figure out it's a bad plate.
Correct.
So by the time you get all the way down here, do your own right turn and come back up, he's still up in this area. He wasn't even all the way down, right?
Correct.
So it's not like he accelerated, not like he was trying to take off from you. He was still driving pretty darn slow because that's a farther distance to travel, right?
Correct.
And you travel, turn, and come back up, and he still was kind of poking along.
Correct.
So it wasn't like he was evading you at that point in time.
I don't think so.
I mean, you've had cars, I mean, you've been doing this long enough, people turn and then they try and take off, right?
Yes.
So he does a number 2 right turns after that. So you're saying 2 right turns are suspicious?
I would say in that manner, we're not sure where he is going at that time. Yeah, it does seem
That's
suspicious.
suspicious, just 2 right turns. Not speeding.
Not necessarily. I mean, that's taken out of context, but.
Contact.
I mean, 2 right turns in and of itself. I mean, we're traveling south, and then we're heading back north again. Upon seeing the side of my cruiser, and yeah.
Now, I think you can switch back over to mine, please. Now, I want to get into this. I want to make sure I'm using the same thing. You did a statement to Michigan State Police after this occurred, didn't you?
I did.
I want to make sure I'm referring, this. I'm going to show you this. Do you recognize that?
Yes.
Do you recognize that as your statement?
Yes.
And this is a type statement?
Yes.
Okay. And when did you sign that? This is your signature on it.
For, I think.
I had the same problem.
Yeah.
Your handwriting is as bad as mine.
Yep.
So for what? For, I said 15?
That would be my guess.
So this is
22.
22? Okay,
Yes.
so this happened on April 4th.
Yep.
Did you type this statement?
Yes.
Okay, you typed it. So and then you signed it on the day you got finished typing with it?
No.
When did you sign it then?
I don't recall the date of it being typed and it being signed and sent. I don't remember.
At least a few weeks after this happened.
Yes.
So you had time to think about what happened.
Yes.
You had time to go over what happened.
Yes.
Did you go over the videos, any of the videos before you wrote this statement?
I did. Yes.
So you reviewed the videos.
Yes.
So you present this, and you're going to be truthful, right? You want to be truthful because you're providing the Detective Tubergen and the Michigan State Police about your version of what happened, right?
Yes.
All right. So in that version, you said Patrick came out with a bladed stance.
Yeah.
Okay, a bladed stance we heard yesterday. It's like that's protecting a gun, protecting something like that. That's what
it could. Yeah, it could mean that. Yes.
Or maybe trying to fight, right?
Yeah.
This is Exhibit 3, Your Honor. Where's the bladed stance?
When initially he opens the door, that's how I perceived that.
All right, go back. Can you maybe dim the lights, please? So at that point in time, that's a bladed stance, so you think he's going to fight or may have a gun?
I'm not saying that. It's just the way he was standing.
So right there, you think that's bladed like he's maybe gonna do something?
It's definitely a different perception than the perception I had.
That's a different perception than the perception you had?
Yeah, because it's a different angle.
This is exhibit 2.
Oh, I'm sorry, exhibit 2, I did switch off. Thank you. So a different angle, so now you're saying you perceive it as bladed stance, like he may fight or have a gun.
He just took a bladed stance, and it looks significantly different when you're in my position to the left of that.
So that would be more your body cam.
Yeah.
Now we're on exhibit 3.
Back in exhibit 3, yeah. So you're saying there's two different views here.
To me, they appear different, yes.
You can turn the lights again, please. So taking this bladed stance, you've heard from Officer Door, that raises the level of suspicion, right?
It's something to be aware of, yes.
Because this in itself, I mean, how many traffic stops have you done for improper plates?
I'm not sure.
Hundreds.
Yeah, probably.
Tons of them. I mean, this is a
Yeah.
common stop. So this is a common stop. And this is improper plate. So somebody getting out, and by your version saying bladed stance, you're anticipating something bad then.
Him getting out of the car, I'm anticipating some kind of level of resistance, whether it's just verbal or him actually taking off running.
So then when he gets out of the car, you approach him. We're not going to go through everything there. But at some point in time, you say he doesn't speak English. You can tell he doesn't speak English.
I didn't say I
Excuse me, you thought he may not, because there's maybe a communication gap?
I was worried in the sense that there may be a communication gap because he hadn't responded to my commands yet at that time. And my perception to what was said, I didn't quite understand what he said. So I wanted to clarify and make sure he spoke English.
Do you speak English? Is that something that helps people that don't speak English understand English?
I think so, yeah.
This does?
I think it's a way.
I'm sorry to interrupt, but for the record, the prosecutor is using a hand gesture, like opening and closing his right hand. I just wanted to do that because you're like this, so I just
Sure.
want to make it clear for the record, but go ahead.
So then he answers he does speak English.
Yes.
Now, we want to go back, it's continuing on. Obviously, he doesn't have a driver's license, so having a driver's license, that's something that happens hundreds of times, correct?
Yes.
He doesn't have his driver's license, and then he shuts the door and begins to walk away from you. That's what you wrote here, back in April. He walks away from you.
Yes.
Now, in your testimony, you said that's when you went hands-on, and you said he had balled fists.
Yeah, he walked away, and when I went to put hands on, you can see that his fists.
You didn't put that in your written statement, though.
You're correct, yeah, I don't think it's in there, yeah.
You had a couple weeks, you forgot about it then, but now you remember it now that he had balled fists?
It seems as though when I see this video quite a few times, yeah, there's things that I notice more.
So
Yeah.
things that you notice, that you perceive from the video that you now can add in terms of what happened.
Yeah.
By your statement at the time, this is once again, so he walks away from you, you grab Patrick's right shoulder, which you proceeded to turn away from me and resist my attempts to place him into custody, okay? That was your version. So he walks away from you, he turns away from you, right?
Mm-hmm.
That's what you wrote.
If that's, yeah.
Would you like it if you want to
Sure,
take
yeah.
take a look at it?
Yeah. Yeah.
Okay. And then he ran away from you, right?
He did, yep.
Continued to run northeasterly from the traffic stop, so he ran away from you.
Well, yeah, he's running away from
Understand?
me.
That's
Yeah.
what you wrote.
Yeah.
So then you had to tackle him. I want to continue on, kind of moving ahead. After you tackled him, you wrote.
Are we reading statements in the?
Yeah, I am. This is his statement. It's a prior consistent statement. I have to confront him with it.
It's not inconsistent with his testimony.
I'm getting to it.
I didn't hear it, so I'll reserve room on the objection.
Okay. You wrote, after you tackle him, you did not comply with the commands as he was continuing to move his arms and legs in an attempt to get away from me.
Objection. I don't think this is the proper way if he's trying to impeach here. As far as he asked the witness if this refreshed his recollection.
I don't think he's trying to refresh his recollection.
No.
He's trying to impeach him with a prior inconsistent statement.
I don't think it's inconsistent, but
He never testified that Patrick was trying to get away from him. Correct?
I'm sorry, what
He
was
never
that?
testified that Patrick was trying to get away from him. Never said he was moving his arms and legs, trying to get away.
Turned and ran away from him?
I don't think that, well, I'll overrule the objection because this is cross-examination. He's reading what he previously stated, and to the extent that the jurors find that is not consistent, I mean, it appears that it is a bit consistent because he didn't say what that statement says, so.
You did not testify he was trying to get away from you. You testified you struggled, but in your statement, you recognize that he was, after you tackled him, he was continuing to move his arms and legs in an attempt to get away.
So, what is the question exactly?
That's what he was doing. He was trying to get away, wasn't he?
I would say that he was moving his arms in a manner that struck me in attempt to get away. Yeah, I mean, to me, it's.
Yeah, but you didn't testify to that, but that's what you ruled back in April, right?
I believe so. Yeah.
Further along after that, you attempted to.
Are we just gonna read the whole statement? I guess this just doesn't seem like the way.
So in your whole testimony, you never testified he tried to get away from you, right?
I think saying that he ran from me would be him trying.
That's one.
Yeah.
But in your struggles with him, we're talking about now your struggle with him. After you tackle him, on 2 separate occasions in your written statement, you recognize he was trying to get away from you.
When I
Didn't you?
tackle him,
After you tackled him.
well, I think that, I mean, that's the goal of the suspect or the driver in this situation is, I mean, typically when we go to arrest people, especially people that are fleeing on foot, yeah, I guess their goal is to get away from us. That's
Sure. Okay, their goal is to get away from you, but you even recognize that back at the time. In 2 separate occasions, you said he's moving his arms and legs to try and get away from you.
Yeah, I mean,
He didn't assault
I
you.
don't think well, he did.
Well,
I don't think I'm saying anything different then.
Well, that's your interpretation.
Yeah.
But back there, you never said he assaulted you, never said he punched you, never said he kicked you. Every time, 4 different occasions now in your written statement, he's trying to get away from you. He's moving his arms and legs, trying to get away from you.
Yeah, I mean, I'm not saying he punched me.
Yeah.
I'm not now, is what.
And you're not saying he kicked you?
No,
right?
correct.
Not saying he threw an elbow.
Correct.
Not saying he bit you.
Correct.
Not saying he headbutted you.
Correct.
Not saying he did anything else but try and get away.
I wouldn't use that blanket statement.
Now, in your testimony, we're going to move ahead to the time where you said he grabbed your taser. You testified in the jury, he grabbed your taser.
Yes.
He grabbed your taser and moved it away from him because he didn't like it tased, right?
I don't know what his intention was.
Well, you want to go back to your written statement back in April? Let's
Sure.
take a look at that. What did you rate then?
Yeah, moved it away from him.
We'll continue on.
Grabbed the body of the taser and moved it away from him.
So he would not be struck with either of the probes. That's what you wrote. You wrote that back and you just, you didn't even read it when I showed it to you. Why are you leaving that out?
I was reading the beginning. I thought that's what you.
So even then, it wasn't he was grabbing the taser to take it away from you. He was trying not to get tased.
I don't think want to, no.
Well, nobody wants to. I'm not even,
Right, yeah.
Tasing is not pleasant.
Correct.
Tasing is not fun.
No.
And I think you said, even in your thing, that tasing felt terrible.
Yeah.
Okay? So nobody's going to want to feel that. But something feeling terrible doesn't mean you can kill them, right?
No.
Because you would agree with that, because that's not part of Grand Rapids policy.
Correct, just that statement.
You can go a little bit further. Still on your body cam, exhibit 3. I'm going to play it for just a little bit. I don't think I have sound. You've heard it enough, so that's fine.
You say it was exhibit 3 again?
It is. I have a 3 on mine. It says up there. I'm gonna stop right here, because now, once again, you've tackled him, he's gotten up, and he's walking away from you, right?
Yeah.
He's trying to walk away from you.
I'm holding on to him. He's pulling us
Holding on.
across the yard.
So
yeah.
as he's walking away from you, you're about a minute, and I got a minute and 4 seconds or so into this?
Into the altercation.
Into the incident, correct. After you start running.
Okay.
Now, at this point in time, according to you say, you're exhausted.
Yeah, I really don't know how to describe it, yeah.
I just want, exhausted by my definition means it completely or almost completely no resources, no energy. You're exhausted already.
Yeah.
Okay. This is after 1 minute, and you said, we had heard in your opening statement that we heard you were an All-American cross-country runner, but now you're an All-American sprinter?
I wasn't All-American cross-country, no. I was just All-American track.
That's why, because, well, the opening statement was All-American cross-country. That's why I clarified.
I think she misspoke and said.
That's fine.
Yeah.
We all do it.
Yeah.
So, but you're an All-American track, but it was only sprints.
In sprinting events, correct.
What was your longest sprinting event?
Well, would you like me to go through what I did?
What's the longest one?
That I would participate in?
Yeah.
Well, the longest event that I'd participate in would be the 1500.
Okay.
But I wasn't, which is 1500 meters.
Sure. But going more recently, in 2022, you were trying out for the SRT, or were you in the SRT in 2022?
I believe I was.
You took a fitness test, didn't you?
A fitness test, yep.
You ran 1.5 miles.
Yep.
And you're like 11 minutes or so, a little over 11 minutes, I remember.
I don't recall.
But you're in the top 70% of Grand Rapids Police in fitness level for that run, weren't you?
I don't know.
Okay.
Maybe.
You did like 65 push-ups and 55 sit-ups in the allotted time, which puts you in the top 90%. Were you aware of that?
Yeah, that sounds correct.
So you're in pretty good shape.
Yeah.
Even though we all get older, but you're in pretty good shape.
Yes.
So at that point in time, what you had done is you tackled them, right?
Yes.
Did you do a forearm strike?
I don't believe so.
Well, I'm gonna go, make sure I got the right one. Now you did a kind of a follow-up statement, correct?
Yes.
This was, it looks like May 13th. There were some additional questions from the troopers, so they had to fill out additional forms, right?
Yeah.
Answer those questions.
Oh, all of them? You want me to go through all of them?
No, but this is your statement from the May. You
Yeah,
recognize that.
yeah, I do. Yeah, I guess I did.
Okay.
Try to- Yeah.
That helps refresh your recollection?
It does, yeah.
So in the recollection, you said the modes of force used was a forearm strike, just one.
Yeah.
Right? Knee strikes, plural, and a tackle.
Yes.
Those are the 3 uses of force you used before going to the taser.
Correct.
terms of this time, one of the justifications it says, you said you're exhausted. You said you're outnumbered, right?
Yeah,
Okay. You were outnumbered when you started this, right?
I was, yes.
You knew you were outnumbered when the moment it started,
Yes,
okay? You knew there's another person in that car.
yes,
You had no idea what was in that car,
correct,
other than that person.
correct,
We've heard your training is unknown traffic stops, right?
yes,
Unknown traffic stops, that there could be guns in the car,
yes,
there could be guns on the person,
they're good,
okay? And you're treating anybody that could be in an unknown traffic stop, they may have a weapon.
they may have one.
And you should treat them as such, right?
I wouldn't say you should treat them as such, because that's a little different than, they may have one.
Okay.
Treating someone as though they have a firearm, it should be aware of that possibility.
Should be aware of that possibility. It's something that worries you, because you said guns was one of the big things right there, being in the car.
Yeah, I mean, it's definitely what we're investigating.
And, you know, this is something, even going back to your days of training, Exhibit 37. This was some of the,
Your Honor, could I please see that?
sorry to admit it.
I don't know whether it's.
Take it. You guys haven't shown us the document. You guys haven't shown us the document the whole time, so. You've had a copy of this. This is going back to Exhibit 37, going back to recruit school.
Okay.
Okay. There's 4 scenarios on it, right?
Yes,
All 4 scenarios involve somebody with a gun, or something with a gun related to a vehicle stop, right?
yes,
So you were aware of that sort of training when you undertook this chase, right?
yes,
I'm going to show you now, show opposing counsel what has already been admitted as Exhibit 36. We got a copy of your training records. This is 1902, second training in 2019. Do you recall having this training regarding a Seattle PD officer-involved shooting after a foot chase?
I don't recall it.
You-
Off the top, I mean, I'm not saying, I'm
Sure.
sure it's been a long time.
Sure.
But-
So it was a long time, 2020, so would you have forgotten that, where it says to allow a safe distance and have a plan while chasing an armed or potentially armed suspect?
No, yeah, I
Well,
just
see-
don't recall the training, like, I just don't.
But
It's
you
been-
recall that?
Oh, yes,
That's one of the things you would have known when you started chasing back in April of 2022, right?
yes,
Going hands-on or tackling someone who is known to be armed is bad tactics, right?
yes,
Mr. Dodge asked you questions about, is disengaging, you said, in the policies a lot, you're not supposed to disengage. Is that
our main goal is to effect an arrest.
the main goal, but you're not prevented from disengaging if it's tactically advantaged, right?
There could be times to disengage, correct?
So that's why I want to make sure, there's no policy that says you have to remain engaged and do whatever, and keep fighting. You can disengage if it would make sense and tactically remove yourself to get a better advantage, right?
Correct. I'm not, want to be clear in the sense, we're trained to stay engaged, but yes, there may be, depending on the circumstances, yeah, you may need to
Sure.
disengage.
And that's the thing, depending on that's what we heard all over the place, depending on the facts and circumstances.
Correct,
All the facts are taken everything into account at the time.
correct.
Exhibit, we're gonna put exhibit 32 up on the screen. Next we go to 911. Okay, I just wanna make sure we're clear, because you said something, well, there's certain things that you know, policies depend or depends on the circumstance. You have no doubt that you're under 911, paragraph 3, Use of deadly force only defended against themselves, another officer, or another person, right?
Correct.
When a reasonable threat of death or serious bodily injury, that's the only time you can use deadly force.
Correct.
And you're fully aware of that at the time back in April.
Yes.
Want to go, okay? Totality of the circumstances, this was the policy in effect. You're fully aware of this totality.
Yes.
Now, we've heard, one of the factors is exhaustion of the officer, injury to or exhaustion of the officer, right?
Correct.
We've heard over and over, you were exhausted,
Yes.
but you weren't injured.
No.
We had pictures, you may have a little scrape on your arm,
Correct, but not like,
didn't go to the hospital, didn't go to the med center,
correct.
so you were tired on one, but not injured on the other.
Correct.
When you look at all the other circumstances in terms of the relative size and stature, Patrick was bigger than you, right?
Yes.
There's multiple people when you started this incident, right?
Yes.
He was stronger than you because we saw in the video that he kind of picked you up when he pushed you.
Yeah.
You didn't know he had access to weapons. There's a car there. You didn't know any weapons. He could have access to weapons, right?
He could have.
You don't know.
I don't know.
But still, with all those things, you made the decision to chase him around the car.
I did, yes.
Now, one of the things he said, they kept on saying, well, resisting arrest is a felony violation, right?
I believe they talked about that.
Yeah, there's your cross.
Yeah.
But simply committing a felony isn't enough to use deadly force, right?
Correct, no.
Ignoring your commands is not a reason to use deadly force.
No.
The only reason you can use deadly force is when you believe you're going to be killed or seriously injured, right?
Correct.
Now, in terms of that, you said when it comes down to the time you fired the shot, you can't even say that Patrick pointed the taser at you, can you?
No, he didn't get
He never pointed the taser at you.
No, he didn't
You
get
thought he might.
Correct. I felt as though he was turning towards me with
Yeah.
it. But, yeah, he didn't actually.
Didn't actually do it.
Correct.
So I just want to make sure I'm clear. I'm going to use the taser, Exhibit 23.
Yep.
When you say, okay, you said in your statement too, you said he was blocking the safety switch, right?
Yeah.
So red is when it's armed, and then that's when it's unarmed.
Correct.
So when he's down on the ground, his thumb was blocking it?
No, here, I'll show you.
Yeah,
So he was holding that more so like this.
like that.
And I could see the red.
You could see the red.
Yeah.
You're in this life or death struggle, and you could see the red?
I could.
You perceive that?
Yeah, I remember when I was fighting over it. I remember seeing essentially this formation where I could see the red in the switch, and that's basically all I could see at that time.
But then his hands like this.
Yeah.
His hands like this underneath him? It wasn't like this?
It may have been in the video, but there's time where this is the way I saw it.
Okay, so you agree that in the video, it looks like his hands on there like this, but you're saying it's like this.
Correct.
That's how you perceive it.
Well, yeah, there's parts where you can't see it.
But you're not arguing that Patrick knew how to operate a taser, are you?
I would say it'd be pretty simple to figure out.
So you think he was actually trying to hold that open?
To hold
the taser, to make it, keep it locked?
I think it's just a normal position to have your hand on it.
Okay,
I'm not saying that, yeah.
All right. So I want to go back to that. So now you say you saw the red, so you knew that it was still active.
Yeah.
I'll make sure that. So during this incident, you actually heard Wayne Butler, the resident, come out.
I remember him coming out, yep.
Well, you wrote, you heard the resident exit the house and tell Patrick to comply with commands. That's what your statement, right?
Yeah,
So you heard that. You noticed a passenger exiting the vehicle.
correct.
You didn't hear any sirens indicating more units around the way. You didn't hear anything. I think you testified to that, right?
Yeah,
You were aware of the first deployment of the taser because did you hear it and then you kind of saw it?
I did it.
You did?
Yeah,
So you know it's the fly.
yeah.
Guys, he just gonna talk through.
I want to make sure I'm clear on what he said.
Okay, so if you can
Like an
approach,
awkward way.
you can approach.
Okay, I think we left off. You were aware of the first taser deployment.
Yes,
Now you say you were aware he was holding his thumb. You saw the red. You were able to see the red on the taser when he was holding it underneath him.
yes,
Even at that late stage, you were aware the passenger was outside the car yelling at him.
from the video.
From the video?
Correct. At that point in time, I was just focused on,
Okay, we're gonna go back to your written statement.
yeah. no,
This is, well, you said
No,
from
no,
the
no.
video.
I did, yes. When I, to, as I, so I, if I can explain.
So yours,
I used the video to write the statement, is what I'm saying.
so then what you wrote isn't exactly accurate? So you're basing some of the stuff you wrote on after watching the video and you didn't really remember that is what you're saying now?
I would say I was more focused on,
Because you're clearly right, you heard the passenger in your statement, but now you're saying you.
yeah, no, I know you came out earlier. I think what you're discussing is later.
But then you're aware, you couldn't hear the sirens coming to help even at that late stage.
No,
You're aware of that, for sure.
I couldn't hear sirens.
And even at the time, when you took time to fire that fatal shot, you were aware of the background. I took a look to make sure the background was clear.
I mean, I wrote it like a police report, yeah.
But, I mean, you wrote like a police report, but
Yeah, I mean, going in
That's
that
what you wrote.
direction, yeah, to imply that, yeah.
so one of the things you can't train, you're not supposed to shoot if there's people around, you may hit somebody else. So you.
Correct. Yep.
Before you had time, you were focused, you knew that you could fire that shot because there's nobody there because you're basically looking at the ground, right?
It was gonna be in a safe direction, yeah.
At no point in time was Patrick ever on top of you.
No,
At no point in time, once again, he never said he was gonna kill you, right?
no,
Never said he was gonna hit you.
no,
Never said he was gonna kick your butt or do anything bad to you.
not that I recall, no.
This entire incident, he was trying to get away from you.
Up until the end,
Up until, well, when you were on top of him, right?
I was on top of him,
Okay.
yeah,
And he was trying to push himself up,
yes,
and you thought he was gonna turn the taser on.
that's what I believed, yes.
That's what you believed.
Yes,
But even the taser's not gonna kill you, right?
my impression is that it can cause death or serious bodily injury,
Okay. It's gonna cause death. You were tased, right?
yes,
You're still here talking to us.
yes,
You watched people in the recruit class get tased. They all survived.
they did,
In fact, there's, nobody even got hurt, right? You didn't get hurt.
I didn't,
They didn't get hurt.
no,
So it's one of those things, it's always possible, but in your experience, you've never known anybody to be killed by a taser.
I don't have personal experience with someone getting killed by a taser.
Do you have any personal experience that you've been working for Grand Rapids Police for 7 years?
Mm-hmm.
Any time where a police officer was injured, seriously injured by a taser?
Not that I'm aware of.
No police officers in Grand Rapids Police were ever killed by a taser.
Not that I'm aware of.
Once again, though, in your written statement, you didn't say you were afraid of getting shot by the taser. Didn't you tell in your written statement that you were afraid you were going to get tased and then he was going to go after your gun?
I would say I don't remember what it's in the written statement, but.
You can take a look
Yeah.
at it.
So, what is your question
The
exactly?
question was that your feeling, when you wrote this, you didn't say you thought the taser was going to kill you, you thought you were going to be incapacitated and then he was going to grab your gun, right?
I think in the written statement, I think I said that it can cause serious bodily injury or death, just the taser, the use of it by itself, but the other part of it is, yeah, it would gain him access to my firearm.
That was your main concern, he was going to access your firearm, right?
I would say both are my concern. I don't know, in that situation, I don't know where it's gonna get deployed. If it's deployed in a sensitive area, yeah,
At
it
no
could
point in
cause.
time did he ever go for your gun, did he?
No,
He never put his hand on your gun,
not that I recall.
never touched your gun.
Not that I recall.
Not that you recall, it seems like you would have. You watched the video,
Yeah,
you did a written statement.
yeah, no, I'm not. Yeah, I'm not saying.
That never happened. So the only reason he did it is because he grabbed your taser.
No,
He had
because
control of your taser.
I shot him because I believed he was gonna use it on me.
Because he had your taser.
Because I
That's the
was
only thing you did.
afraid that he was gonna use it on me.
But that's the only thing he did, was he had possession of it. He never pointed at you?
He started to turn up towards me, and I felt if I didn't respond at that time, I wouldn't be here.
Sure. And he's not here, is he?
No, he's not.
I have nothing further, Your Honor.
Mr. Dodge, you need direct?
Please. I think it was, the question was asked that Mr. Lyoya never said he was going to hurt you with the, all throughout, correct?
I believe that was a question.
Yes, and did he ever say he was going to hurt you?
I don't recall really, in the struggle, I don't recall anything. He said, I know he said things, but I don't remember what was said exactly.
But did he fight with you for almost 3 minutes?
Yeah,
Is that abnormal in your experience in police work?
yes.
What is that often indicative of?
Typically that person's trying to escape from some greater crime. That's my impression.
And Mr. Lyoya fought with you for 3 minutes, almost 3 minutes. And did he fight for possession of your taser?
Yes.
Is that, I think the prosecutor asked about something that was mentioned in your statement about, you wrote in your statement, Mr. Lyoya put his hand on the taser and pushed it away so the probes wouldn't hit him, or something along those lines.
Yeah,
Was that your reference very early on in the struggle?
yeah,
But at some point, it went from pushing to pulling, correct?
correct.
To the point that
exclusive control by Mr. Lyoya of the Taser, correct?
Correct.
This mention of a statement. Chris, is it fair to say after this episode, and even over a few years, this has been a pretty traumatic experience?
Yes.
And with no disrespect to the Lyoya family either, because obviously it's difficult for them too, but for you as well.
Yes.
And have you needed a considerable amount of assistance with your trauma?
I guess I'm gonna have to object. What's the relevance?
I'm asking him as far as what his memory is now that he's being confronted with 3 years later.
I'll overrule it for now.
Has this been difficult?
Yes.
Has your memory been, has it been difficult as far as putting it out of your head, having it back in your head, having this video thrown into the equation?
I would say so, yeah.
But back at the time of this statement, there was a lot going on prior to that statement. Is that fair to say?
It's fair to say.
And did you want to be cooperative with the state police?
I did.
And you're a police officer, you're used to writing a police report, correct?
Correct.
And based on everything going on, was it important to take a look at your video to try to make as thorough of an explanation as you could of what had taken place?
Yes.
So you did view the video just like the rest of the public viewed the video, correct?
Yes.
And you put together and tried to explain things as best as you can. Is that fair to say?
It's fair to say.
So when you're confronted with, well, you said you used a forearm, but you never said, now you don't remember using a forearm. Do you remember every detail of what happened or what might be on that video?
I don't, no.
Is that how your mind's working on this?
Yeah.
We talked about sprints and workouts. Is a physical fight different than sprints or going to the gym or even college athletics 12 years earlier, 10 years earlier?
Yeah, they're significantly different.
And really people don't know that until they've been in that type of physical combat situation.
Correct.
And did it feel different on this occasion now that you're fighting over a live weapon?
I'd say so.
As far as disengaging, generally your training, I believe it's laid out in several of the materials, are you trained to go all out to try to apprehend persons?
Yes.
And if you're not able to move it up to some other level of force if it's reasonable. Is that right?
That's correct.
And here, did you move up to a taser when nothing else was working?
Yes.
And you had done that in the past, correct?
Correct.
And it was effective?
Correct.
This topic of, were you afraid he was gonna tase you and get at your duty belt and kill you, or direct the probes or drive stun in a location? Were you trained in either manner? Were you warned in either manner to be fearful of something like that?
Yes.
And is that coming right from the manufacturer?
I believe so.
And is that coming right from general training to police officers on the realities of what can happen if somebody gets your taser and uses it on you?
Yes.
So in your mind, you're just going off of what you're trained.
You don't have to object, he's leading, he's been leading the whole time, I'm trying to give him some leeway.
I can rephrase. In your mind, are you going off of what you've been trained on the device and what may happen if somebody takes the device from you?
Yes.
Had Mr. Lyoya been able to get up on several prior occasions already, and had on occasions, had he been turning towards you?
Yes.
And at the final moment here, what was different? What did he have that was now different?
He had a dangerous weapon.
I could just have one moment here.
One more question.
So we'll follow up with that. He turned towards you on at least 2 occasions, right? At the door, the initial stop, right? You went to put his hands on you. You put his hands on him, right?
I did.
Okay, he put his hands on you, and he spun and turned, right?
Correct.
He was facing you.
Yep.
Didn't throw a punch.
Yeah, I just slapped my hand off.
Slap
yeah,
your hand.
Yeah, not. Yeah.
Get away.
Yep.
That's what he did. Slap your hand, get away.
Correct.
So the other time, so then he fell down. Or not fell down. You tackled him down.
Yes.
Picked him up, or he got up and walking with you on his back away.
Well, he was able to get up after I tackled him. There was
Mm-hmm.
some up down there, but eventually we get to that
So
point.
that was
We get to that point you're discussing.
Sure.
Yes.
But that was the only time he got up in this incident, really, right? After being
no,
knocked out.
What I just described.
Yeah.
The couple. Yep.
The one time he got up. That was the one time he got up.
No, he got up once, and then he got up again, and that's where we're up to what you're talking about. Unless you're just calling the one time before.
The tackle.
Tackle. Then he
got
got up.
He pushed himself up.
Yep.
So you're walking away. You're holding on to him.
No.
Oh, that's okay.
I tackled him. He got up.
We'll go to the video,
Yeah.
so we're all on the same page.
Yep.
That's gonna be exhibit 3, Your Honor. Can I get it right, a little closer to 216 in. Turn this.
No. Stop. Put your hands up. Stop.
So that's in number 1, that's what we're talking about. Turned away, spun around, turned away.
Okay. Yep. Yep. Yeah. No, I'm there.
Didn't punch you, didn't kick you, didn't do anything, just spun,
Correct.
gave you a little shove.
Correct. Yep.
1915. Got one running.
Yeah, we'll speed it ahead a little bit. Right.
So.
Stop!
Get your hands behind your back! Hands behind your back! Turn your hands behind your back! $19.50, time to work hard.
Okay, so now we've stood up now, right?
Yes.
He stood up, you're on his back.
Yes. I think what you're asking me was what I was trying to. I guess maybe I didn't understand the question.
That's fine, but this is-
But he had gotten up before that, is what I'm saying.
He didn't get all the way up, he started to push his way up, right? When did he, let's go to
You might need a different camera
Yep.
angle, because
Maybe.
sometimes when you're at different angles, it.
You're chasing him here. This is now exhibit 2. Tackle. So that's where you're talking about he gets up there?
Yeah,
Okay,
that's
so
what I'm
he
saying.
gets up there.
Yeah, that's,
All right, fair enough.
yep,
But once again, he gets up there, he didn't swing at you, didn't kick you.
correct.
Do anything there.
Yes.
I'm going to go, you can catch it here, so let's move back. So now here, you're standing up, and this is the other time he turns towards you, right?
Yeah,
So he
yes,
turns towards you then. Once again, he doesn't hit you,
correct. No,
doesn't kick you,
no,
doesn't throw an elbow at you,
no,
doesn't try and headbutt you.
no.
He spins around and nothing happened. He doesn't get beat. He's not aggressive at all.
I wouldn't say it's still aggressive manner. His fists are clenched. It would be perceived as we're trained as active aggression. That's
It's active aggression at this point.
yeah, which yeah, but he didn't throw a what I would constitute as a, and what you're saying as a punch or a strike or something of that
At
nature.
this point in time, he grabs the taser and moves it away by your own statement. He moves away so he doesn't get tased.
Yes.
I have nothing further.
But he may have actually been able to get up at least a few times. Is that fair to say?
It's fair to say.
Going to the moment where you ultimately use deadly force here. This individual had fought with you, and follow up to this, for approximately, did he fight with you for almost 3 minutes?
I don't remember. Yeah, somewhere around that time frame.
And I believe you've discussed already, why do individuals normally fight police to avoid capture this long?
My perception is there's got to be something pretty significant they don't want to be arrested for.
Did you know what that was at that time?
No.
Now, he got up on the other occasions and did not appear to at least strike you, is that right?
Yeah, not correct.
But on this final moment where he's getting up,
Yeah.
is that different? Is this time different?
Yeah, in my mind, it's an imminent threat of death or serious bodily injury. At that point, I'm not afforded the opportunity to wait and see what he does with it, to see what happens to me. I'm not given that opportunity.
Because do you know what his intentions are at that time?
I don't.
Do you know why he's fought that hard with you to avoid arrest?
I don't.
Do you know why he would fight that hard to take full control of a dangerous weapon?
I don't.
And as he's turning towards you, would you be expected to wait and see? I'm going to wait and see what he does with it.
I wasn't trained to do that.
No further questions.
No, Your Honor.
Hands on the knees, questions. That's all of them?
And welcome in for those who are joining us. We have been watching the testimony from Christopher Schurr in the trial against him. Right now, the reason why we're dropping in is because the jurors are able to ask questions during this trial. And when that happens, the audio is completely cut. As you know, we cannot know any other jurors at this point. And so when they ask questions, they will cut the audio and we'll soon be able to hear those questions. The judge will read those aloud. and we'll hear Schurr's response. But, you know, as we continue to watch this, we have plenty more testimony to watch. What are kind of your first reactions, Tanner, for what we've seen so far?
Yeah, so far, it really does sound like they're still honing in on the use of force. And really kind of in this last bit of testimony that we just listened to, they were going very, very in-depth to the incident itself. You know, obviously that is something I think we all expected both sides to do here, but they are really questioning about, just in that last little bit, the argument about how many times that Patrick Lyoya actually got up in this scenario. Of course, Prosecutor Chris Becker giving very direct questions about that entire incident there. And then when it went back for or a redirect from the defense team, they sort of kind of generalized. They were like, okay, so it's fair to say he got up several times, almost kind of, to me, diminishing the prosecution's questioning there a little bit, which was very interesting to see that dynamic. But in terms of the jury and what they're asking right now, and again, this is something that's happening as, you know, they muted the mics. They've asked the attorneys to come forward and approach the bench to ask them, hey, are these questions okay for us to be able to ask? Do you have any objections to these questions to be asked? And I actually have some here. So actually some of the juror questions have to do with the Taser safety switch, MSP, and how police write reports. So I believe the question specifically was for Mr. Schurr there, asking, does writing a statement or police report require you to write in the moment of an incident for accuracy or what happened? And these are all questions we're going to hear play out in real time, but just to give you a little bit of a preview of what is to come here. Some other questions have to do with what Patrick Lyoya may have been feeling in that moment in terms of maybe his alcohol intoxication, other weapons that might be in that nearby vicinity, the police reporting process, and it does sound like he was asked a question about why he shot Lyoya in the head. So these are all questions we're going to hear play out in real time here in just a few minutes. But again, it was a pretty lengthy period that we wanted to cut in and kind of give you this analysis because of those questions being asked. Again, there were 8 questions here from jurors, which is the most that we've seen so far, rightfully so, because we're talking to the defendant in the case.
And that's what I was going to mention. The jurors have been able to ask questions this whole entire trial. Up to this point, we only saw maybe 2 or 3 questions at a time from them. But again, this is really their opportunity. Schurr is sitting just inches away from them at this point. They're able to ask questions to kind of clarify the things that happened this day. And I think it's interesting that they're able to do this at this part of the trial because, as we've been saying, you know, it comes down to what he was thinking at that time, the reasons why he made those decisions. And these questions may help the jurors kind of clarify their thinking after hearing so much from the defense and prosecution, to be able to actually ask the person who was in that situation. It could help them maybe understand a little bit better.
Yeah, you were mentioning so much, right? There has been a lot of testimony here, not only just today from Christopher Schurr. He's been on the stand. He was the first witness called at 8:30 this morning, so 8, 9, 10, 11, 12. I mean, he's been on the stand for like 4 to 5 hours, and it sounds like as they take a break for lunch, which we do know that they will break for lunch shortly after these jury questions are done, we do know that the testimony will resume at 1. We can listen to the jury questions now.
On off switch, or does it need to be held in the on position?
Good question. It's called a safety switch. It's an on-off. It's like a light switch. So it was on. I switched it on. It actually is some tension. I don't know the amount of weight to turn it on or off, but once it's on, it's on. It takes actual decent amount of physical pressure to shut it off.
And next, does writing a statement or a police report require you to write in the moment of the incident or for accuracy of what happened?
I think I get what.
Is right in the moment.
Yeah, I would. All right, if I answer that, I think I know what they're. If I understand the question correctly, I feel like there's a. I guess what I've been trained to do, there's kind of a difference in some part of it. You're using the video, and then parts they have you just kind of go more or less off your memory for different various portions.
And the next question, in the beginning of the video, when the subject assaulted you prior to running away, at that time, is it okay within GRPD policy to use a taser prior to the tackle or in place of the tackle?
So that's kind of a loaded, to answer that. The strike could potentially justify under GRPD policy the use of the taser. However, using it on a subject that's running away, causing them to lock up and fall, especially around concrete vehicles, they hit their head, they could die using it or applying it in that manner, if that answers that question. So typically we're not trained to use it on someone who's running.
Well, the question asked about prior to running away, so as you
Oh,
discussed
prior,
that
well,
you were on concrete, so.
Well, I think he starts to run at that point. So
Well, the
I
question
think,
is prior, in the beginning, when the subject assaulted you prior to running away, at that time, is it okay?
oh, prior to running, actually physically running, I would say yes, but the amount of time it takes me to get my radio out, he's already running at that point, so then we're in that same situation that I was discussing, if that makes sense. The actual, I think it would be petty to deploy a taser for what he did. That, for me, that's my opinion, based on just that information.
Okay, next, did you feel at any time prior to you presenting and deploying your taser that the subject was trying to grab or obtain the taser or any other weapons on your belt?
Was the question prior to?
Did you feel at any time prior to you presenting and deploying your taser, the subject was trying to grab or obtain the taser or any other weapons on your belt?
Prior to deploying the taser, I didn't feel as though he was trying to grab any weapons.
Next, do you recall being able to smell alcohol on Mr. Lyoya during your first interactions?
No.
Next, when you say you saw the taser being held as a handgun by Lyoya, did you prioritize attempting to press on the safety or to turn the safety off or to remove the taser?
The entire goal was to get the taser back. I couldn't get it back. The only thing I could potentially get my fingertips on was the safety at that point.
I know I asked about alcohol during your first interaction, but at any point did you notice he was under the influence?
I didn't smell it or notice it in those moments. Based on his actions, I would believe it, but I wouldn't just say because of him not responding to some of the tactics automatically means that he was under the influence. So I guess the answer is no.
Next, when you write a statement or a police report, what is the process?
Depends on the report. If it's a more involved report, we'll review video as much as we can and then type it, and it might go back and forth.
Do you require running through new scenarios each time a new model taser is introduced?
You definitely do different you do scenarios when you get a new taser, for sure. However, when it might be the same scenario, when we switched to the new model, the bigger thing was the effectiveness at close range because of the design of the cartridges itself. So and we didn't have to worry. The way the cartridges were designed were better for close. We didn't have to. I don't want to get into the actual design because I can't remember the original Taser. I hardly remember the one that I used in this, but the big thing was it was more effective at close range and to train to use it in that manner.
Next is, why do you shoot Mr. Lyoya in the head?
I wouldn't say that I was necessarily aiming per se. I only had essentially a viewpoint of his upper back and head area. I deployed my handgun and fired it in that direction. It ended up hitting and striking his head.
Mr. Dodge, did you have any follow-up questions from any of those?
I do not, Your Honor.
Mr. Becker, how about you?
I'm done, Your Honor.
I don't see any other hands going. There's one hand raised on the jury.
And again, that audio has cut off once again because jurors are continuing to ask questions. I think that just shows, Tanner, that these jurors are really trying to clarify any information that they need clarified to make their decision. And some of the questions were pretty interesting.
Yeah, a couple of things with the jurors asking so many questions in this round of testimony. You have the defendant on the stand. I think it's a given that they're very curious about what his state of mind is or was on the day that this all happened. And also I think they're very curious about his account of events here. The other thing too is that we're on day 5 of this trial, and at some point, I would expect jury members to be probably more comfortable with doing that, as they have been kind of trickling in questions each and every day as the trial has began. Again, Judge Mims, the judge presiding over the case, giving them that option to be able to answer or to ask questions in this trial because, as we've learned, this is something that is unique in a way to Michigan, where judges can allow those questions in court, not so unique on other parts of the country, but very interesting that we have now, I believe we have 8 questions. I think we still have 2 more to ask right after this pause. And again, we're seeing this on a 30-minute delay, so everything you're watching happened about 30 minutes ago. So just very interesting questions from the jury, because we were actually discussing in the breaks here, in the middle of the testimony, that you can see the questions, and you can also see what may have stuck out with jury members earlier on in the week. Testimony that was done on day 1 or 2, we're seeing it tie back to some of that, specifically with the state of maybe Mr. Lyoya, his alcohol consumption during that weekend. We're seeing some of those questions resurface in the jury questions here.
And I wonder if the jurors being able to ask questions, does that make this, process for them a little bit more human? When you are sitting and listening to a defense and prosecution, writing down all these notes, trying to put everything together, to be able to ask the defendant themselves, very specific questions, I wonder if it's kind of clarifying them, but in a more human way to say, okay, this is what he was thinking. Okay, this is why I think this. So it'll be interesting to see how these questions play a role in their decision. They have so much information, but do these questions that we're hearing kind of tip them one way or the other? Because these are the questions they've been wondering about.
Yeah, we should also mention too, while all of this is going on, we know Ben Crump is in Grand Rapids. We were told moments ago that he was due to give a press conference there at the courthouse. Of course, he has been largely working with the Lyoya family during this process, and so we now have confirmation that he is in Grand Rapids at the courthouse. It sounds like we have those questions back. Let's listen in.
To my knowledge, we can just drive around and run license plates whenever we want. And to answer, just driving too slow, I guess potentially driving too slow depending on the speed limit you're in. I guess if you are exceedingly below the speed limit, yes, that is a traffic violation. That wasn't necessarily what I was stopping him for that day.
No, Your Honor, thank you. Nothing, Your Honor.
Any other questions from the jury? Doesn't look like it. So, may Mr. Schurr step down?
Yes, Your Honor. Thank you.
Thank you very much. You may step down. The next witness isn't going to take 5 minutes like I hoped, so we're going to break for lunch now. And I'm going to ask everyone as usual to leave your notes upside down in your chairs and to not discuss the case with each other or with anyone else, and still continue to avoid any news reports in the media and on social media. And what we'll do is we'll resume testimony at 1 o'clock. So that's what we'll do. Thank you. Okay, anything we need to address before we break for lunch? Since we're on the first case, I'll ask the defense first.
No, Your Honor, thank you.
Any further people?
No, Your Honor.
Okay, we'll see you after lunch.
All rise, please.
Used to the drill.
At this point, yes. Thank you. May you be seated if you'd like.
And we're going to be wrapping up the first half of day 5 in the trial. Christopher Schurr, what you're seeing right now is that the courtroom is resting for lunch. Doesn't mean the defense is resting its case, just means that they have now gone on break for lunch.
Yeah, so a couple of key bits of testimony that we heard from Christopher Schurr. Again, he's been on the stand since just after 8:30 this morning. So again, it's been a pretty long day, to say it, for those, not only Christopher Schurr, the attorneys involved here, but also the jury members who really did a great job of asking questions during this. Again, if you're just joining us, those jury members can ask questions. We heard 8 total questions, ranging from the Taser, ranging from police training, ranging to what his state of mind was during that day that this all went down in April of 2022. And of course, we also heard about what his perceived, what he perceived as Patrick Lyoya's alcohol intoxication level too. That was a question that a jury member brought up. We also saw him talk about the police reporting process and the days after that. So really, really good questions. Again, those jury questions really allow the jury the opportunity to get, I'll say, quote unquote, one-on-one time with Christopher Schurr while he's on the stand.
And I think something that's important to remember is that we had no idea that this was going to happen today. There had been a lot of questions as to whether Schurr was going to take the stand.
A lot of speculation.
A lot of speculation and anticipation, because again, this is the first time we're hearing from Schurr in the last 3 years. So it's interesting to see the defense deciding to let him take the stand, especially at the end of this week. We also saw them kind of really get into specifics, both the defense and prosecution, about what was happening that day. You know, we were able to ask the question of what was going through his mind. Well, rather, the defense was able to ask that question. And I believe that the quote that he said was, I believe if I didn't do what I did when I did it, I wouldn't have been there today. And that was something experts were really talking to us about, was trying to humanize this and put in perspective what was going through his mind. So it sounded like the defense was really trying to hone in on that.
Yeah, they were. And of course, when he was being asked questions during the direct this morning, early on in the first part of trial here, you know, a lot of that argument really the last 5 days has been about the taser in this situation and also the use of force. And of course, they talked a lot about the totality of the situation too, and how police judge what the force should be in response to the situation at hand. And of course, he had many quotes just on that taser specifically, saying, I believe he was going to use it on me, really doubling down on what the prosecution, or excuse me, the defense argument has been this entire time, even when we were speaking with some of the experts as well. So really interesting to hear from Chris Schurr. Again, like you said, this is the first time that we've been able to hear from the former officer since this all went down about 3 years ago. And again, we should also mention we're following multiple developments, not only in the courtroom, but just outside the courtroom. We know that Ben Crump is there in the courthouse, somebody who has worked very closely with the Lyoya family. I would imagine that we would hear from him today. I know that we were getting that live feedback into the newsroom, so hopefully we'll be able to play that for you here during this later half of the day.
Definitely, and we're going to have to go through all that what we've seen so far as well. You know, obviously this is one of the biggest testimonies that we have seen, but you know, jurors are going to have to take all that they have taken, all that they have heard today, and really put into perspective. You know, and really remember the crux of this trial. It's not whether or not Christopher Schurr shot Patrick Lyoya. It's whether or not he was justified. We just want to remind people, you've been watching the trial of former Grand Rapids police officer Christopher Schurr, who is charged with second-degree murder in the killing of Patrick Lyoya.
Yeah, so we have been streaming this entire trial gavel to gavel on 13+, and our coverage will continue there.
Our coverage continues now with live reports from inside and outside the courthouse, expert analysis, and the rest from the defense. Stream continuing coverage on 13+, download on your TV, and watch for free. If you're just tuning in, you're watching day 5 in the trial of former Grand Rapids police officer Christopher Schurr. Schurr is the person who is accused of killing Patrick Lyoya, and he took the stand for the first time in his own murder trial. I want to get right to Callie Lecter, who's at the courthouse right now, able to see that testimony firsthand. Callie, Riley also joining us. Ladies, talk about what did we see today?
Yeah, absolutely. I think when Christopher Schurr took to the stand this morning, it was around 8:30, right when court was starting. He was the first one to take to the stand. We've been here. This is day 5 now. We've seen countless hours of testimony, and when he was called to the stand, it was like everyone in the media room in that courthouse kind of leaned forward. We were all at the edge of our seats waiting to hear from him. This is the first time he's spoken publicly, since this case happened in 2022. So that was a really big moment in this case to see him get on that stand and ask questions personally to kind of clear up his opinions and emotions surrounding this case.
And it's one thing to hear from all the witnesses that we've heard over the past couple of days of this trial. All of them are speaking about this concept of a reasonable officer. That's really because no one can testify to what Schurr was feeling that day except for him. So that was the question we've been asking, or everyone's been asking basically for the past 3 years. When it comes to trial, after he was charged, will he take that stand? And today we got our answer. And he was able to speak to what he was feeling that day. We saw the defense during their examination kind of go through decision by decision, action by action, and then going through, what was he feeling in that moment, and was it per GRPD policy? Was it in line with that? And that's really what a lot of the defense's witnesses have been speaking to. What toll could an incident like this take on someone's body? We heard from an expert witness in exercise science and exhaustion and exertion yesterday about, the toll this could take on a reasonable officer's body. What could it be taking on Schurr's body? Now today he said, this is how I'm feeling. And we also heard a lot about GRPD policy. We heard from 2 captains and an officer who are still with GRPD about their policies and what they're trained to do, or lack of policy, and in that moment, what do they do on that? And Schurr was able to directly testify to those points. So that's kind of what we saw. And of course, there was the cross-examination by Kent County Prosecutor Chris Becker. And he was going through, that initial report that Schurr made after the incident. I believe it was, days, weeks, the timeline was kind of unclear, but around beginning of April 2022. And you kind of saw him Becker push back on that during his cross-examination.
And ladies, this is actually the first time we have heard Schurr talk about the situation. Can you walk me through some of the answers that he gave in questioning and your reaction to hearing him speak about the situation for the first time?
Absolutely. I think it was really interesting to hear from his perspective. He spoke on his exhaustion during that struggle. They went through the video moment by moment, and he said, at this point, I felt this way. At this point, I felt this way. Up until this point, we've just seen kind of the facts of the video, what's happening in it, and hearing from these experts on their opinion of what that could mean. Now we know firsthand what he was thinking in those moments. And Lauren, you brought up a really powerful quote that he had, that he basically said, if I didn't do what I had done, I don't believe I would be here today. And during that cross-examination with Kent County Prosecutor Chris Becker, he said, well, Lyoya isn't here today. And that's when he kind of rested before we had another round of cross-examination. So it's been a really emotional and powerful day in court today.
And something else that the defense brought up is, again, like we've been saying, it's been a couple of years since this incident initially happened. And so when the defense went to question Schurr again after the initial cross-examination by Becker, they were saying, how does this feel to, be talking about this again, bringing up all these old memories? And also, there was points like, do you remember every single little detail that happened? Because it's been 3 years, could a normal person remember something that happened, a minuscule detail that happened 3 years ago? So a lot of those also came into play. How much is there stored in the memory? What are kind of the main moments that are still remembered from 3 years ago?
And ladies, we're also able to hear the jurors ask questions to Schurr. What was your reaction to that? It's almost like some of the questions that they had actually lingered from the beginning of this trial.
Yeah, Callie can really speak on that. We've been talking about these questions. Some of them are really poignant, amazing questions that really get to the heart of the case. Yeah, Callie and I were just speaking on this.
Yeah, and so like I've been saying over the past couple of days, through these juror questions, again, we're seeing what viewers at home are seeing up there in the media room on the 5th floor, about 5 floors down from the courtroom. We can't see the jury, we can't hear the jury. It's to protect their anonymity. So you're really getting to know these jurors through their questions that they're asking. And a lot of these questions, you know, like you touched on, Lauren, like Riley touched on, it really shows that they've been paying attention. They need to synthesize all this information from several witnesses that they've heard over the past couple of days and, you know, make a story and make an opinion based on it. One of the questions that stood out to me, actually, I believe it was 2 separate questions, was about, you know, when Schurr was in the moment, did he know that Patrick Lyoya had, you know, a high BAC, that he would be considered, you know, by law drunk? And Schurr testified no, he could not smell anything, although some of his actions that Lyoya was doing, his decisions could you know, lead someone to believe that someone was drunk. He said at that moment he did not assume that he was intoxicated, and that was something that we heard from a bunch of these witnesses over the past couple of days, you know, that if someone is intoxicated, that pepper or OC spray will not work on them. Certain tactics will not work on them when they're in this type of situation. And so maybe a juror was asking, you know, if Schurr didn't know that Lyoya was intoxicated, could he have tried other measures? And that's kind of the core of this case right now. Was this unjustifiable or justifiable? Was pulling the trigger justifiable or unjustifiable? And Becker laid out in his opening statement, you know, he needs to prove beyond a reasonable doubt that, you know, this was unjustifiable, that there was other things that could have happened. So I think that the jurors, you know, as we're wrapping up, again, we don't know how many more witnesses there are going to be, but I think as we're wrapping up, we're getting towards the end of the trial. These jurors are just trying to piece together everything they've heard to come up with their decision, Lauren.
And ladies, you kind of both already spoke to this, but I wanted to really hone in on seeing the defense and prosecutions really hit on specific details in this situation. You saw them walking through video with Schurr, asking him, you know, what were you thinking during this? Why did you do this? Can you talk about seeing that process in this trial?
Yeah, absolutely. I think the defense right now is really trying to solidify their main point in the case, which is this phrase, totality of the circumstance. They're really trying to focus in on Schurr's exhaustion levels and whether that played into his decision making. They're trying to hone in on that, on the fear that he had in that moment. They're trying to prove that, you know, this is more than just the circumstance of, you know, he shot someone, that there were more factors at play here. So the defense is really trying to prove that. They tried to prove that yesterday through the GRPD captains who spoke on, you know, the training and what he could have been feeling in that moment. And they especially tried to prove it today with Schurr on the stand and him speaking to his fear that he was going to die through this struggle with Lyoya.
Their basis, again, they don't have to prove anything because Schurr is innocent until proven guilty. That burden falls onto the prosecution and their argument and their case. But you know, the reason why they went through minute by minute was, like you said, and what we've been saying this whole entire time, was to really break down why he made the decisions that he did. They're trying to justify what led him to every single point, because again, it needs to be unjustifiable beyond a reasonable doubt, you know, for there to be a guilty verdict by the jury. So they're trying to show that everything that he did was justifiable, it was by the books, and their basis for their argument is that, you know, he was doing everything by the books per his training, and this was self-defense. And so you had Schurr up there on the stand saying he was scared. He believed in that moment if Lyoya got a hold of his taser and used it against him, he would get his gun possibly and kill him. And you heard the statement, you know, like Riley brought up, you brought up, Lauren, you know, he wanted to make it home safe that night. He wanted to do his duty, and per what he was trained. And that's a lot of the testimony that we heard during defense questioning.
And I want to ask about the type of the atmosphere in terms of asking these questions. Before, with certain witnesses, we've kind of seen this back and forth between the defense or prosecution. I know you are watching it not in the courtroom itself, but on, you know, a stream just like us. Did you see any back and forth between the defense, prosecution, and Schurr on the stand?
Absolutely. There were some, successful objections in there when Schurr was testifying. We had, a little bit of issues over, whether the report that Schurr submitted to the Michigan State Police after the shooting was admitted in evidence. And we kind of went back and forth on that a little bit. And Kent County prosecutor said, it's in evidence, I get to use it. The judge agreed. So we've had a little bit of that back and forth over, 3 hours of testimony. That's bound to happen. But yeah, that's definitely been at play here today.
From both sides, we had some objections to relevance. What is the relevance to us all in the case? And you had the judge, there's no sides, she's an impartial figure in the courtroom. But in terms of, allowing the objections or denying the objections, there was objections allowed and denied on both sides, to use, just regular terms, not some court legalese. And so, you've had this back and forth. And again, I think it all just comes down to, you feel the atmosphere, the trial is wrapping up. This is kind of the final moments before, there may possibly be another witness called. Again, we don't know. But before those closing arguments, those closing statements, to really get the point across to where, they can talk together. Because when it comes to those, I guess you may be able to object during closing arguments. I'm not 100% certain on that, but this is really the last moment where you can object to, the other side in this case. So definitely seeing it back and forth. And again, it also just comes down to the figure of the trial. This is the trial of Christopher Schurr. He's on the stand. So of course it's going to be back and forth because he's the defendant that, the defense is trying to support and they're trying to win for, but he's the defendant that the prosecution is trying to successfully win this case against.
And ladies, I know that court will be back in session for you shortly, so we're going to let you go. We appreciate you bringing us the latest updates on this case. And throughout the trial, we've been able to talk to experts on this. We want to bring them in now. Joining me is Anastasia Marcoux, Andrew Rodenhouse, and Tanya Cross-Phelan. I just want to get straight to this testimony from Schurr. I'll start with you, Anastasia. What is your initial reaction to not only see Schurr on the stand, but his response to a lot of questions he saw today?
Well, I thought he did an excellent job establishing kind of the factual predicates he needs, the facts that he needs to get the jury instruction and to give his lawyers the ability to argue self-defense to the jury. So he did a really good job with that. I thought, how the jury reacts to his tone, to his mannerisms, that's a little bit more up in the air. I'm not sure, he didn't show a lot of emotion, and I'm not sure how that's going to play in front of the jury. But overall, he answered the questions directly. He didn't argue with either side. And I thought, overall, I thought he did a good job.
Tanya, let's bring you in. What's your reaction to seeing Schurr testify today?
I agree that I thought he did a very good job. As we were talking earlier this morning, he's in a unique position in the sense that he is an officer and he's been trained at least to be able to testify in a courtroom. He started right off by saying he's not comfortable speaking in public. But as he told the story, you could tell he was speaking somewhat professionally when he was speaking about training, about his background, and about the processes and procedures for a typical traffic stop. I also agree that he didn't fight, and he also didn't show a lot of emotion. But to that point, I think it's important because as we were also talking this morning, we were interested to see if Prosecutor Becker's cross-examination of Mr. Schurr was going to be as robust as it has been against some of the other witnesses. And in some respects it wasn't, but when it did get a little heated, if you will, I thought Mr. Schurr really held his ground. He didn't get upset. He just factually, calmly tried to answer the questions. And when he didn't understand a question that was being asked of him, he asked for clarification, or he would say, if I think you're asking this. And so he appeared to be trying to be helpful, to give answers to the question for both attorneys. So in that respect, I thought he did a very good job.
And Andrew, I want to bring you in as well. What is your reaction to seeing Schurr take the stand?
Well, I agree with what everyone said so far. I thought it was important for him to do so. I was really impressed with his demeanor. We had discussed previously, how is the prosecutor going to cross-examine him? And he came out of the gate like really aggressive, and you could tell he was trying to shake Chris Schurr to see if he could get an emotional reaction out of him. Because if he could, I mean, that would be really detrimental. That would show that maybe he's a hothead, and he didn't. And Officer Schurr didn't stop or fall for it. He remained calm. He asked clarifying questions, and eventually Mr. Becker kind of backed off from that approach and took a more traditional cross-examination approach to him. I thought that the juror questions were pretty interesting too, and maybe we can talk about that a little bit.
And that actually was my next question, was those jurors' questions. Some of them seem to be questions that maybe have been lingering for some time in this trial. What was your reaction to not only seeing, or I guess hearing those questions, but then Schurr's response to those questions?
Well, first of all, I thought he did a really good job answering the questions as directly as possible. One of the things is we can't see from here is which jurors are passing the questions. And throughout trial, if you're in the courtroom, you get kind of a sense for which jurors are asking which questions. So we're just speculating here at home or at my office. And I think that the question about, are you just allowed to go around and run license plates? And that is a very typical type of question you would get from a juror who is not informed in the ways of law enforcement. They're just lay people. They don't know how this stuff happens. And they're probably hearing it for the first time that, yeah, officers can just go around. In fact, they not only can they run plates, they actually have plate readers that do it automatically for them as they're driving around town. And that comes as a surprise to most people. And so I thought it was interesting that the way that Chris Schurr handled those questions was just to answer them directly.
And Tanya, I want to jump back to you because you talked about Schurr's response to questions being, calm, asking for clarity. I think one of the things that both you and Andrew had talked about this morning was, kind of reaching the jurors on a more human level. We heard him at one point say, if I didn't do what I did that day, I wouldn't have been here. Do you think that even though he's not overly emotional, is he kind of connecting to the jurors on a more human level with his responses?
Well, that certainly was the goal, I'm sure, to try and connect with the jury. And time will tell when the jury returns its verdict if he connected successfully with them. But one of the things, again, going back to the defense counsel, Mr. Dodge, asking right from the get-go, do you like speaking in public? And his answer was no. I think one of the things I noticed that I thought was interesting is he didn't try to overdo the eye contact with the jury. For example, expert witnesses are trained to answer almost all of their questions looking at the jury, and we saw that from most of the expert witnesses in this case. But what you noticed about Mr. Schurr is when he did answer a question, he was making direct eye contact with the person who asked the question. So during direct, he had eye contact most of the time. Once in a while, he'd look over at the jury, but for the most part, with his attorney. When Mr. Becker was asking the questions, most of his eye contact was with Mr. Becker. But notice that when the jurors asked the questions and he was answering them, he really did turn and look at the jury. And I think, to me, that came across as he was trying to let them know, look, I want to answer your questions and I want you to have the information you need to decide this case. So just in those 8 answers to those 8 questions, I think he made a valiant effort at trying to connect with the jury.
And speaking of questions, Anastasia, I want to ask you about the questioning that we saw from both the defense and prosecution. Obviously, they've been trying to build their case, and they have the person who was there that day. Do you think that the questioning was, typical? Were you surprised by anything that was questioned to Schurr today?
Actually, I was not surprised by the questioning. I think they've asked the questions that they both sides have set up throughout the trial, all about his training and about the foot pursuit was a big part of Prosecutor Becker's questioning. The question about why he shot him in the head basically was implied. Did you really need to do that? Was implied through his questioning. And I thought that they asked the questions that were consistent with both sides' points of view throughout this entire case. So I thought that both sides did what they wanted to do, is my impression of it. It's not like you're going to be able to get a witness to say, I screwed up, I shot this guy and I should be found guilty of murder. That's nothing that Prosecutor Becker is going to be able to do. But he made his points about whether or not this was really necessary. He made his points about whether he really needed to follow him, whether or not he really needed to shoot him in the head. And the defense did the same. I'm tired. I'm worn out. I'm exhausted. I thought I was going to die, and that was the themes from both sides were I thought were well presented today.
And I also wanted to ask you about those juror questions. Did anything stick out with those questions, or did anything make you say, oh, this could help the defense or hurt the prosecution, or vice versa?
I thought the fact that they were asking questions about whether or not, this is typical police practice. The questions were, some of them were about police practice. And I think they are wondering whether this is something that should be done, whether or not police should act a certain way. And I think they're really thinking about whether this is self-defense or whether or not this is somebody that's potentially been trained to do something maybe he shouldn't do. I mean, I think that's really what's going on here. And you don't want to read a lot into jury questions because it could be just one person asking the same question. It could be just a curiosity and not something that is really forefront in their mind. So I don't want to read a lot into jury questions, but I thought they were insightful that to the extent we want to know the jurors paying attention, they are. And they're asking questions that are pretty much along the themes of the trial.
And Andrew, I wanted to ask you about moving on from this. Obviously, we don't know when the defense will rest its case. It didn't rest its case before lunch. They just broke for lunch. Do you continue to have Schurr on the stand? Do you say we have one more witness? I guess, how do you go from here? Because this really was the anticipated testimony that everyone was waiting for.
Well, I think that he's testified and now it's over. My understanding is that he's been able to step down from the stand and he's not. I suppose I don't think he can be recalled for anything. He's testified, so that part is done. The big question is where is the defense going to go next, or are they going to rest? I mean, they could come back from lunch. They could do one of two things. They could start calling some character witnesses, which now that we've heard from Officer Schurr, I'm not sure that would be a good strategy, but we might hear that, or they could come back from lunch and say that the defense rests. And if they do, at that point in time, then Mr. Becker would have an opportunity to present what is known as a rebuttal case to rebut whatever the defense brought up in their defense case. And so those are really where I see that this going, is either some character witnesses, which may be unlikely, or the defense rests, because it's a pretty strategic time to do it. You've had all the building blocks. You've had all these experts testify, and then the main attraction was Chris Schurr, who says all the stuff that you need to say. And so if I had to bet all the money in my pocket, which isn't a lot, by the way, ZZM, you could pay more. But if I had to bet all the money in my pocket, I would bet that the defense rests when we come back from lunch.
And just to clarify, we are not paying Andrew. Andrew, if I could give you $1 or $2, I would, but I cannot do that. Tanya, I also want to bring you in about the process of a trial like this. We've seen a full week of testimonies and objections and motions. Are we still on pace for this type of trial? Or do you expect this to go longer? For people who are watching, what can you kind of help them kind of understand of where we are in this trial?
Well, every case is different, certainly, and some cases take much longer than others. And so I don't want the audience to think that there's a normal pace for certain kinds of cases. But generally speaking, from what we've witnessed so far, it appears that the prosecutor accomplished what he wanted to in his case in chief with the number of witnesses he identified that he would call. And the defense, although they had cited the potential of calling 40 witnesses, they've gone through several over the last couple of days. And I think in most situations in self-defense trials, the defendant usually is the last person to testify. So it will be interesting to see what the defense does after the lunch break, whether they call any other more witnesses or not. And to the point of the prosecutor's rebuttal case, if we go right to the prosecutor's rebuttal case, Usually it's not long. The prosecutors are usually very strategic in what witnesses they bring in, and they're limited to only being able to rebut specific points they think the defense made during their case. So, this might get to the jury yet today, but I don't know. I'm thinking that probably we will see the prosecutor's rebuttal case yet today, or at least part of it, and then move to closings and instructions perhaps on Monday. But again, that's assuming that there aren't a lot of other defense witnesses that they want to call in.
And let's assume that we are able to hear closing arguments. Is there any risk of having closing arguments today and the jury start deliberating either later today on Monday? Does it give them time to think about it? I just wonder, that weekend gap, does that play a factor in this trial?
Well, it cuts both ways, and you can ask 10 different defense attorneys and 10 different prosecutors, and they'll give you different answers. In many ways, it's good to go right into closing arguments, because one of the goals of a closing argument is for the lawyer to give the jury the perspective of what all the evidence means in the case, and why the evidence supports the verdict they're asking the jury to deliver. So then they have that right after the end of the case, and it helps them kind of put things in perspective as they start thinking about the case. And your question is, if we don't do closing arguments until next week, does it give them time to start thinking on their own about things without the benefit of the lawyer's closing arguments? And the answer is yes. So it's always something that trial lawyers grapple with, of the timing of closing arguments.
And Anastasia, I want to ask you, because while the defense has not rested its case yet, when the prosecution did, we quickly saw the defense put in motions for a mistrial or for a directed verdict. Can the prosecution do that, or do they have to go to that rebuttal situation that Tanya was talking about?
The prosecutor cannot move for a directed verdict in a jury trial. The only body that can decide guilt or innocence in this case is the jury. They cannot move for a directed verdict because they're the prosecutor. So they're either going to bring in rebuttal, or we're going to closings. There still is the question, like Andrew said, about whether or not the defense is going to bring in other witnesses. And like Tanya said, it's possible that they were waiting for Mr. Schurr to testify before they brought in character witnesses about his truthfulness and honesty, and then kind of humanize him. Maybe that's what they want to end on. But I think we're really close to the end here. And Tanya's right and Andrew's right that rebuttal here is going to be fairly limited. So we're either going to get maybe to the end of the proofs today and closing next week, or they may go to closings this afternoon. I think it's more likely closings will be next week.
My final question to all of you is, what are you expecting to see next? What are you maybe excited for? What are your final thoughts as we move into possibly the end of this trial? I'll start with you, Anastasia.
One of the things that's going to be a curiosity is whether or not the judge down the road instructs the jury on voluntary manslaughter. I think the judge probably has to at this stage, because it's something called necessarily lesser included offense of murder. What that means is voluntary manslaughter kind of is under the umbrella of murder, and if there's any evidence of Mr. Schurr acting in a heat of passion, out of high intensity, out of high emotion, and then the judge might instruct on that even over the objection of both parties. The judge could potentially do that. So that's going to be an interesting issue. And then for me, because I love the law and the concepts of self-defense, I'm going to be curious about how the judge instructs on certain elements of self-defense, like duty to retreat and whether or not necessity is required. A lot of different things that are going to come into play when this judge instructs the jury. The closings, we know what the closings are going to be. We've heard their arguments through their cross-examination and through their openings. I'm really interested to see what the judge does and how she instructs the jury down the road.
I just want to ask quickly about that voluntary manslaughter, because again, I'm not a legal expert, so anything you guys throw out to us, we just want clarification. If she does bring that up, does that mean the second-degree murder charge is thrown out? Does that mean there's, a different time of how long he could, if convicted, spend time in jail? I guess, how does that change things for the outcome if the decision is made one way or the other?
The jury is instructed they're supposed to start with the most serious charge and decide whether the person is guilty or not, and that would be second-degree murder. Then they're supposed to go to the next charge. That's what they're instructed to do. And the next charge underneath that umbrella is voluntary manslaughter. That's considered a less serious crime. Punishment, yes, it just carries less severe punishment if convicted of that. So that's kind of the procedure. And through all of that, they're supposed to consider whether or not self-defense applies to both of those. So self-defense is a complete defense, complete justification for both voluntary manslaughter and second-degree murder.
Okay, and Tanya, I want to bring you in as well. What are you looking forward to for the rest of this trial?
Well, from a legal perspective, he stole all my answers. However, one of the things that we've been talking about through this whole trial, the law geek in me loves to watch the strategy of how the parties put their cases together. And all of this, a trial is about telling the jury the story of what happened in this case. And so although we have a good idea of what the lawyers will argue in closing argument, from a skills and style standpoint, I'm very curious to see how they put together the story of what happened in the closing argument in the context of the law and the facts that we've heard them, and how they weave the evidence that has been presented both visually, tactily, and through testimony into their closing arguments. It's going to be fascinating to listen to that.
And finally, we have to bring in Andrew Rodenhouse. Andrew, you, I think, are 2 for 1 at this point in predicting or suggesting what could happen. What do you think you're looking forward to as the trial continues?
I am looking forward to finding out, and we're going to find out here real shortly, on whether or not the defense is done, or if they're going to call more witnesses, and who they're going to call if they call more witnesses. Kind of throughout this whole trial, the defense has done a really good job of putting down the building blocks, the foundation to bring in the next witness, to bring in the next witness, to bring in the next witness. And we all assume that it's going to culminate with Chris Schurr, because that's, as trial attorneys, that's normally how it goes. But in this isn't a normal case, and so we could. But I'm just looking forward to seeing who they might call. I mean, it's possible. Call his wife. Like, what kind of a person is he? What kind of a husband is he? Is he a caring individual? And have her maybe shed a few tears on the witness stand about how much she would have missed him. And so I don't know. I'm kind of sitting on the edge of my seat like the rest of you. Again, if they rest, then it will be a short rebuttal, possibly arguments today. As an attorney, as my personal preference, would be, if we're this close to the end, to just go ahead and give the closing statement and have everyone go home, so that I'm done and I don't have to worry about it over the weekend. Come back Monday, sit through the judge's instructions, because that's just, as an attorney, we've already worked it out. So we're just sitting there listening to the judge read it. The jurors will be paying attention, at least hopefully, but that'll be an interesting part for them. But as the lawyers, that's kind of boring for us to sit through. And so my personal preference would be to, if I can make the closing arguments today, make the closing arguments today.
Well, we'll have to see what plays out. Tanya, Anastasia, Andrew, thank you so much for joining us again today. Prominent civil rights attorney Ben Crump is at the courthouse today, seemingly there watching the Christopher Schurr trial. Crump is representing the Lyoya family in their civil suit against the city of Grand Rapids, along with attorney Ven Johnson. 13 on your side's Josh Albertus heard from Crump today earlier at the courthouse. He joins us live now. Josh, what did you hear today?
Yeah, Crump spoke to reporters just after this lunch break was called earlier. Before we get into it, he was there with a few of the Lyoya family members as well. I just want to play for you the full remarks there so you can see what he said before we kind of get into it. Take a look at what Crump had to say.
I'm attorney Ben Crump, along with attorney Ven Johnson, attorney Ayanna Hatchett, and our legal teams. We have the honor of representing the family of Patrick Lyoya. We have his mother, father, Peter and Dorcas, as well as his other family members, the mothers of his children, gathered here at this moment during this trial, where the police officer that killed him, what they believe is absolutely a case of driving while black. They thought it was important, since so much is going on in America, to remind everybody to watch the video of the killing of Patrick Lyoya. The truth is in the video. They don't understand a lot of things that are happening. They don't understand many of the court procedures, but they know what they see with their own eyes. And they know that in their heart, this was an unjustified, unnecessary, unconstitutional killing of yet again another unarmed black man. It is so important that you look at the video, you look at the actions of Patrick, always trying to get away, never posing any kind of aggressive action towards the officer. The whole time he's trying to go away. So this family continues to ask for your prayers, for justice. They continue to ask for your prayers for healing. They continue to ask for your prayers for his children. They continue to ask for the prayers for the community to heal. They have continued to ask that people stand with them, but people stand with them in a responsible, peaceful manner. This is one of the things that is so troubling to many people across America. You have videos showing these killings, but so often, as we come up on the 5-year anniversary of the killing of George Floyd, you see there still isn't accountability when police kill black people. And that remains a persistent issue in the United States of America. Thank you.
Can I ask what's your take on the Christopher Schurr's testimony today? You heard what he had to say.
We're praying for justice. The family believes that nothing justifies him shooting Patrick Lyoya in the back of his head. It, at most, was a traffic stop. That should not equal a death sentence.
And what should happen to the officer?
Thank you. He should be held accountable. The same thing that would happen if it was your child. What would you want? That's what his family wants. If that was your child, what would you want? That's what this family wants. That's what our community wants. Nothing more, nothing less. If it's your child, what would you seek? Thank you.
And that point you heard there about what they feel has been shown through this trial, Lyoya in their view always trying to get away during the incident. Just interesting to note that because that same thing seems central to what you heard from the prosecution as they were doing their cross-examination of Schurr this morning. You know, it seemed like the prosecution were trying to establish that Lyoya was trying to escape, trying to not get tased, but that there was no action-based indication that he wanted to actually attack Schurr. But of course, Schurr kind of indicating on the other side, you know, in his own defense that it wasn't his training to wait and see what Lyoya would have done if he indeed did get a hold of the taser, Lauren.
And Josh, I want to ask about the emotion there. We saw Crump get a little, not feisty, but just emotional, talking about if that was someone else's child, what they would have done. Talk about the feeling in the room right there.
Well, you may have noticed there, Lauren, Crump was the only one speaking. I mean, there were family members there, but they were completely, they were silent. I mean, we've seen a lot of emotion, especially outside the court when it comes to this case. And, you know, people talking about, you know, how this family may have to be, you know, reliving that moment through the video over and over. So they were completely silent. I mean, honestly, if there was any kind of feeling from that, I'd say it's, you know, it's somber, it's it's solemn as they wait for the rest of this case to play out, is how it seemed to me in that moment. But, you know, he did hear there, he was kind of speaking for the family a little bit when he said, you know, the family is praying for kind of what he said here. Let me check my notes. Family was continuing to pray for justice and healing. And so, you know, but they had nothing to say, and that is probably, I guess, is probably going to be the case at least until this case wraps up. But it was just definitely a solemn feeling as they did not have anything to say at this point.
And Josh, I just quickly want to ask about just supporters, just in general outside. I know that you've been in the courthouse most of the day, but you've been able to walk in and out. Earlier, we did see some people supporting. Are there people still out there, or have they started to linger away?
Well, actually, Jeremy, my cameraman, if he wouldn't mind pointing over there, you can actually see there is still kind of a crowd over there right now. There are both Schurr supporters and people who have been chanting to the streets, you know, justice for Patrick. So we are still seeing quite a fair bit of people compared to the rest of the week at this point, especially as, you know, we have been reporting the news, of course, that, you know, Schurr had taken the stand. And so it's possible that we may see closing arguments soon. It may be wrapping up soon. So, you know, whether or not this kind of crowd size increases or reaction increases, we'll have to wait and see. But certainly there is still a presence on either side out here, Lauren.
Well, Josh, we appreciate you reporting, and we will be checking with you later on. Thanks, Josh. And like we've been talking about, today marks the first time in 3 years that Schurr has spoken directly about this incident. We want to take a moment to bring you back to the day of the incident and what happened to bring us to this moment.
8:11 a.m., April 4th, 2022.
1915.
A Grand Rapids police officer pulls over a tan Nissan Altima near the intersection of Griggs and Nelson Southeast on the city's southeast side.
Hey, stay in the car! Stay in the car!
Patrick Lyoya, a 26-year-old refugee from the Congo, exits the vehicle, disregarding commands from 31-year-old Officer Christopher Schurr, a 7-year veteran of the force, to remain inside the car.
You have a driver's license. Do you speak English? No. Stop.
Almost immediately, a struggle begins that lasts nearly 3 minutes and ends when Officer Schurr shoots Lyoya in the back of the head.
Drop Taser!
That same day, the investigation is turned over to Michigan State Police, and city leaders gather to tell the public what has happened.
This is indeed a really difficult day for our city, and my prayers go out to everyone impacted by today's tragic incident.
A little more than a week later, on April 13th, dash cam, body cam, and cell phone video shot by the passenger in Lyoya's car is released to the public.
Stop grabbing him like that.
No!
No, he good like for real. Yo, you hit him too.
But for many, it is not enough.
Our streets!
Frustrated, people take to the streets demanding their voices be heard. On April 22nd, nearly 3 weeks after his death, Patrick Lyoya is laid to rest with family, community members, and civil rights leaders attending.
In Grand Rapids, we have to play our part now.
Fast forward to April 27th.
Let him speak and stop disrupting this meeting.
Commission meetings are packed with community members demanding the officer's name be released and that he be charged. After weeks of public pressure, Chief Eric Windstrom, just over a month into his new role as chief, publicly identifies Christopher Schurr as the officer involved in Patrick Lyoya's death. Christopher Schurr is later charged with second-degree murder on June 9th and fired from the force 1 week later. In December, the Lyoya family files an excessive force lawsuit against the city of Grand Rapids and the police department.
And like we've been talking about, this is the first time we've been able to hear from Schurr since all this started. And while Schurr was on the stand, he made a definitive statement as to what he did to stop the struggle between him and Lyoya and why he did it. Take a listen.
What have you been trained going all the way back to the MCLS Academy as far as action versus reaction? What have you been trained?
That action beats reaction.
And what does that mean here in that scenario for you?
If I had waited for him to point it at me, it would have been too late.
And what were you fearful of?
that he was going to use it on me and I was going to die.
Now, and you were in a proximity to each other that he could do that to you?
Yes.
With how you've been trained about that device?
Yes.
Under your training, Chris, are you required to wait to be seriously injured or killed before you can resort to deadly force?
No.
So what did you do next?
I shot him.
Why?
I believe that if I hadn't done it at that time, I wasn't going to go home.
And Schurr had a lot to cover during his testimony and answered questions from the defense about GRPD's use of deadly force and their policy. Take a listen.
What level of force is firearm deployment upon a human?
Deadly force.
And in GRPD, do they take you through scenarios and situations that police might encounter as is exhibited on the video there?
They do.
The same scenarios as LCC, or do they go through quite a few more?
Definitely a lot more. LCC, you're more or less laying the groundwork and probably more book work and not as many scenarios. I felt as though Grand Rapids, we did more scenarios.
How many, roughly?
Probably thousands.
We saw just a sampling on the video of some of those scenarios.
Yes.
Now, as you're instructed on those scenarios, are you trained that there's only one way to effectively perform a task?
No.
Basically, what are they showing you there?
Essentially, there's a parameter, if you will, to handle it. There's definitely preferred ways, but there's definitely no person is the same. So the way I handle something is going to be different than what someone else handles something.
Now, does the GRPD Academy, similar to MCOs, do they try to expose you to some of the limitations that an officer may expose out in real life?
Yes.
Do they discuss topics like human reaction time?
Yes.
And Schurr also explained some of the videos we have seen throughout the trial, including one of him being tased as well as practicing with one. Take a listen to that.
Taser, taser, taser.
How'd that feel?
Terrible.
What did it feel like?
Just essentially your muscles contract involuntary to their max capacity, and it's extremely excruciating pain.
Now, can you compare it to anything else that you'd ever experienced?
No.
Have you ever felt like anything like that before in your life?
No.
Now, after having felt the effects of the taser, would you volunteer to do it again?
No.
But prior to being tased there, did the master taser instructor give you some instructions on what was going to happen?
Yes.
What did they tell you?
They did a couple different deployments and varying spread, and he let me know how he was going to deploy it on me.
Okay.
And where.
I'm sorry, where?
Yeah.
And does that help at all with any angst that you may have?
Probably alleviated some.
Now, when you were tased there, did you feel like you had much control over your body?
No.
And we've heard this term, I think, sometimes, taking the ride. Is that what they refer to it as, is when you're under the effects of the taser?
Yes.
How long does that ride last?
5 seconds.
Do you feel during that 5 seconds that you have the ability to defend yourself?
No.
What are you trained that can mean for a police officer in the field if someone fights them for their taser and uses it on them?
They would get access to our firearm.
Now, in police training, do you discuss topics like that? Officers getting disarmed of their weapons?
Yes.
Generally, what are you trained to presume if a subject forcefully disarms an officer of their weapon?
They would use it on us.
And Schurr continued his testimony recounting details from his initial traffic stop and why he began a foot pursuit. Take a listen.
So you asked the driver for their driver's license, and what was his response?
He patted one of his pockets, I believe, initially when I asked for it, and then wanted to say that he said it was in the car, and I told him to get it.
Okay. Now, what did you do during this? What did you do at this point?
Well, I told him to get the license,
Mhm.
at which point he asked the front seat passenger for the license, and I just kind of take a step back and observe that the front seat passenger appears as though he opens the glove box and shuts it without providing any type of license to the driver.
Based on your 7 years of police experience, what are you sensing at this point?
At that point, I'm sensing he doesn't have a license.
Okay. So what happens next?
The driver shuts the door and begins to walk away from me.
And when can a driver just walk away from a police officer in this situation?
No.
Based on your experience and the circumstances that had transpired thus far, what are you feeling at this point?
Well, your stress level definitely goes up. You're going to end up going hands-on with the person. So it's a pretty stressful situation. It starts to raise your heart rate a little bit, if you will.
So what do you do next?
I grab onto him,
Okay.
tell him to put his hands on his head.
Why?
I just wanted to place him under arrest.
Okay. Had he committed violations that were arrestable offenses?
Yes.
What happens when you place hands on him?
He spins towards me and shoves me away.
Now, in your experience, when you go to place individuals under arrest, do they always want to be arrested?
I would say typically people don't want to be arrested.
But is one of your essential job functions, going all the way back to the MCOLS Academy, that you may need to effectuate arrest by using some level of force?
Yes.
Is that what you were attempting to do here?
Yes.
I believe you mentioned that the driver pushed you. Is that right?
Yes.
Was there anything else during this initial skirmish that you took as any types of aggression?
His fists were clenched.
And what does that mean if someone's fists are balled up to you?
Could lead to a physical assault on me.
So at this point, did this turn into somewhat of a tussle already initially?
It did, yes.
Under Michigan law, is it a violation, a felony violation to assault and resist a police officer?
It is.
So now what happens?
He proceeds to run away from me.
Does he get very far from you?
No, not really.
So what do you initially do?
Initially, I got on the radio just to let dispatch know that I had someone running to elicit emergency response.
What does emergency response mean?
Essentially, people will start driving with lights and sirens activated and exceeding the speed limit, in hopes to get people there quickly.
In your, maybe it was 5 years or so working in that area, when you send out a message for an emergency response, what is your normal expectation of having other officers show up on scene?
Well, I think one of the big things is that area is pretty well confined, and it's not like we're working in the city, so we have officers in a small area, if you will. Typically, when you say that over the air, you can hear the sirens just saying something like that on the radio, and I don't recall hearing them at that time. But also, I mean, cars typically get there within a minute or two.
Okay. Now, was the driver, as he started trotting away, was he moving very fast?
No.
On April 4, were you in overall good physical condition?
Yes.
And going back all the way to the MCOLS Academy, are you trained that you may need to get into foot chases?
Yes.
And are you trained that you need to often run into very volatile and unknown situations?
Yes.
Based on your experience working in the service area of Grand Rapids, why do individuals often run from police?
My experience has been that when people run, it's typically for some type of felony offense associated with what they're doing.
So, does any foot chase then, is there always some type of risk or perhaps danger to an officer in a foot chase?
Yes.
Is there a policy advising officers that they cannot foot chase?
No.
And during the struggle between the two, you can hear throughout the video that Schurr's taser went off twice. He was asked about the second deployment during his testimony. Take a listen to what he had to say about that.
Let go of the taser! Let go of the taser!
Please turn the light back on. Does it sound pretty chaotic right there?
Yeah.
And can you hear your breathing?
Yes.
Has it improved at all?
No.
And we've heard this talk in this time frame about a second cartridge. At some point in the struggle, did you ever notice that the taser deployed a second time?
No.
Does it sound like you're panting for air in that moment?
Yes.
And as you watch the videos now, or the cell cam video now, are there other things going around you as well that you don't remember?
Yes.
And do you remember what people were saying around you at this moment?
No.
But after the fact now, you've seen this video many times, correct?
That's correct.
And have you heard this assertion that the taser was deployed a second time?
Yes.
But Chris, as you watch this video, okay, the cell cam video of the passenger, from the moment that we can now see the taser was deployed, do you fight, after that, do you fight any less effort into trying to get the taser back after that?
No.
Why is that?
I'm afraid he's going to use it on me.
And finally, Kent County Prosecutor Chris Becker began his cross-examination. Confronting Schurr with Schurr's own report on the incident had contradictions to his testimony. Take a listen.
Okay, I think we left off. You were aware of the first taser deployment.
Yes.
Now you say you're aware he was holding his thumb. You saw the red. You were able to see the red on the taser when he was holding it underneath him.
Yes.
You, even at that late stage, you were aware the passenger was outside the car yelling at him.
From the video.
From the video?
Correct. At that point in time, I was just focused on.
Okay, gonna go back to your written statement.
Yeah.
This is, well, you said
No,
from
no,
the
no.
video.
I did. Yes. If I can explain.
So yours.
I used the video to write the statement. Is what I'm saying.
So then what you wrote isn't exactly accurate. So you're basing some of the stuff you wrote on after watching the video, and you didn't really remember that, is what you're saying now?
I would say I was more focused on.
Because you're clearly right. You heard the passenger in your statement, but now you're saying you.
Yeah. No. I know you came out earlier. I think what you're discussing is later.
But then you're aware you couldn't hear the sirens coming to help even at that late stage.
No.
You were aware of that for sure.
I couldn't hear sirens.
And even at the time when you took time to fire that fatal shot, you were aware of the background. I took a look to make sure the background was clear.
I wrote it like a police report. Yeah.
But, I mean, wrote like a police report, but.
Yeah, I mean, going in that direction, yeah, to imply that, yeah.
So one of the things you can't train, you're not supposed to shoot if there's people around, you may hit somebody else. So you
Correct. Yep.
Before you had time, you were focused, you knew that you could fire that shot because there's nobody there because you're basically looking at the ground, right?
It was going to be in a safe direction, yeah.
At no time, at no point in time was Patrick ever on top of you.
No.
At no point in time, once again, he never said he was going to kill you, right?
No.
Never said he was going to hit you.
No.
Never said he was going to kick your butt or do anything bad to you.
Not that I recall, no.
This entire incident, he was trying to get away from you.
Up until the end.
Up until, well, when you were on top of him, right?
I was on top of him,
Okay.
yeah.
And he was trying to push himself up.
Yes.
And you thought he was going to turn the taser on.
That's what I believed, yes.
That's what you believed.
Yes.
But even the taser's not going to kill you, right?
My impression is that it can cause death or serious bodily injury.
Okay. It's going to cause death. You were tased, right?
Yes.
You're still here talking to us.
Yes.
You watch people in the recruit class get tased. They all survived.
They did.
In fact, there's, nobody even got hurt, right? You didn't get hurt.
I didn't.
They didn't get hurt.
No.
So it's one of those things, it's always possible, but in your experience, you've never known anybody to be killed by a taser.
I don't have personal experience with someone getting killed by a taser.
Do you have any personal experience that you've been working for Grand Rapids Police for 7 years?
Mm-hmm.
Any time where a police officer was injured, seriously injured by a taser?
Not that I'm aware of.
No police officers in Grand Rapids Police were killed by a taser.
Not that I'm aware of.
Once again, though, in your written statement, you didn't say you were afraid of getting shot by the taser. Didn't you tell in your written statement that you were afraid you were going to get tased and then he was going to go after your gun?
I would say I don't remember what it's in the written statement, but.
You can take a look
Yeah.
at it.
So, what is your question
The
exactly?
question was that your feeling, when you wrote this, you didn't say you thought the taser was going to kill you, you thought you were going to be incapacitated and then he was going to grab your gun, right?
I think in the written statement, I think I said that it can cause serious bodily injury or death, just the taser, the use of it by itself, but the other part of it is, yeah, it would gain him access to my firearm.
That was your main concern, he was going to get access to your firearm, right?
I would say both are my concern. I don't know, in that situation, I don't know where it's gonna get deployed. If it's deployed in a sensitive area, yeah,
At
it
no
could
point in
cause.
time did he ever go for your gun, did he?
No,
He never put his hand on your gun.
not that I recall.
Never touched your gun.
Not that I recall.
Not that you recall, it seems like you would have. You watched the video,
Yeah,
you did a written statement.
yeah, no, I'm not. Yeah, I'm not saying.
That never happened. So the only reason he did it is because he grabbed your taser.
No,
He had
because
control of your taser.
I shot him because I believed he was gonna use it on me.
Because he had your taser.
Because I
That's the
was
only thing you did.
afraid that he was gonna use it on
But
me.
that's the only thing he did with it. He had possession of it. He never pointed at you?
He started to turn up towards me, and I felt if I didn't respond at that time, I wouldn't be here.
Sure. And he's not here, is he?
No, he's not.
I have nothing further, Your Honor.
And like we've mentioned before, we are on a 30-minute delay. We're able to jump back to the proceedings that happened 30 minutes ago. Let's take a listen into a new witness taking the stand.
I do.
Thank you. You may be seated.
Thank you. Pour myself some water real quick. I'm parched.
I'm sorry, Your Honor. Did you
Say whenever you're ready.
Good afternoon, Dr. Blake.
Good afternoon.
Can you please tell us what your current profession is?
Sure. I'm a police practices and human factors consultant. Have done some training in the past. I have my own company called Blake Consulting and Training. actually should probably cut that training portion off. I don't do that as much anymore, but I do most of my time is focused on consulting in cases like this.
And now when you say police practices, what do you mean?
Police practices ranges everything that police officers do, from search and seizure to the use of force and everything in between, traffic stops, everything that police officers do. So that's what I look at. That's what I technically investigate in these type of cases, and they ultimately are what I opine upon as an end result in certain cases. In others, I focus on the human factors aspect specific to policing and critical incidents.
What are human factors?
Human factors, interesting area of looking at performance. So human factors essentially, succinctly, is kind of looking at human capabilities and limitations within a system. So we've got the capabilities and limitations of an individual person, human being. When I talk about system, I'm talking about the organizational system that those people perform within in any given situation. So it could be a nurse in a surgery center. It could be a pharmacist. It could be a mining operation. It could be a policing situation, which is where my focus is. But human factors is focused in a wide range of areas. It has all types of different specialty areas, scientists, researchers, people with varying degrees in different areas such as psychology primarily, and also engineering. Now, I'm clearly not on the engineering side, I'm on the psychology side. So I'm focused on that area.
All right, let's start with your background in police practices. Were you ever a law enforcement officer?
I was a law enforcement officer for about 14 years.
Tell us about your law enforcement experience.
So after I got out of the military, I joined the Department of Energy as a security police officer at Lawrence Livermore Labs in California. That job it's a law enforcement job. We were granted limited powers of arrest and we carried firearms. A little bit different job though. Our primary focus was the safety and security of the installation and the people. And as I was there, I joined what's called a special response team. And their responsibility is kind of a quasi counterterrorism because those labs have certain materials that need to be protected. So our primary task in that area was the recapture and recovery of special nuclear material is what it's called. And, I stopped there. After that, I did a couple years there, and then I went on to the San Francisco Bay Area Rapid Transit Police Department, obviously in San Francisco, California, and the surrounding areas. Obviously went to a police academy, a state police academy for that. Worked there for several years on patrol in several different jurisdictions. It covered a lot of geographical areas. And then from there, I went on to the Livermore Police Department, where I spent the majority of my sworn law enforcement career. Did a lot of tasks and duties there that are typical with law enforcement. I worked patrol, SWAT, did gangs, narcotics, was a field training officer, a lot of the things that you've heard from a lot of witnesses so far. After my time there, I went on to, I actually got injured on the job and ended up not being able to return. I wanted to stay in law enforcement, so I ended up going to what's called the Alameda County Sheriff's Department, which is near where Livermore was. Ended up working there in their regional training center as a civilian trainer, and I focused there on use of force in the force option simulator program that they had there. And I think you've heard some information about that from Mr. Bartell yesterday, but that's that simulator with the video and the ability to use replica weapons that have lasers on them and interact with the screen. Very interesting job for me, because during that time I was moving through the education process. I've always been interested in this area of human factors, but especially applied to policing. But as I was able to do that job, I was able to watch performance in simulated situations. And I would see what happens to people when they operate under stress. I would see when we would debrief them after a scenario, maybe what they didn't remember, what they didn't perceive, or they misperceived. So I was able to kind of apply that scholar practitioner kind of hat in being able to not only have an academic basis, but I was also just observing for that information as I was going through these scenarios. And then after that, that's when I left law enforcement as being employed in any fashion.
Do you hold any law enforcement instructor certifications? You could just list them.
Yeah, sure. The law enforcement instructor certifications included, I'm a firearms instructor. These are California Post certified. So it's the equivalent of MCOLs. You've heard that terminology. We have that same thing in California. So they certified people to be firearms instructor, which I was. Force options simulator, which I did. I was an instructor in reality-based training. That was through a separate company. I was a field training officer, so that's an instructor certification. There's more, but I keep forgetting them.
It's okay, we can move on.
Yes.
Have you attended any use of force or officer-involved shooting trainings?
Yes, and I'm hoping to get this out. It's the Robert S. Presley Institute of Criminal Investigations Officer-Involved Shooting Investigator course. That's provided through CalPost. That's the only officer-involved shooting class, but I've had other training in the area.
Do you maintain memberships in criminal justice-related organizations?
I do, several. Academy of Criminal Justice Science, which is more on the academic side. So that's an organization that looks at what's going on in policing. They conduct a lot of research and publish journals associated with that. So I keep current through that. I'm also a member of the International Association of Chiefs of Police. Also, the Association of Force Investigators, which is a kind of a national organization focused on looking at use of force. And then lastly, the California Force Instructors Association, which is state specific, but we have some international international folks that are members. And again, we're focused on training trends and training information in police use of force.
Have you ever taught criminal justice at any higher institutions?
I have. I was a criminal justice professor at 2 community colleges. Basically taught intro to criminal justice courses, and also in those positions I actually also functioned, because those community colleges there, like here, oversee police academies. So by being hired as an adjunct criminal justice professor, I had a dual ability to teach in the police academy there, which I did.
Okay, and have you taught police officers about safety and tactics, police procedures, or use of force and officer-involved shootings? Have you done all those and shared your education with members in the field?
Yes.
Okay. All right, now I called you doctor. You're not a medical doctor.
No, don't like
Okay,
that confusion.
but you have a doctorate and you have a master's. Please tell the jury what your master's is in and your doctorate.
So my master's degree is in psychology. I did a thesis focused on police use of force. So the actual research project was looking at decision-making and reaction time in fatigued and non-fatigued states, basically. So that research project had to be completed in order to get the master's degree. And then my doctoral degree is in performance psychology. Again, focused a lot of my research during that time, focused on police critical incidents, police use of force. My doctoral dissertation was an application of what's called the human factors analysis and classification system to law enforcement shootings. And that was, again, a little bit over a year-long research project. Did a lot of interviews and a lot of digging into archival data to complete that project in order to get the doctorate.
Okay. Now, you've heard some of the testimony in this case.
I believe I heard almost all of it.
Okay, and we heard from Dr. Kroll yesterday.
Yes, sir.
Okay. He talked about peer-reviewed articles. I'm not going to go through what that means, but do you have any peer-reviewed articles that are related to your field of study?
I do. I have 9, I think the total is right now. I published the one master's degree thesis project in a peer-reviewed journal, done some research on firearms reaction time, some case studies on police shootings, and looked at force option simulators. As a lot of research has been done, so we did basically a systematic review to look at how those things, what research has been conducted and where we need to go in the future and what's been found up to this point.
Okay, and do you maintain any memberships related to human factors?
I do. I'm a member of the Human Factors and Ergonomics Society, which is an international organization that's focused on that area of science. They also publish 2 journals that I also receive through them. And then I'm also a member of the Human Factors and Ergonomics Society Forensic Professionals Technical Group. Now that's the portion, the arm or branch of Human Factors and Ergonomics Society that focuses on kind of what we're doing here, looking at and investigating incidents and accidents in different fields, applying human factors, and ultimately maybe ending up in a courtroom like this.
Have you taught human factors to law enforcement officers or executives, attorneys, others in the field?
Yes, I have. After I left, well, actually kind of overlapping with my tenure at the Alameda County Sheriff's Department, I also was a kind of subcontracted to a company called Human Performance Training Institute. And there we did teach a course across the nation that looked at all these human performance factors. We went through some of the science. We talked about and taught the application of the science to these type of incidents, use of force incidents, to include officer-involved shootings.
Okay, and then you said you were a consultant, you have a consulting company. Can you name some of the organizations that you've consulted for in relation to police practices and human factors?
Yes, I've consulted with the California Department of Justice, the United States Department of Justice. I've consulted with the ACLU, American Civil Liberties Union. I've consulted with several prosecutors' offices in the state of California, as well as defense attorneys in both. And then there's a difference between civil and criminal litigation. So also plaintiff and defense attorneys in the civil litigation world.
Your Honor, at this time, the defense tenders Dr. Blake as an expert in the field of human factor psychology and police practices.
Thank you, Vladimir, Your Honor.
Okay. Was it psychology in police practices or and?
No, it's human factor psychology, and then also a separate police practice.
So an expert in those 2 fields is what you're requesting?
Yes, Your Honor.
Mr. Becker?
Thank you, Your Honor. Just want to make sure, because kind of now 2 things. The report I got was a human factor psychology draft report. That's a report you prepared.
Yes, sir.
It was a human.
I mean, I'd need to see what you have there, but it sounds like, sure. That looks like it, yes.
And it's titled Human Factor Psychology. It wasn't anything with use of force at that point in time, but now we're going into that as well.
I don't think that he tried to certify me as an expert in use of force.
Oh, that's what he just did.
No.
I thought I said police practices.
Police practices, okay. Going into human factor psychology, there are 21 identified and recognized specialties in the American Psychological Association. Human factors is not one of them, is it?
No, it's not. I think there's a section, so you're talking about all the sections. Yeah. And I was previously a member of the APA. They do have a performance psychology section, which is very closely related.
There's a police and public safety one, right?
Yes.
And you're not a member of that?
No.
There's a behavioral and cognitive psychology. That's another one, but you're not a member of that?
No, sir.
There's like 50 divisions in the APA you can join, and human factors psychology is not one of them.
No, it's not. As I stated, human factor psychology is a umbrella area of science that's made up of people from various different backgrounds in psychology and other fields.
So you're not licensed to practice psychology anywhere in any state, are you?
Well, wait a minute. A licensed psychologist is completely different.
That's
than
what I just want to make it clear for
yeah,
the jury.
okay.
Just want to make
So
clear.
a licensed psychologist is somebody who practices clinical psychology and diagnoses people with maybe a mental disorder. I do not, that's a completely separate field.
And that's why I want to make sure, because you sort of psychology, we want to make it clear, you can't counsel anyone, you're not licensed to counsel anyone, that's not
No,
anything
sir.
that you do.
No, sir.
Now, Michigan Tech has an undergrad program in human factor psychology.
Okay.
I looked it up and it said human factor psychology focuses primarily on the interaction between people and machines. They make technology work better with humans. That was their definition. It sounds like you're much broader than that, is what you're saying.
Well, there's several definitions. I think if you look at the Human Factors and Ergonomic Society website, you'll find a definition that's closer to what I described.
Well, once again, going to the American Psychiatric Association, they talk about a career in human factor psychology. They talk about jobs where using a hands-free telephone to make a call while driving makes it less dangerous. That's one of the things you can do with human factors.
Yeah, and it's exactly pertinent to what I wrote in my report about attention, divided attention, perception. That's fundamental aspects of that field.
Other top jobs include architecture and design firms, how to build designs that will operate and how people interact with building layouts.
Yeah, again, all of that is safety focused. So warnings, designs, labels. There's been comments on for instance, comments on the Taser, that it's designed like a handgun, so therefore it's prone to error. People or police officers mistaking Tasers for handguns or vice versa. So the field is very broad. You are correct.
Now, in terms of that, you are not certified, the Board of Certification of Professional Ergonomics, are you?
No, and I can tell you why if you'd care to know.
Well, would one of the reasons be why that your undergrad degree isn't sufficient to get certified?
It actually, that's correct. Not my undergrad, but my graduate degrees. And the reason why is the field of human factors, like lots of fields, has changed their focus into contemporary topics. One of the contemporary topics is what's called UX, user experience. It's very involved with computers and that type of thing. Human capabilities and limitations associated with functioning with computer programs and all of those. Some of the required courses to become board certified are associated with those things, and to be quite honest with you, I'm not interested in those courses, and I'm not going to go work in that field, so I didn't pursue that any longer.
Well, I mean, it says the mission is to protect the public profession and its professionals by assuming standards of competency and advocating for the value of certification. You don't think you need to be certified because you just don't like it?
Not everybody's a board certified in anything. There's medical doctors that you can get board certification that may not be. There's psychologists that you could get board certification, they may not be.
Going to your undergrad degree, you're undergrad degree out of Union Institute out of Cincinnati, correct?
Correct.
That was closed in 2019, correct?
I didn't even know that.
Didn't even know that.
Actually, no, I didn't know.
Okay. Were you aware that Union Institute was known as CopU because so many police officers took the classes because they were online?
Actually, I attended in person to a portion of those classes.
A portion, but you still did others that were online?
Sure, that's kind of the norm today.
Were you aware that the Ohio Board of Regents report on Union Institute back in 2002 talked about Union Institute's weakness for lack of academic structures sufficient to produce a minimum level of academic achievement among its graduates?
No, I was not.
And even at Union Institute, you did not get it was nothing to do with human factors, you were criminal justice management.
Absolutely.
Which was designed to advance careers of law enforcement personnel into supervisory management and executive positions.
Correct.
You talk about your master's degree. Your master's degree was Kaplan University, correct?
Correct.
Correct. Kaplan University was a for-profit online university.
I believe so, yes. The for-profit part.
So now that's not around, it's been subsumed by Purdue Global, correct?
That's my understanding.
Were you aware that in 2012, the Senate United States Senate Committee on Health, Education, and Labor produced a report saying students raised concern with academic quality by filing complaints with school, state, and federal agencies regarding the level of education they got at Kaplan.
No, I found it to be vigorous. I did quite a significant and detailed thesis, and I had doctors from other colleges who were on the board who certified my thesis. So I felt it was a rigorous program.
You thought it was a rigorous program, but part of the thing with Kaplan was, going to their ad, a convenient web-based academic program allow you to tailor your own curriculum and plan class and study time to fit your own unique schedule. You kind of did your own thing at Kaplan.
Well, that's not true. I didn't. I don't know what that refers to, but I had a very structured schedule, just like any other college. I'd sign in, watch the instructor, I had to complete the assignments online, I had multiple papers and research projects that had to be completed, and I had to complete the thesis under the observation of a doctor in the field. So again, I thought it was rigorous.
Were you aware that Kaplan was sued by the state of Florida back in 2014 for engaging in unfair and deceptive practices related to student recruitment about job placement and accreditation, and they settled out of court for $1.3 million?
Objection, relevance?
Yeah. Goes to the academic credentials of his university. He talks about he's a part of academia. This is the type of university he went to for his degree.
I don't see, a lawsuit where they got sued related to, I don't know what, I don't see relevant to his qualification.
Okay. Are you aware of the Harvard Law School report on veteran complaints about misconduct at Kaplan?
Nope.
Okay. Complaints by veterans that it was too easy. A student in psychology was taught to use Microsoft Paint. Was that you?
No.
I would hope not.
I am a military veteran, but I don't recall that at all.
You didn't participate in that study then?
No.
Because you found it hard, but they have a study from Harvard saying it was basically too easy at Kaplan.
Okay. They have a study?
It was a report on veteran complaints about misconduct and illegal practices at Kaplan schools. You're not aware of that?
No.
You also talk about Human Performance Training Institute. You taught there, but that's not a degree.
That's correct.
All right, just want to make sure on that. But that was that was training for law enforcement and aviation personnel?
The boss, the owner of the company, was a former West Point professor who taught and did a lot of the human factors applications in the aviation field in the military. So he started that company, and I came in under him.
I got from the company that was started by 3 former law enforcement personnel.
Well, so it's changed hands since then.
All right, so it was started by that, but when you came in, it wasn't law enforcement.
No, they had an aviation component, because human factors came from aviation primarily. So this, I just call him the boss. The boss came from that world and opened up this company, and he kept that portion, and he also taught human factors to law enforcement. I came in under him.
Okay. Now, your doctorate is from Grand Canyon University?
Correct.
Now, what I had, is it a doctorate? A doctorate in performance psychology. Is it qualitative or quantitative? Because I saw 2 different ones when I looked up Grand Canyon University.
Well, qualitative and quantitative are research methods. I do believe, I think I looked at the website, and is this recent?
Yeah, this is, they separated out 2 of them. And
Yes.
You don't have separated out 2.
No, because at the time, they didn't have that.
Okay. So
You had a choice. You had a choice while you were going. It's really focused on the doctoral dissertation as to whether you want to go down the quantitative route and use those research methods, or you want to use the qualitative route.
Okay, so qualitative route, so that you did more the qualitative route.
Well, I didn't take that. That program didn't exist. My dissertation is in fact using a qualitative methodology.
But, okay, looking at their website in terms of qualitative, they talked about practices intended to improve employee performance. Use some of the strategies, look at goal setting, enhancing work output, how to improve work and leadership. That's what they describe qualitative doctorate program.
And I don't remember the description of that's not the program I went to, is all I'm saying.
Thank you. I have nothing further.
Thanks, sir.
We so move again, Matt?
Leave it at the court's discretion, Your Honor.
Okay, Dr. Blake. In anticipation of preparing a report, you reviewed some materials related to this case.
Yes, sir.
And that includes a lot of the videos the jury has seen.
Yes.
And some GRPD policies and training materials.
Correct.
You reviewed Mr. Becker's experts' reports.
Yes.
And you have heard, I think you said a lot of the testimony.
Yes.
All right. And obviously, prior to listening to the testimony, you prepared a report.
I did.
Okay, and you're aware that that report has been submitted to Mr. Becker?
Yes, according to what he just showed me, yes.
Yes, it was pretty obvious.
Yes.
And based on that, you've been able to form some opinions that are relevant to this case.
I have.
And also have observed and have a response to some of the opinions of Mr. Becker's experts as well.
Yes.
Okay. Now, you're aware that the prosecution has experts that provided an opinion, and it's Professor Seth Stoughton and
Correct.
Mr. Bloomfield, and their opinion was that in stressful environments, human decision-making suffers. Officers may experience distorted sensory perceptions, including visual distortions, for example, tunnel vision, auditory distortions, for example, auditory blunting, and temporal distortions, perceiving events as occurring more quickly or more slowly than they actually are. You're familiar with that statement by Professor Stoughton and Mr. Bloomfield?
I am.
Do you agree with that statement?
Absolutely. That's what the research shows. I think that statement is actually from Mr. Stoughton's book.
Okay. And so you've listened to some of the testimony. You heard that Professor Stoughton and Mr. Bloomfield indicated that they talked about that they had considered, for example, auditory distortions.
Yes.
Okay. When they did the report, you also heard at least Mr. Bloomfield say that he's not an expert in that field.
Correct.
Okay. Did you also hear that they formed an opinion that no reasonable officer could have heard, for example, the second cartridge go off in this case?
Yes.
Or would not have heard the second cartridge go off? Okay. So I'd like to talk about that, in particular, this idea of auditory distortions. And we talked a little bit about auditory blunting and auditory exclusion. Can you tell the jury what auditory distortions are?
Well, so it's auditory exclusions is what was talked about. And basically what we're talking about in general is a failure, a temporary loss of hearing, a failure to hear under acute stress. That's the general consensus from the law enforcement literature. And when I say law enforcement literature, I'm talking about the trade itself. That's how it's talked about. We can move over to the academic world and look at the research, and now we start seeing more information that is consistent with what the law enforcement field believes. And so we have research that is primarily, there's some research in an area called inattention deafness, which is focused on cognitive load, again, failure to hear under cognitive load, usually a visible task, and the failure to hear is an alarm, an audible alarm. But that research is very, very similar. The concept is very, very similar because cognitive load is a stressor. You're under stress. You're having to work hard. So they're the same
I'm
thing.
going to stop you a little bit.
I got going on.
Because there's a lot of terms in there. We need to unpack some of this.
Sorry. I got going.
So auditory exclusion, you define, but you started talking about cognitive load. Are there certain conditions that you associate with auditory exclusion?
Sure. Stress, cognitive load, and attention are the big ones.
Okay. So let's go with stress first, since that's the one you said first. Most people seem to know what stress is. Is that what you're talking about in connection with conditions that are associated with auditory exclusion?
Yes, stress. It's the capability and demand, that's the capability of the human, the demand of whatever the system is, whatever the task is, and your perception of the ability to deal with that demand. So it's those three things that are going to kind of fundamentally be the foundation for stress.
Okay. Cognitive load, you started talking about it, but what do you mean by cognitive load?
Cognitive load's an area of psychology where, to make it simple, we're looking at, once again, how difficult the task is. Again, it's the stressor. How difficult is the task? How complex is it? Is it time compressed? Is there a lot of things to pay attention to? A lot of things to respond to? Your brain is under a lot of load, and it has a limited ability. You think about it like the RAM in a computer. Your computer only has so much storage space, so much ability to function at a certain speed. And once you surpass that, it kind of goes defunct. So think of the brain like that. There's only so much information we can take in and process and respond to in a certain period of time.
Okay, so the information is coming in, the brain is like a computer, you can only handle so much.
True.
Okay. Now, you also mentioned focus of attention. What did you mean by that?
So in psychology, we have something called the spotlight of attention. So that's one way of looking at it. If you think about looking around a room, as I scan the room, if I look at one person in the jury box, I can pick up a lot of visual detail about that individual. I can tell you what they're wearing, maybe what the writing is on their shirt or the tag on their shirt. But details over here are absolutely, I know people are here, but I can't tell you anything visually about them. I can't garner any information. As a matter of fact, even slightly to the left of the person I may be looking at and focused on, I know they're there. I might know what color sweater they have, but the detail is much, much less. So, it's very easy to do that just looking around the courtroom and focusing on one person, but trying to discern a little bit of information just to the right or the left and then incrementally go out, and you realize very quickly that as you move out to the periphery while you're fixated, you're getting less and less information.
So these are the three sort of conditions that you would associate with auditory exclusion.
Yes, in the sense that what I was describing there was visual attention. So auditory attention, again, if you're listening for something, you're much more likely to pick it up. If it's an unexpected noise, especially in a complex environment or in a noisy environment even still, or you're focused on another area with all of your attentional resources, be it visual or otherwise, certainly you may not pick up that information.
Okay. And so you saw Mr. Bloomfield's testimony, and he provided an opinion where he said he considered auditory exclusion, and he also provided an opinion that said that the event at issue here was not the type of stressful situation where one could suffer auditory exclusion or blunting. Do you agree with that?
No.
Why not?
If you look at the police trade literature, and then you even go into the research that's been conducted here, there's multiple studies in this area. You find that this is exactly the situation, the type of event, being an officer-involved shooting, that officers report habitually, hundreds of them, having either dimmed audible information or not hearing things at all. Not only that, but that's also from that, I mentioned earlier that scholar-practitioner concept. This is also what I've seen in all these scenario-based environments that I've trained other officers in. They don't hear the gunshots. They don't hear radio traffic when the sirens are going and they're driving 100 miles an hour to go from point A to point B. And they're involved in all these tasks that are sucking attention and sucking that RAM or that available space that's available to process information. And they're not picking up details that they're not listening for, or details that's unexpected because they're so focused on something else.
Okay. And so you did review the video, and obviously no one knows what someone heard, right? And the question for you is this the type of condition where it's possible that auditory exclusion could apply? And in relation to the information you reviewed, do you think that it's possible that Officer Schurr experienced this sort of condition of auditory exclusion?
Yes.
Can you explain that, please?
Basically basically repeating what I just said. If you look at this incident and think about what were the attentional demands of the officer as he went through this process, and what were the attentional demands when that taser went off. He was fighting, he was doing all kinds of different things that he's already discussed, but clearly I see that as a rapidly evolving, complex situation, significant stress, and that sound, that noise was already, the sound was a little bit dimmer than what it usually is. I'm a taser instructor, so that's something I'm very familiar with. And so it wasn't as loud as what it would normally be. When that taser went off, he was in the middle of, or it occurred at the same time he was speaking. So that's another reason, you know, when you're yelling something, a noise from somewhere else during all this other stuff may not be heard.
Okay, and you've watched the video. There's a suggestion that the Officer Schurr stopped in the middle of a word. Is there anything else about that particular point in that video that suggests that maybe it's not that he just happened to have heard something? There are other conditions that could have been in play.
Well, the possibility is always there, but there's also, I hear later on, after the shooting, he gets on the radio and he's unable to complete a sentence. He starts saying 1915, send me, and I think there's a long pause and more units, or I've been involved in an officer-involved shooting, something to that effect. There's a pause there. So is it possible that when that taser went off, that he just couldn't finish that sentence because he was out of oxygen? He couldn't, the breathing.
Even if he heard it, meaning his ears comprehended the sound, would you expect a human being in this situation to engage in like analytical thinking about the significance of that second taser pop?
No.
Why not?
Well, analytical thinking is when you have that time to go from one step to the next step, simulate, talk about, think about what could we do next, what would be the outcome of that. Whereas when you're in a situation like that, you're kind of relying on what's called heuristics. You're kind of matching patterns and cues and information the best that you can under the current conditions. And as you're flowing through this, I just lost my train of thought. That's horrible. Could you repeat the question for me one more time?
Well, I actually had a couple more. Can I break this down a little bit for you?
Sure.
Let's start with, what is heuristics?
Heuristics are basically patterns. We develop patterns from our experiences. So knowledge, training, and experience. As we come up through our lives, we start learning details about people, places, and things. And we store that knowledge. And when we recognize a similar pattern, we make very rapid, sometimes implicit decisions about that information, and make decisions based on that. And it works for us most of the time pretty well.
Okay, and you were talking about what the brain does, the sort of the psychology of doing analytical thinking in a situation like this. And I don't know if you finished your answer or not, but is it your opinion that a human being in this situation wouldn't necessarily be observing all the information and stimulus informed through their ears, but they would understand what's going on even if they heard it?
Yeah, and that's where I was going with that. That's not an analytical process. You're kind of responding very quickly to the information. And if you hear a noise while your focus of attention is on all these other things, this rapidly evolving, I need to grab this, I need to control that, I'm trying to maintain my balance, That's going to take a lot more of your attentional resources. Then, so you may not have heard it. It is common in these policing incidents similar to this to not hear or see or recognize the situation as what it was in the moment.
All right, so I'd like to move on to, I like to call split-second decisions, but I don't think that's a medical term, right?
No, it's not a medical term.
But perception reaction time, including movement time. Can you tell the jury what perception reaction time is?
Yeah, so when we talk about the time from when a stimulus presents itself, meaning something that I need to respond to, like a red light on the wall. I'm told I need to push a button when the red light lights. So that's the stimulus. So there's a time between the stimulus presentation and my first movement. And this is going to be weird for you, but that's actually reaction time. You haven't moved yet. That's all the mental processing time that's going on. You're recognizing the stimulus, you're deciding what to do, you're selecting an option. In this case, you already have that selected for you. And then beyond that, when you start to move, to push that button, so if your fingers, you have to start like this, light comes on, there's going to be a delay, and then I'm going to start to move. As soon as I start to move, reaction time's over. Now I'm in the movement time mode, however long it takes me to move my hand from here and push the button. So task complexity and there's all kinds of issues that are potentially going to slow down that initial perception reaction time. On the back end, the movement time portion, also the task and the complexity. For instance, if it's not just a button, well, I have to reach down and grab my firearm and disengage the retention mechanisms, draw, aim, fire. That's going to obviously take a lot longer time because there's more involved in that process.
Okay, so let's talk about this a little bit with an example that the jury's seen many times. There's a still shot in this case of the moment the casing of the bullet that was used by Officer Schurr is coming out of the gun. You've seen that?
I have.
So that's a moment in time.
Correct.
Can you tell us what is that moment in relation to perception, reaction, or movement time?
That's well after perception, reaction, movement time that has occurred.
Okay, so that time period, perception, reaction, and movement has completed at the moment that's already out there.
It had to have, yes.
I mean, the function of all this is there's time that it takes to actually make something happen, right? First you have to perceive it, and then your body has to do certain things in response. And I think you talked about pushing a red button. In a controlled environment, have you actually studied this where you figure out what's the fastest somebody could go from perception to end of movement?
We have looked at that. I did the handgun study I talked about earlier. But I think what you're getting to is just there are studies out there that have done similar experiments, and they've looked specifically at that reaction time component, the time that you can't see, because they're looking at the moment of when the stimulus started and when the person started moving. So it's the time between there. So it's implicit. You can't, there's cognitive processes going on. That time period in studies that involve firearms draws is about 250 milliseconds, and that's consistent between two studies that I can think of.
Okay, 250 milliseconds, break this down for us. That's less than a second.
It's a quarter of a second.
Is this where we get the term split second, because we're splitting them up?
That would be the correct way to use that, yes.
All right. And so the fastest in a controlled environment that someone can go from perception to movement is less than a second, but basically a quarter second?
Definitely less, yes.
Okay. And that's in a controlled environment. In a uncontrolled environment, in the real world, we're not in a room with a red light, would you expect that reaction time to be slower?
Well, again, that's that mental processing time component, and that's in a very, very simple task. You're talking 250 milliseconds. When we have the real world influences, stress, age, complexity of the task, how many things are you attending to, the saliency, how important is that that stimulus in the environment? Is it bright or is it dim? Does it capture your attention? All those things now are going to influence whether or not you pick it up and start this process. And then, as again, the task complexity is in the movement time portion. That is also, as I explained, going to lengthen the time. But in this particular case, it could be relatively quick as far as the total process of perception to response time, if we're looking at the changes that occurred that Mr. Schurr testified, or Officer Schurr testified to, that may have caused him to use the force that he did.
Okay. So the ultimate question here is, I talked about this one moment in time where there's a casing coming out that shows the sort of the bullet casing in the air. Is that reflective on when Officer Schurr made the decision to shoot?
No.
Okay. So it was sometime before that.
It has to be.
All right. And obviously it can't be after that.
No.
All right. But you don't know exactly when that occurred?
No, it's implicit. I can only rely on what the officer said.
Okay. Now, you also saw the testimony of Professor Stoughton, where he said that Officer Schurr had sufficient time to give a verbal warning.
Yes.
Do you agree with that opinion?
No.
Why not?
Well, as I understand it, Professor Stoughton assumed that the decision was made to fire the weapon when it was drawn. I don't believe that's the case, based on testimony and based on my observations. Because if you look at the video, you see the weapon drawn, it gets pointed at Patrick, and then there's an additional directive command that's given. And then there's still more time after that and changes that occur before the shot is fired. So I think it's a little, well, totally speculative that the decision to fire, to come out and pull the trigger, was made when the weapon came out of the holster. And what I see is, I do see a change in the environment, in Patrick's positioning, that is consistent with what he has testified to, that elicited that decision. So that's a small period of time after the last directive was given. So if the decision was made after the last directive was given, that's a small period of time. So if you think, if the warning is expected to be drop the taser or I'll shoot, how long did it just take me to say that? Maybe a second and a half? So the immediacy of the threat doesn't allow for that. So for that reason, I don't think that it was feasible.
Okay, and you talked about a change in the environment. Are you talking about when Mr. Lyoya was turning?
I do.
Okay. And there wasn't sufficient time to give a full compound sentence warning in that particular moment?
Not my opinion, no.
Okay. Nothing further?
I want to go into some of your writings there. A copy of this, I want to know, can you tell me if you recognize that?
I do.
What do you recognize that as?
Factory, that's a study that I did. It's actually the peer-reviewed and published article from my thesis, my master's thesis.
Master's thesis.
Yes.
So this is factoring, fatigue, and deadly force encounters, kind of what we're talking about here.
Correct.
Now, but your thesis was based on, this article was based on, you lost an overwhelming amount of data, didn't you?
An overwhelming amount of data. It's been quite some time, sir.
Take a look. This is what you wrote.
Sure.
Highlight portion, top paragraph.
Okay, actually, I don't, yeah, that's true, I wrote that.
Yeah, you wrote that. You lost a total of 215 participants logged into the program, but only 53 were actually able to complete the questionnaire that you wanted.
Correct. It wasn't a questionnaire, but there were
What-
53 participants.
53 participants
Yeah.
out of the 215 that tried to log in. And then you based your decision on your thesis on 53 participants.
I did.
And they were all supposed to be law enforcement officers.
They were.
Well, they weren't because of a portion of the subjects were unknown to the researcher, although unlikely, it is possible that not all the subjects were in fact police officers. That's what you wrote.
Wait a minute, that's, you have the wrong face page on that. This is not, sir, this is not right. Yeah. Okay, I'm getting this confused with something else, I apologize.
That's
My
right.
fault.
So 50, out of the 53, you start out with 215, you went down to 53, and out of the 53 of law enforcement officers, you can't even say they're law enforcement officers for sure.
Correct.
And this is your rigorous Kaplan University master's thesis.
Well, sir, I mean, you can criticize it if you like, and we could go through it if you like, but ultimately, we lost a lot of data. That's not unusual in research. You lose data. Some participants are excluded. That happens. We reported on how many participants we had. We reported on the results, and we sent that in for peer review publication. It was accepted for peer review and publication. So it was rigorous enough for that.
For the law enforcement executive forum, is that what it was? Law
Yes.
enforcement executive forum.
Yes.
That's the basis of almost all your publications, isn't that true?
A portion of them, yes.
Well, you list about 50 of them. We're gonna go through Police One, Force Science, Police One again, Force Science. Those are all police-related entities, correct?
Yes.
Vertra News, that's Lon Bartle's
Company.
company. You're familiar with Lon?
I am familiar with Lon.
You work with him quite a bit?
No.
Not at all, but you did an article with him, didn't you?
Yes.
Okay.
Not with, well, yes, yeah.
You did a joint article with him, right?
Yeah.
But it sounds like did he sell the California Post, the simulator you use?
I have no idea. No, we don't even, as a matter of fact, when I was working there, we didn't even use that simulator, so couldn't, no.
Yeah, I'm looking, there's probably about 25 Police One articles. It's the vast majority of the things you write in, correct?
Correct.
One of the Police One articles I found, Digital Media Evidence and Force Investigations, back at, looks like October 19th, 2020. You recognize that?
Yeah, I certainly do, thank you.
That was with Mr. McFarland, who sits in the back, right?
Correct.
This is a whole article about how the two of you worked together on a very similar case, a use of force case, where both of you testified for the defense in that case, correct?
Yes.
And you wrote an article about your experiences in that case.
Yes.
And how the use of force captured on video can be misinterpreted, exposing officers and agencies to significant criminal and civil liability risk. That was the purpose of the article, right?
I don't know, it was certainly something we wrote to lead into the article, yes.
One of the things they brought up quite a bit on was the freeze frame photo that he asked you about a number of times in terms of when the moment the shot was, you see the thing.
Yes.
One of the things you consider, though, is you think that the best way to view a video is by frame, isn't that correct?
I think that's a good method to see everything that needs to be seen due to failures to see and other issues that can occur to an observer.
going to show you another Police One article. This was September 21st, 2017. Do you recognize that?
I do.
Okay. You wrote this article.
Yes.
Okay. In this article, you wrote, investigations involving any video should be broken down frame by frame to see and understand more of what occurred, as the human eye is not capable of picking up data at full speed.
Yes.
Those were your words.
Yeah, I stand by them.
Yeah. Your personal experience includes a video that showed hundreds of law enforcement officers and civilians. Once a frame by frame is shown, a new vote is taken and the exact opposite occurs. So you would advocate frame by frame.
I do advocate frame by
Did
frame.
you watch any of our frame by frame?
Absolutely.
Another Police One article that you wrote. It was November 17, 2016 article.
Yes.
This article, and I'm not sure if what you're talking about, you wrote, people learn to store information through their lifespan through training and experience. This allows us to make quick, unconscious, and often correct judgment about places, people, places, and things, right? So that's the heuristics you were talking about.
Yes.
Okay. However, there are times when these judgments and decisions can be wrong using that heuristic, correct?
Correct.
Just looking at it, I got some not exactly great Psychology Today. That's kind of a periodical you're familiar with.
I am familiar with it.
It's kind of the for people who are not academics, they could probably, it's something they rely on, and you're familiar with it and look at it time to time, I would assume.
I do on occasion, yes.
They talk about heuristic decisions. They talk about it's a mental shortcut that allows individual to make a quick decision, pass judgment, or solve a problem with minimal mental effort, correct?
It does say that, but I think that deserves context.
They can reduce the burden of decision-making, but they can also be costly when they lead to individuals to miss critical information or act on unjust biases. Is that a fair statement?
That is a fair statement, but it deserves context.
Familiar with the Journal of Criminal Justice?
Did you ask me if I was
Yeah, are you
familiar with it?
familiar
I'm
with-
sorry, I didn't hear you. Yes.
Yeah, you're familiar with the, it's a peer-reviewed journal, if you will.
Yes.
It's, something, I don't think you have any articles published in it, but it's something that's relied upon in the criminal justice industry, if you will.
Sure.
I have this article examining police use of force, examining the relationship between calls for service and the balance of police force and suspect resistance. In this statement, it says, research concludes that officers develop hunches about how suspicious an individual is, the likelihood they have a commitment, and their moral character. Would you agree with that?
Could you read that one more time?
Sure.
I'm sorry, it was a little quick.
The research concludes that officers develop hunches about how suspicious an individual is, the likelihood they have have commitment, and their moral character.
Sounds like you're reading the results of a research article that I haven't read, so I'm not going to agree with it.
You're not going to agree with that, okay.
Well, I have to read the research.
And get the context of it?
I would like to, yes.
Familiar with, this is a little bit different, criminal justice and behavior.
Heard of that one, yes.
Okay, something you rely on, is a peer-reviewed?
I may have read an article from there, I don't know.
Okay. In that, they talk about split-second decisions. You talked a little bit about split-second decisions. They say there's no time for considered analytical decisions. They rely on intuition and experience. A split-second syndrome exists where rapid decision-making inhibits diagnostic capabilities, resulting in bad decisions, right?
It sounds like you're reading the results of a study again. Is that just the narrative, or?
That's what the quote I have from the other article.
Can I see it?
I just put it away.
No, I'm sorry. I mean, before I comment on an article that I haven't seen, you know, is that possible? Yes.
That's possible. That's
But-
one of the
but-
things that, I mean, heuristics can lead to bad decisions, right?
Heuristics can lead to, yes.
You jump to conclusions. That's maybe a simplified way to do it.
Again, context. I think, you know, people, like I said, if I had to weigh it out and put a, and I don't have a scientific reference for this, but if I had to say on a daily basis, we make hundreds of heuristic-based decisions, and most of them, if not all of them, are right. And it does happen where that failure to go deeper, that we make an error, certainly.
Thank you. Anything further? A couple follow-up.
Mr. Becker talked about the single frame where the casing is coming out, and he was talking about frame-by-frame analysis.
Mhm.
You don't have any problem with frame-by-frame analysis?
No, my articles and everything I would talk about specifically focuses on frame-by-frame analysis. Is absolutely something you want to do in a case like this.
The point of your testimony is that you should look at the right frame.
Look at the right places in the right frame, track movement between frames back and forth. There's a myriad of things, yes.
Okay, and now we talked about Mr. Bloomfield and Professor Stoughton. Are either of them experts in human factors that you're aware of?
No, not that I'm aware of.
Had you heard of Mr. Bloomfield prior to this case?
Bloomfield, no.
Okay, you've heard of Professor Stoughton?
Yes.
Okay, nothing further.
Nothing further, Your Honor.
Hand raised on your jury, so I'm having my clerk come and grab that question. First question is, we heard that the defendant was focused on getting his taser back from Mr. Lyoya. Even when someone is focused visually on something, is it possible to experience auditory exclusion related to what they are focused on?
That's a great question. Is it possible? I think so. There's not a scientific experiment on a situation that's just like this. But my opinion would be that sound is different than a visual, unless there was a visual indicator that went with the sound. So like if there was some type of small light that came on that was noticed and the sound, then I would be more inclined to say, oh yeah, you should probably hear that sound. But in this case, all this environment's moving very, very quickly. He's maybe focused on the taser, we don't know where he's looking. You know, we get an orientation from looking at the video, maybe where his head's looking, but we don't know where his eyes are looking. So what his focus of attention on in that precise moment, I don't know. I don't know where what he was seeing at that moment. So ultimately, yes, I do believe that you could be visually focused on something and not hear the sound in a situation like this.
Okay, and another question, as a police officer on duty dealing with threatening situations daily, is there any actual possibility of analytical thinking in most stressful situations?
Another good question. There's a mixture. I mean, we don't just go through all day long, in this heuristic-based decision-making mode. There's a balance between the analytical and the heuristic. We rely more on the heuristic as things start to speed up, become time compressed, and we're under stress. When more time exists and no stress, then we're more likely to engage in analytical decision-making. So there's a balance that's going back and forth throughout the day, and in a police officer's life, it depends on what the situation is. If they're at a domestic violence call and it's the scene's secure and they're doing interviews and they're asking questions and complying with a list of policy requirements, then it's very likely that they're thinking analytically. What do I need to do here? We'll check the box and accomplishing all their tasks. However, when they first got to the scene and things were rapidly evolving, and maybe someone was holding let's just say it was rapidly evolving, then they're going to go back to their training and experience and recognize that situation and start doing very quickly what they need to do until that situation slows down a bit.
Any follow-up from those questions, Mr. Lyoya?
No, you're not. Then we are.
Any other hands raised? May this witness be excused?
Yes, Your Honor.
Any objection?
No, Your Honor.
Thank you very much, sir.
Thank you, ma'am.
And the defense like to call the next witness?
Your Honor, is it possible we could take a restroom break? The next witness is going to be a while. I apologize.
And what you're seeing is the wrapping up of the testimony from another witness brought forward after seeing the testimony from Christopher Schurr. We're going to bring in Riley Mack, who's been inside the courthouse all day long. Riley, I know a lot of people are still thinking about that testimony from Christopher Schurr. Can you talk about the atmosphere when Schurr took the stand?
Absolutely. So I've been inside that media room throughout the entirety of this trial. That's been 5 days. That's been so many hours of testimony, going through all of that. And we've heard, all the different perspectives, people who, they were neighbors when this situation was unfolding on their front lawn. We've heard from law enforcement who came to the scene after. We have never heard a first-person perspective from that scene that day. So when Christopher Schurr was called to the stand today, there was a bit of a shock in the media room. Everybody's leaning forward. We want to hear what he has to say about that day. This is a real court case. We don't know what's going to come next. So to hear that he was going up on the stand was a bit of a surprise. He spoke on his emotions that day. He spoke on his exhaustion. He said he could not even find the words to describe how tired he was after that struggle with Lyoya. He also testified that he never wanted to hurt Patrick Lyoya. He said, if I didn't do it, I don't believe I would be here. He believed the threat of the taser was that deadly that he was justified in using that deadly force. Through the cross-examination, Kent County Prosecutor Chris Becker really just was trying to prove throughout that was Lyoya just trying to get away? Was he not, grabbing for the taser to use it against Schurr? Was he just, trying to get away from the situation without getting hurt? And at one point, Schurr does testify that Lyoya never truly pointed the taser at him. And he also said that he's never met someone who's been, seriously injured or killed by a taser. So really interesting stuff, and the first time we've heard publicly from Christopher Schurr today.
And talk about the length of that testimony. I know that we just got done listening to another person, but it seemed like Christopher Schurr's testimony took the whole entire morning.
Yeah, it absolutely did. It was about 3 hours on the stand there through his testimony and then also the cross-examination. We went back and forth a few times. The trial has really been going by pretty quickly. We've had on the first day, I think it was 8 witnesses take the stand. Today, we're on, our second or third. We're about to go into our third witness after the break. So yeah, it's been a long day just with one person on the stand.
Riley, we know that another witness has actually taken the stand for the defense. We're going to let you get back in the media room so you can watch that testimony. Thank you so much, Riley. We now want to jump to some sound from Schurr's testimony. As we've been talking about, jurors have been able to ask a lot of questions. And in the beginning, we didn't see a lot of questions being asked, but as time has progressed, we've been able to see jurors ask whatever questions that they have. And it seems like in the last couple of days, the number of questions have been beginning to increase. Now, remember, we don't know who the jury is. We don't know if one juror is asking one question and another juror is asking another question. We don't know if, there's one juror that's asking a lot of questions. We just know that they're able to ask that question. And when you're watching, we want to remind you that one, we're on a 30-minute delay. And so you're seeing things not happen right away. But also, when a juror does ask a question to help keep them anonymous, we're not able to hear them. So you'll hear the audio mute at that point. So that way they can ask that question. We now want to bring in those questions that jurors talked about, asked Schurr during his testimony. Take a listen.
First, is the safety on the taser an on-off switch, or does it need to be held in the on position?
Good question. It's called a safety switch. It's an on-off. It's like a light switch. So it was on. I switched it on. It actually is some tension. I don't know the amount of weight to turn it on or off, but once it's on, it's on. It takes actual decent amount of physical pressure to shut it off.
And next, does writing a statement or a police report require you to write in the moment of the incident or for accuracy of what happened?
I think I get what.
Was right in the moment.
Yeah, I would. All right, if I answer that, I think I know what they're. If I understand the question correctly, I feel like there's I guess what I've been trained to do, there's kind of a difference in some part of it you're using the video, and then parts they have you just kind of go more or less off your memory for different various portions.
And the next question, in the beginning of the video, when the subject assaulted you prior to running away, at that time, is it okay within GRPD policy to use a taser prior to the tackle or in place of the tackle?
So that's kind of a loaded. To answer that, the strike could potentially justify under GRPD policy the use of the taser. However, using it on a subject that's running away, causing them to lock up and fall, especially around concrete vehicles, they hit their head, they could die using it or applying it in that manner, if that answers that question. So typically we're not trained to use it on someone who's running.
Well, the question asked about prior to running away, so as you
Well,
you were on concrete, so.
Well, I think he starts to run at that point. So
Well, the
I
question
think
is prior, in the beginning, when the subject assaulted you prior to running away, at that time, is it okay?
Prior to running, actually physically running, I would say yes. But the amount of time it takes me to get my radio out, he's already running at that point. So then we're in that same situation that I was discussing, if that makes sense. I think it would be petty to deploy a taser for what he did. That, for me, that's my opinion, based on just that information.
Okay, next, did you feel at any time prior to you presenting and deploying your taser that the subject was trying to grab or obtain the taser or any other weapons on your belt?
Was the question prior to?
Did you feel at any time prior to you presenting and deploying your taser, the subject was trying to grab or obtain the taser or any other weapons on your belt?
Prior to deploying the taser, I didn't feel as though he was trying to grab any weapons.
Next, do you recall being able to smell alcohol on Mr. Lyoya during your first interactions?
No.
Next, when you say you saw the taser being held as a handgun by Lyoya, did you prioritize attempting to press on the safety or to turn the safety off or to remove the taser?
The entire goal was to get the taser back. I couldn't get it back. The only thing I could potentially get my fingertips on was the safety at that point.
I know I asked about alcohol during your first interaction, but at any point did you notice he was under the influence?
I didn't smell it or notice it in those moments. Based on his actions, I would believe it, but I wouldn't just say because of him not responding to some of the tactics automatically means that he was under the influence. So I guess the answer is no.
Next, when you write a statement or police report, what is the process?
Depends on the report. If it's a more involved report, we'll review video as much as we can and then type it, and it might go back and forth.
Do you require running through new scenarios each time a new model taser is introduced?
You definitely do different you do scenarios when you get a new taser, for sure. However, when it might be the same scenario, when we switched to the new model, the bigger thing was the effectiveness at close range because of the design of the cartridges itself. So, and we didn't have to worry, the way the cartridges were designed were better for close, we didn't have to, I don't want to get into the actual design because I can't remember the original taser. I hardly remember the one that I used in this, but the big thing was it was more effective at close range and to train to use it in that manner.
Next is, why do you shoot Mr. Lyoya in the head?
I wouldn't say that I was necessarily aiming per se. I only had essentially a viewpoint of his upper back and head area. I deployed my handgun and fired it in that direction. It ended up hitting and striking his head.
Mr. Dodge, did you have any follow-up questions from any of those?
I do not, Your Honor.
Mr. Becker, how about you?
I have none, Your Honor.
I don't see any other hands. Oh, there's one hand raised on the jury. Next question is, when is running a license plate allowed? Is driving too slow reason enough?
To my knowledge, we can just drive around and run license plates whenever we want. And to answer just driving too slow, I guess potentially driving too slow depending on the speed limit you're in. I guess if you are exceedingly below the speed limit, yes, that is a traffic violation. That wasn't necessarily what I was stopping him for that day.
And like we've said before, we're on a 30-minute delay. We're now able to bring you the proceedings happening in the courtroom. Let's take a look in.
Lewis. And Vaughn is VON. Yeah.
Could you please state where you're currently employed and in what capacity?
Sure, I'm the Director of Consulting and Communications at Force Science.
Can you explain what Force Science is?
Sure. Force Science is just a company. It's not an individual type of science. But at Force Science, we have 4 divisions. We have a training division where we go around the country and we train police officers and community members. We train attorneys in how human performance issues impact use of force decision making. We do that for civilians and police use of force decision making. So that's our training division. And we have a consulting division, which I run. In our consulting division, we train attorneys, investigators, police officers, politicians, community members on how to evaluate use of force cases. And particularly our unique offer is we make sure that the evaluation includes what we call the human behind the badge. And so we're always looking at the big words of the psychological and physiological and environmental influences on decision making and performance. So our job in consulting is what we refer to as this concept of honest accountability. And so what we do in that sense, what we train and what we consult on is to ensure 2 main things, is that the guidelines and standards and policies that we use to hold officers accountable are clear enough that an officer or even a civilian can predict the lawfulness of their own behavior. And so we go into the policies and the laws and we look at the language so they can do that. And then the second half is we have to make sure that the expectations on police officers or civilians are not beyond human performance capabilities. So we can't hold an officer honestly accountable to a use of force decision if we're expecting something that no human could do. So in our consulting division, we really focus on those issues. We'll talk a little bit about my background, a little bit about how we do a little bit more than that. But I'll just also say we have a research division led by Dr. Bill Lewinsky. I'm not part of the research division, but what the research division does is it pulls from multiple disciplines. So we have thousands of peer-reviewed studies that undergird our training. So our research division is constantly looking across like the National Highway Traffic Safety, sports, medicine, psychology, and we're trying to find, are there any human performance issues across all these disciplines that might apply to a civilian or a police officer involved in a critical incident? If there is, we then take those studies, those findings, because nobody really reads peer-reviewed journals, and so we translate them. We'll put them into articles, we'll put those out in police magazines, we'll put them out in psychology magazines, we'll put them out to our audience who will use the information can read it. So you won't find us in like a popular mechanics magazine, but you might find us, I think you've heard like Police One or Lexipol or some of these bigger law enforcement publications. If there's no research in a specific area, our research division what we do is we find those gaps and we'll conduct the research ourselves. So Force Science has about, not very many, maybe 30 peer-reviewed research projects that we've conducted through our organization. And again, I've only conducted one of them or been a part of one of them. The rest were done before I came or by other experts. Those are then published in peer-reviewed journals, and then we translate those as well into the audience. The fourth one is just training development. We train instructors and we do curriculum development. So those are our 4 areas at Force Science.
Have you ever analyzed use of force cases?
Yes, that's what I do for a living.
And in what context do you do that?
So our cases, we don't care who calls us. We work for defense, we work for prosecutors, we work civilian, we work police cases. We will analyze for internal affairs, we'll analyze for politicians, we'll analyze for media, community members. We don't care who calls us because our analysis won't change. It's just hoping to educate them on the human performance issues, the laws, the policies that regulate police conduct and civilian conduct.
How long have you worked in the criminal justice profession?
A little over 30 years now.
And what were some of your roles in the law enforcement?
In law enforcement, yeah. So as you could tell, I started out as a police officer. I started back in maybe 1990 as what I would call a baby cop. I was basically a reserve police officer while I was going to college. I'll just generically just say I was a reserve, and then I became a full-time police officer basically from, I think we're going to go through this. I'll just say I was a police officer, and then I became a lawyer, was a military attorney, and then a senior policy attorney. And I think we'll go through some of the details of each of those.
Yes, so break that down. You have a lot of experience, so we'll get there. Could you please summarize your educational background?
Yeah, so I have I'll start with my associate's degree. I'm just as proud of that, associate of science degree. But I have a bachelor's in crime and delinquency studies. I have a master's in criminal justice administration. I have a doctorate in law, so I'm a lawyer, so I have a law degree. And then I have what's called a postdoctorate, a master's in law degree, which is just the next level law degree.
And since you're licensed to practice law, are you licensed in any jurisdictions?
Yes, Virginia and Kansas.
And based on your CV, do you have any specialized education, training, and experience that qualify you to identify and assess the customs, principles, and standards that are frequently observed in law enforcement?
I do, yes.
And specifically that impact training, policy, evaluations of police practices, use of force, decision-making, and performance?
Yes, ma'am.
And you mentioned it a little bit, but you were a police officer from roughly 1993 to 2014?
Yes. And that was both full and part-time. So I did a lot of that part-time for about 9 or 10 years full-time. And then stayed on as a reserve officer. After I was a police officer, which I'll go through a little bit of what I did as a police officer, I was going to law school and working on my master's during the day while I was working narcotics at night. Finished my law degree, 9/11 happened, so I joined as an Army judge advocate. So I was a military attorney. And then I transitioned from full-time police work to just coming back weekends and holidays and working the street when I could through my military career. So I was a full-time attorney practicing law, and I would just come back and work the street when I could. There were some gaps in there, so I wasn't working that whole time, but there was a lot of experience during those times that I continued to have.
All right, so you're putting us to shame with 3 jobs at once, potentially?
Mm-hmm.
All right, so for the job that you attended a police academy for, were you trained in the use of force, foot pursuits, and traffic stops?
Right, so my first job as a police officer, you imagine we were trained in use of force decision-making, all the things you probably continue to hear. So traffic stops, investigative detentions, tactics, as you continue to hear a lot about tactics, and yes, of course, foot pursuits and traffic stops.
You were also a field training officer and in-service instructor, where you taught new and veteran officers police practices, use of force, traffic stops, de-escalation?
Yes, so my job, after you go on the job for a little bit, you transition to more of a supervisor, a training role. In that capacity, I was a trainer, I was a tactics trainer, I was a communications trainer. I don't think I mentioned this, but I was a crisis counselor before I was a police officer, so I also transitioned to become a de-escalation trainer, a communications trainer. I taught tactics. You heard force-on-force training, so I set up and conducted force-on-force training. I ran our defensive tactics program and our de-escalation and our use of force program. So we were seeing not just the brand new officers, but we were training outside agencies. We were training veteran officers and supervisors, and I led those divisions for a while.
You also listed some additional training that you received in your CV, and there's a few that I wanted to ask you about. Can you describe some of these specific courses that you attended? One of them is the FLETC, Police Legal Advisor.
Right, so this is more in my legal capacity. The Federal Law Enforcement Training Center had a police legal advisors course, so I attended that course and passed the test, was certified in that course. That just focused on really the federal constitutional standards for policing, which eventually I would spend a lot of time actually teaching and focusing on constitutional policing issues. The FLETC Police Legal Advisors course was the first certification course I went through to sort of prepare me to be a police legal advisor. So ultimately you may hear that I did that for about 5 different chiefs of police where I was their legal advisor. That's the course that set that up, yeah.
Okay. And you also list NLETC, Basic, Intermediate, Advanced, and National Instructor. Can you tell us what that is?
Yeah, so that's one was the Federal Law Enforcement Training Center. That was purely academic. It was very heavy law-driven. The National Law Enforcement Training Center is all hands-on. So I was a basic instructor, intermediate, advanced, and ultimately a national instructor for the National Law Enforcement Training Center, doing weapon retention and disarmings, control and defense tactics, ground control techniques. Ultimately, I was a PR-24, which I don't even know if police still use those, but you've seen the side-handled baton with the kind of spinning thing. That I was an instructor for that, and also the straight baton. So these were all through the National Law Enforcement Training Center. That allowed me to train not just our own agency, but outside agencies from across the country. And as a national level instructor, I train the trainers. So my role now is less hands-on for the National Law Enforcement Training Center, and I'm really focusing on the legal aspects of use of force when I come in and teach for the NLETC.
And you also list the Force Science Advanced Specialist course?
Sure, the Force Science Advanced Specialist course is one we put on. I attended it before I worked for Force Science. It's an 18-week course where they bring in really some of the top experts in the country. They're outside adjuncts that come in and teach for Force Science, and some of these are the most prolific writers in a particular area. It's about 50 credit hours of college credit if you want to put in for it. I don't think I did. It's hundreds of hours of individual study, but the focus of that, and the reason I wanted to include that, is because that's where you really look and learn to apply human performance considerations in use of force encounters. So I want to make it very clear, that doesn't make me a scientist. There's no such thing as force science expert. Force Science is just a company, but what that course prepares you for, and there is no other course in the country like it, it allows you to issue spot human performance issues and the potential influence that they might have on decision-making and performance. If we then need to dig deeper, we would bring in somebody with a PhD or a medical degree or a psychology degree to tell you why those things are happening. This course prepares you to look for those things and to issue spot those things.
And it also looks like you have 50 college credits and hundreds of hours worth of independent training.
That was from the, I didn't actually put it for those. That 50 college credits is describing the
Force Science.
the Advanced Force Science Specialist course. Yes, ma'am.
And it looks like you have quite a few in here. You've listed over 150 different training courses that you've taught or attended across the country in the last 5 years alone. So could you please explain the variety of audiences that you've trained in? I have a few courses that I have questions about, but if you could tell us who you trained.
I just wanted to highlight that our training, my training particularly, is for attorneys, it's for civilians, it's for police. We train politicians, we train community members at universities, we train at FBI National Academy Association conferences, we train and consult with DOJ, we work for the defense, we've done training for defense attorneys, we've done training for prosecutors, I've done training for reporters. So really we're trying to ensure that any stakeholder who has an interest in understanding police violence or police decision-making is understanding the potential influence of human performance in those areas. And also a really big part of what we do with all of these stakeholders, which is really all of us in the community, is to ensure we understand the difference between a video presentation and a human's experience. So that's a big topic that we like to write about and train on.
And some of these that I want a little more detail on. So you mentioned evaluating use of force for executive leaders and attorneys.
Right. That was the last one I did. That was this year. That was in Riverside, California. So I do this personally across the country. That was a prosecution office and their investigators. And Riverside is massive. I think they have 180 investigators in their. I never heard of that. It's like a small police department. So their attorneys and their investigators attended this, and that one we specifically focused on how to evaluate use of force cases, where the human performance considerations and video analysis fit into a use of force case, and that was a prosecution office.
You also list human terrain mapping and behavior pattern recognition.
Yes, the reason for that is I just want to give a sampling of the audiences. These are tactical operators, so I still, although I'm not working the street, I still interact with, survey, train with tactical officers, and I also train them. That was a course that was specifically designed for tactical officers.
You also have U.S. Law Shield. What is that?
The U.S. Law Shield is it's an insurance company is what it is, but that was a class where we taught the actual attorneys. I just wanted to ensure people understood that we train attorneys who represent civilians, not just police. So we actually will be part of teams representing criminal defendants, civilian criminal defendants. We don't just represent or work with police cases.
You also have Cumberland University listed?
Right. This is an example of a university. There were community members there and university students that we wanted to reach out to and give an opportunity to understand the reality of human performance in critical incidents. We also, with those organizations, will work with, you heard from Lon Bartel with Vertra. They'll bring their simulator in, and we let the civilians run through those simulators so they can experience what it's like to try to make a decision as a police officer in those split seconds. And that's one of the most impactful ways we can sort of educate the community on the reality of a police officer's decision-making experience.
So it sounds like Force Science works with a lot of experts in the field of law enforcement, human factors, like we heard from Dr. Blake and Lon Bartel. Is that correct?
Yeah, so as a consultant director, you hear my expertise is police practices, use of force, threat assessments, responses, the potential influence of human performance issues in force encounters, and video. But I do this all as issue spotting. I connect the dots and say this is an issue that needs to be addressed. I'm also the one who says we probably need a psychologist here, we probably need a human factors PhD, we probably need a doctor. I won't do that part of the consulting or the testimony myself. So we have developed a network across the country of some of the top experts, and we try to work with them to fill in those gaps.
Are Professor Seth Stoughton or Nicholas Bloomfield part of that network?
They are not.
You also list the limitations of video for use of force investigations, use of force summit from December of 2024. Can you tell us about that?
Yeah, just if there was any question, that's one of the top rated use of force conferences. It's by selection only, and I just recently did a presentation there on the limitations of how video can and can't be used to judge a human's experience during an event.
You have many more, but I'm not going to have you go through all of them,
Yes, ma'am.
just for interest of time. In addition to this, has Force Science trained law enforcement officers on the use of force? Do you know how many they have? How many they've trained?
Yeah, I mean, at this point, it's probably hundreds of, I would say 100,000. I mean, there's tens of thousands, if not over 100,000 people we've trained through Force Science. I personally trained tens of thousands of officers at this point.
Has Force Science taught students or law enforcement officers in Michigan?
We have.
Do you know roughly how many?
I tried to look. I think it's roughly, in Michigan proper, over 400 last time I checked. I think just Grand Rapids and the Michigan State Police and Kent County, I think maybe 100 in total of that group that I could verify we've trained recently.
And you mentioned you've had several students from the Grand Rapids Police Department?
Yes.
In your current job, are you hired to conduct training and consultation in, I think you already mentioned this a little bit, but police practices, law, investigations, trainings, use of force, and evaluations?
Yeah, that's what I do full-time now, yes.
And do you do this across country and internationally?
Yes, we recently had cases in Ireland. I'm going to Mexico City next month, I think. We've got a couple of cases I've handled out of Australia. So we're retained internationally and nationally.
Let's talk a little bit about how you ended up as an expert consultant in police practices, use of force, policy, and training. You have several experiences, and I kind of want to talk now about your law enforcement experience.
Yes, ma'am.
It looks like you taught defense tactics and use of force.
Yes.
And I know you mentioned some of this already. Patrol tactics, traffic stops, foot pursuits.
Yes, ma'am.
De-escalation, communication.
Yes, ma'am.
You've developed training, we're on a policy review committee, and have wrote use of force policies.
Yes, I did.
You were also on a high-risk warrant team.
Yes, so we had a difference between our SWAT team and our high-risk warrant team. So I spent much more time on the high-risk warrant team, which basically mostly was narcotics warrants. Ultimately, I ended up working for our SWAT team. I did that for a very short period of time. But yes, I worked both those.
And you also mentioned you're an attorney.
Yes, ma'am.
And you practiced law for about 15 years?
Yes, ma'am.
So I just want to go through some of your experience practicing as a lawyer as it applies to police practices, policy development, and use of force.
Yes, ma'am.
Looks like you taught constitutional policing, use of force decision-making, and investigations full-time to military and civilian police officers?
Yes, at the United States Army Military Police School, I was an Army judge advocate, so I was stationed there full-time for about 2.5 years, where I trained specifically on constitutional policing, which was use of force, Fourth Amendment, Fifth Amendment. So when you could stop somebody, when you could use force, criminal law, criminal procedure, That was both military and civilian police attended those courses, so it wasn't just uniquely military law, but I did that full-time as part of my military duties.
Thank you for your service. You were a police legal advisor for agencies including at least 4 chiefs of police and emergency services directors?
Yes, ma'am.
And that included the review of training and policies?
It did.
Did that include the review of use of force cases?
It did.
And you were also a prosecutor?
I was.
And you were a senior prosecutor for several years, supervising a legal team?
Yes, ma'am.
You were also a special assistant U.S. attorney?
Yes, ma'am.
Where was that?
That was in the Eastern District of Kansas. That was not, we had to evaluate, I personally evaluated those cases for mostly constitutional issues. Those cases did not involve use of force necessarily. They were mostly attempted murder and sexual assault cases while I was in that capacity.
You were also the senior domestic operational law attorney for a multi-state region in the U.S.?
Right, so that's only important in that that's when I started to have to become very familiar with how different states and different jurisdictions handle police practices, because they all do it very differently. And so we had to integrate military with civilian operations for anything that happened in the U.S. And so I had to be familiar with very specific local laws and the federal laws, and then how to integrate those. So I was the senior legal advisor for what was the defense DCO, Defense Civil Officers, I think is what it was called. Defense Support Civil Operations is what we was. But I was a senior legal advisor, and so my job was to start to look at how various jurisdictions handled police practices and use of force to make sure we could integrate with them.
And at one point, you were also the senior domestic operational law attorney at the Pentagon?
Yes, ma'am. So my job there was, again, it seems odd, I'll only explain because it's military. It sounds like, well, that's military, it's not civilian. My job was specifically to understand civilian use of force laws across the country now, because all of our military assets might have to integrate with them, and we had to find out where there was any differences between how we might operate and how they might operate. And so I was in charge. I was the senior domestic operational law attorney. I advised the highest ranking JAG. It was a 3-star, General Darpino, on domestic operational law issues, and it just happened to include a time frame where we had just had a potential terrorist attack in the U.S., and so we were writing policy very quickly. So I actually wrote Army and DOD use of force policy for that at that period of time.
And so you were also the operational attorney for the Army Criminal Investigations Command?
Yeah, what's important about an operational attorney versus, say, a litigator or a consulting attorney? An operational attorney works directly with the criminal investigators. So again, these are the ones where a criminal investigator might be at the scene right then. A police officer might have pulled the car over right away. And so you had to have a very high level understanding of police practices and use of force and constitutional issues, because they needed to have an answer right now. There's no time to study, there's no time to research. An operational attorney is the one who's advising those operational criminal investigators and police officers in real time. And so I had that job working for the Criminal Investigations Division for the U.S. Army. Simultaneously, I was working as for the Terrorism Criminal Investigations Unit, also as an operational attorney where we just investigated terrorism cases.
In addition to your police and legal work, you worked for Lexipol as a senior policy attorney?
Yes, ma'am.
Can you explain the role of senior policy attorney in the development of model police policies?
Yeah, so after I retired from the military, one of my first jobs was for a company called Lexipol. When we started to hear some of these things about model policies and some of these organizations like IACP or PERF, the Police Executive Research Forum, Lexipol is among them. They generate model policies, they generate consideration papers. So my job as a senior policy attorney was to draft, literally write these model policies, and then to customize or work with clients to customize those policies for local application. And so what is important about that is, in my role as a senior policy attorney, I was required to understand the laws, the federal laws, the state laws, the local laws, the community interests, any political or cultural issues that were going on. I had to understand technology that was advancing through law enforcement. I understand reform issues as they were coming up, because we were having to look at what the current state of the law was and compare that to any recommended changes or reform efforts or any recommendations or reform efforts. And then our job was to advise on whether those types of changes would make it into the policy or not, make it into the model policy. So I think we'll talk more about what a model policy is and what it is not, what it's intended for and what it's not intended for a little bit later. But that job for about 2.5 years required me to have a very deep understanding across the entire country of police practices, use of force, and our cultural and technological influences on those issues.
Have you evaluated the adequacy of policies in the context of specific incidents or litigation as well?
Yes, ma'am.
Can you tell us a little bit about that?
Yeah, so when we take on a case, we're involved in a lot of the high-profile cases in the country, and so when we get involved, some of the first things we have to do is kind of look at the policy that the officer was operating under. And so we will then look at that policy, and my job specifically is to look for internal and external inconsistencies, because you might have a foot pursuit policy and a car pursuit policy and an investigation policy that we call it wallpaper. So if you wrote one policy and then you wrote the other one, you didn't recognize the same changes, then the officers are kind of confused because they'll end up having two different standards affecting the exact same conduct. So our job when we look at those cases is to look for internal and external inconsistencies within policy. Once we've done that, we look for inconsistencies between the policy and the local training, like the county training, or we'll look at state laws, and then we'll look at federal laws. So what we're basically trying to say is if we're going to hold this officer accountable to his conduct, we want to make sure that he understands clearly what the expectation was. So when we start to see all these inconsistencies between what's expected of the officer, we have to identify that for our client and say, look, you're going to have real trouble holding him accountable to a standard when he's being asked to follow 3 different standards, for example. And so we look for that. That's the biggest part of our policy reviews when we're trying to engage in what we call honest accountability of officers involved in these critical incidents.
Can you explain how your work incorporates human factors into understanding police use of force?
Right, so we've heard a lot about human factors. We've heard about action-reaction or action-beats reaction, auditory exclusion and auditory blunting. Human performance issues in our job in evaluating cases is really the entire point of evaluating the case, right? Because we are evaluating what an individual officer perceived. And so in order to do that, we're having to look at the bucket of information that the officer perceived and then what meaning they assign to it. And whether that meaning, basically what cops know, what does that mean to a cop, is what drives their decision, right? When we try to figure out that initial bucket of information that we want to hold the officer accountable to, you have to understand that a human is involved in a critical incident. And so when you're looking at that human, you got to say, what are the psychological, physiological, and environmental influences on their ability to see something, or like we've heard in this case a lot, their ability to hear something. What is their focus of attention, and how is that going to impact their ability to see various different objects in the environment, right? So the human performance side, if we don't consider those in every aspect of a criminal investigation or of a use of force investigation, we've essentially taken the human out of the equation. And then we're just looking, which is obviously what we refer to as unjust or corrupt accountability, right? You can't hold an officer accountable to things that are beyond human performance capabilities. And I don't think anybody disagrees with that.
And you mentioned a little bit about action versus reaction. Can you explain how that's incorporated into these?
Yeah, so when you heard from other experts on this idea of action and reaction, there are certain human performance issues that almost all reasonably well-trained case evaluators or investigators are going to recognize. So these are not things you need a scientific degree to understand or see. We all see them, we all experience them. Police specifically will see them in training quite frequently. So we'll see auditory exclusion, we'll see tunnel vision, we'll have that described to us. And then we, in fact, will actually have to, they're so well known in the industry, we actually have to create tactics to mitigate them. So if I give you an example of that, auditory exclusion, for example, is so well known that if I have an officer involved in a fight with somebody, and we have these new policies, or you might have heard of called duty to intervene, right? So we want other officers to come in, look at the scene and go, hey, I think the guy's unconscious, I think we have him in control now, we can slow down the use of force. 2 things are known to us as trainers. The person involved in the fight might not be seeing it the same way because they're focused on the fight. When you come in after the fact as an additional officer or as a supervisor, you're going to be like the referee of an MMA fight. You're going to see things. If you guys have watched MMA, sometimes the guy's knocked unconscious and the referee has to kind of push the fighter off, right? Because the fighter's not seeing it yet. Well, in policing, it's the same thing. We recognize and we have to mitigate. We have to have tactics that reflect the fact that this person in the fight might not be hearing us. And so we'll actually tap on them. We'll yell their name, we got him, let's slow down, I'm with you. And you have to become a more important stimulus than what they're dealing with. So we know that from a human factor standpoint, auditory exclusion means if I just come in and say, hey, Bob, I can't reasonably expect them to hear me because I know they're so focused, so we develop tactics. So those kind of human performance issues are well known and are part of policy development, training development, operations development, investigations, and then case evaluation. So you're gonna see it throughout, and you'll see within the police industry that police practices experts are often the most qualified people to recognize the influence of human performance in a critical incident, even more than the researchers who are typically doing clinical lab studies. We take what they have, and then we're the ones that actually do the application piece.
And you mentioned in a critical incident event. Can you explain why that is?
Why that is?
Yeah.
Yeah, you heard a little bit about rational decision-making and heuristic decision-making. I don't like that term. Sometimes judges don't let me say that term, heuristic. But what it just means is rule of thumb. What heuristics is, we all experience it, is there's certain patterns we see throughout life, and we basically go through life.
We haven't A, qualified as an expert. B, now he's talking about heuristics when he testified earlier that he can't talk about psychological things. That's why we brought in another doctor for it. So I think he's going beyond whatever he can testify to.
I'm still going through his qualification. I mean, he has I've tried to cut out the most important parts, but he has a lot of qualifications that I would like to put on the record.
Talking about his qualifications is okay. Delving into definitions of things, I believe, would be inappropriate at this stage, as he has not been admitted as an expert in anything yet.
Okay. I may have a few more questions for you. I'll try to keep it quick. You also list that you've published approximately 75 published articles.
Yes, ma'am.
And your work is widely distributed across national police publications?
Yes, ma'am.
You've been published in dozens of publications, including Police One, For Science News, Michigan Chiefs of Police magazine. You mentioned Lexipol, International Law Enforcement Educators and Trainers magazine.
Yes.
And you're frequently interviewed and cited as a use of force expert in books, magazines, articles, news reports, and
Yes, ma'am.
professional magazines.
Yes, ma'am.
You've been asked to present and write for the IACP Legal Officers Conference and
Yes,
to
ma'am.
publish in the IACP Police Chief magazine.
Yes, ma'am.
And what is IACP?
That's the International Association of Chiefs of Police. I think we heard that from some of the model policies or consideration papers that were being offered.
You've recently presented at the Axon Taser Conference.
Yes, last week or 2 weeks ago.
You've been asked to present legal considerations for the Taser Master Instructor course.
Yes, ma'am.
And you have several organizations on your CV. I'll just go through a few and kind of have you explain or tell us if you're still a part of that organization.
Yes, ma'am.
So you're listed as expert advisor for the International Association of Directors of Law Enforcement Partner Advisory Committee.
Yes, the International Association of Directors of Law Enforcement Education Trainers, they're an organization that compiles all of the individual state training, police training organizations, and they're an association that sort of organizes the conversations with those groups, and I'm on their expert advisory panel.
And you also are, looks like, a member of the board of directors for the Association of Force Investigators,
Yes,
and a national level instructor at the National Law Enforcement Training Center.
yes, ma'am.
It looks like you're a member of the American Society of Evidence-Based Policing,
Yes, ma'am.
and an instructor at the International Law Enforcement Educators and Trainer Associations.
Right, so the ILETA, an International Law Enforcement Educator Training Association, is just what it sounds like. It's an association that brings together annually the law enforcement trainers from across the world. They hold a conference every year, and they also have a publication that they put out to basically train the trainers is what it is.
Have you been retained previously as an expert consultant in police practices or use of force?
Yes, ma'am.
And what types have you served as an expert? Civil, criminal?
Yeah, so as I mentioned earlier, so it's civil, criminal, it's police, it's internal affairs, it's civilian cases. If it's a force encounter and there's a stakeholder who's interested in understanding that force encounter, we'll work with them.
Have you ever been qualified and testified as an expert in a court of law?
Yes, ma'am.
Have you ever been disqualified as a police practices, policy, or use of force expert on any cases which you have been retained?
No.
Are you being compensated for your time in this case?
Yes.
Is your compensation contingent on the outcome?
No.
When evaluating police conduct, what methodology do you use?
Yeah, that's, so the first thing we do, so we look at how do use of force case evaluation, experts evaluate a case. The methodology for us is first you collect the available information, right? So we're trying to find out what is the bucket of information that the officer had perceived or was aware of during the investigation. So in order for us to do that, we look at the videos, we look at written statements, we look at the forensic evidence, if there's autopsies, we look at as much information as we can relative to their training, their policies. And once we have that information, the next step is then we start to answer two basic questions. The methodology to answer two questions: was the threat assessment reasonable, and was the response reasonable, based on what the individual officer had perceived and the information that or the meaning that they assigned to it. And so when we're looking at that, we're evaluating that case against the law, the policy, and the training of that individual officer. And then comparing the law, the policy, and the training of the individual officer against their performance and against their decision-making as we understand it from the objective evidence. We then will make those comparisons and evaluate how those things stacked up, and then we'll write a report that provide our opinions on that. The biggest part of our methodology is as we're trying to figure out what the officer observed. So we'll talk about this concept of observe, orient, decide, and act. So what did they observe? What meaning did they assign to it? Part of the methodology is then to apply human performance factors across each of those domains, observe, orient, decide, and act, to see how an ordinary human would operate under those same conditions. And then the other big part is we look at video evidence, and part of the methodology is to distinguish very clearly that a video is not a proxy for an officer's experience. The video does not tell you what the officer perceived, what they paid attention to, and so part of our methodology is to really be careful not to equate a video with the officer's perception.
And one of the things I think that you've mentioned was the local training and policy records of the agency.
Yes.
Why is that important to consider?
The standard by which we're judging the officer's performance is the local policy and the law of that jurisdiction. So we'll look at the state law, we'll look at the local law, and then we'll look at their policies and their training, because those are the standards and expectations which we're going to judge their performance against relative to their threat assessment and response.
And your methodology conforms to the standards of generally accepted, or is generally accepted by professionals in your field?
It is.
And you've talked a little bit about human factors and officer decision-making under stress as widely understood and incorporated by reasonably trained police practices and use of force experts. Part of your analysis here will include some of those factors, but your testimony will be limited to what you've talked about so far today, right?
Right, so when I talk about any human performance issue, I'll talk about it in the concept of what a police practices expert and use of force expert would generally understand about the incorporation of those factors. I'm not a scientific expert. Like I said, I think there was, that I can't talk about the concepts. Well, I will likely talk about the concepts as any other police practices expert might. I think we heard from the other experts talking about some of those general concepts. The distinction between me as a police practices expert and a scientific expert is that I will tell you what we typically see in policing and what we expect during the investigations. But if you need to know why those things are occurring or if they specifically occurred in an individual, that's not something that I or any of the police practitioners or witnesses can tell you. Oftentimes, only the individual officer can tell you whether they were experiencing something. Our job is essentially to say, relative to human performance, if one side says there was a sound and the officer must have heard it, and he's lying if he says he didn't, we would simply say there are other explanations that could also explain that phenomenon. We're not saying which one applied, that's up to you guys to believe, but we're gonna say if you're gonna hold out that the officer has to be lying, we're gonna say, well, there are other human performance issues that could also explain that phenomenon, and we're just gonna make sure that the trier of fact is aware of those as well.
And in some of your reviews of other cases, have there ever been instances where you found that's not the case?
What's not the case?
That they, based on the review, that there may not be other things that play into how the officer is conducting himself in a use of force incident.
Yeah, so if there's ever the impression that we only defend cops or that there's no cop we're not willing to defend, there are a lot of cases we review where there's no human performance issue or police practices issue that's going to explain an excessive use of force. So our analysis will not change, and there are plenty of cases we evaluate where a human performance issue is not going to help explain a bad police decision or an excessive use of force.
And have you reviewed Professor Stoughton and Mr. Bloomfield's report in this case?
I have.
And do you agree with their methodology?
I guess I'm gonna have to object. He hasn't been qualified in anything. We've been, I don't know what she's doing.
All this is same, doesn't matter if he agrees or not.
Okay, Your Honor, I would move for admission of Mr. Kleem as an expert in police practices, police tactics, policy, and the use of force.
No objection.
So can you repeat that one more time, please?
I would move for admission of Mr. Kleem as an expert in police practices, police tactics, policy, and use of force.
All right, and there being no objection, I will consider him an expert in those fields.
And Mr. Kleem, have you reviewed Professor Stoughton's report and Mr. Bloomfield's report in this case?
Yes, I have.
And do you agree with their methodology?
No, I do not.
Why not?
There are two main errors that are inconsistent with how reasonably well-trained experts would perform this type of an investigation. The two biggest ones that I noticed that I would disagree with is one, well, maybe three. They don't don't actually apply human performance issues to their analysis. They I think potentially led the jury to the impression that there are generally accepted police practices and standards that officers, whether they have ever heard of them or not, are supposed to be held up against. That is absolutely not true. Officers are not held up against standards that they've never been made aware of. And we'll talk about that, I think, at length of why that is. Another major issue with their methodology is this case or any use of force case to be evaluated through the lens of the officer who's involved. And so you might hear that we look at it from a reasonably well-trained police officer. It's under the totality of circumstances, was it reasonable for that officer to believe, based on the information they had in the circumstances they were in, based on their knowledge, that there was a reasonable belief of the threat of death or serious bodily injury? What we heard from Professor Stoughton and I think Mr. Bloomfield is that there was sort of this sort of, I call it an avatar. There's this magical, reasonable officer, reasonably well-trained officer, and they even said, what would a reasonably well-trained officer have perceived? Well, if you understand what they just did there, they're saying that it doesn't matter what this officer perceived, what would some magical, imaginary officer have perceived, and that's what we're going to hold them against. That is beyond human performance capabilities. So those are three areas where their methodology was inconsistent with what is generally accepted as a methodology for evaluating these cases. And there's a fourth one where you don't use a video. It's very difficult to use a video and then determine from that what an officer was thinking or what they were paying attention to. that is an objective third party, or an objective two-dimensional video. It has nothing to do with the psychological workings of the police officer. And yet we heard some evidence from them that they relied on the video to tell us whether an officer did or did not hear something, for example.
Have you, and you mentioned some of Professor Stoughton and Mr. Bloomfield's testimony. Have you also been watching this trial since Monday?
I have.
Why haven't you been here in the courtroom with us?
Objection, what's the relevance? Who cares?
I guess I can move on, but if the jury hasn't seen him, I just wanted to explain why. But we don't have to. Okay. Well, if you need to drink water or anything, you can
Thank you.
feel free. All right, so have you reviewed the incident involving Officer Schurr and the use of deadly force against Mr. Lyoya?
I have, yes.
And what have you reviewed in this case?
I have there's an extensive list. So I looked at the videos, I looked at the officer statements, I looked at the autopsies, I looked at the Michigan laws, I looked at, this case has been working its way through courts in various levels, so I've looked at the basically the appellate record, the record of the case to kind of figure out what the law is. I've looked at the local policies. I've listened to the testimony of the experts, including the trainers. I think I've got a much longer, extensive list attached to my report, but those are basically the things I relied on.
Based on your review of those and your expertise, is it your opinion that a reasonable officer in Officer Schurr's situation believed that deadly force was necessary at the time it was used?
Yes, after evaluating this case, I think it was not only reasonable for an officer to believe that he was facing, in his situation, was facing a threat of death or serious bodily injury, but after listening to that testimony, these officers are specifically trained to believe that, based on the testimony you heard from your Axon experts, your Taser experts, and the Taser warning labels. These officers are actually trained to believe that they were facing a threat of death or serious bodily injury when someone has taken their Taser from them and is in a condition to use it against them.
And why is the fact that the suspect had taken control of Officer Schurr's Taser significant?
Yeah, so you heard this concept of intent, capability, and opportunity. So when we evaluate that imminent threat, we do something very similar to what Professor Stoughton described. We break it down a little bit further. It might be a little bit more useful, but we look at intent, ability, means, and opportunity. And if the officer reasonably believes, like they don't have to prove it beyond a reasonable doubt, they obviously don't have time for that. But if an officer reasonably believes that the person has the apparent intent, the apparent ability, the apparent means, and the apparent opportunity to inflict death or serious bodily injury, then they are authorized to use a quality of force to immediately and decisively stop the threat. They can use force to stop the threat right now. So in this case, when you looked at physical ability, he's moving, he's wrestling, he's gripping. I don't think there's any serious contention that he had the physical ability to use that weapon. The means is where the Taser come into place. When we're analyzing the means, that's the weapon itself. And so was it reasonable for an officer to believe that a suspect who has wrestled a Taser away from them has the means to inflict death or serious bodily injury? And again, is it reasonable for them to believe that? We heard extensive testimony that not only was it reasonable for them to believe that the Axon expert actually believes that himself and testified to that, as did Professor Kroll. So that's the means itself. So the importance of it is, in an imminent threat analysis, like Professor Stoughton talked about, we're looking at intent, ability, means, and opportunity. The Taser itself was the means. So what we're left with is the opportunity and the intent. And we can talk a little bit about why I believe those things were present in this case. And again, why do I believe it would be reasonable for an officer to believe they were present in this case? We can talk about that, but right now I'll just stop with the means itself.
And you mentioned that the framework is similar to Professor Stoughton, but differs in some ways, or is
Yeah, across the country there's some variations of that. It's actually not a legal requirement. It's kind of a useful after-the-fact tool to use. So we've seen intent, capability, opportunity. We've seen intent, opportunity, jeopardy. We use intent, ability, means, opportunity just to flesh it out a little bit more.
And is it your opinion that in this case, Mr. Lyoya had the apparent intent because he fought very hard to disarm the officer, he didn't throw it away, he disobeyed the officer's commands repeatedly, he was capable of using it and began turning towards the officer?
Jack, now we're leading because she's...
Okay, I'll ask you what I'll withdraw that. What is your opinion about the apparent intent of Mr. Lyoya?
Right, so one, you heard that officers are trained to believe that if somebody takes their weapon, it's reasonable to believe they intend to use it against you. What is particularly relevant in this case is that Mr. Lyoya did not just take the weapon and throw it away. He took the weapon, transitioned hands, and held it in a position capable of being utilized with just a simple trigger press. Is it reasonable for an officer to believe that someone who has struggled that hard to take your weapon has the intent to use it when they've taken the time to transition it to what is typically a dominant hand, and to hold it in a manner that's consistent with its use and also does not throw it away? So based on that and his earlier failure or his refusal to obey lawful commands, the aggressiveness with which he resisted the arrest, those things to me would fall, a similar situated officer in those conditions, not only would it be reasonable for them to believe that, as a trainer, we would actually train them to believe that, and I think that was consistent with the training we heard Officer Schurr received.
In your opinion, would it be reasonable for an officer to believe that Mr. Lyoya, by displaying the apparent intent, ability, means, and opportunity, posed a threat that could cause a person in Officer Schurr's situation and position to fear death or serious bodily harm?
Yes, again, it's just a reasonable belief. He doesn't have to actually be correct, but in this case, I believe that he was, or an officer in his position would have been. We've talked about intent, ability, and means. The final thing, part of my opinion, was opportunity, and the question is, would it be reasonable for an officer in Officer Schurr's position to believe that Mr. Lyoya could actually turn fast enough and use that weapon against him? That's the opportunity. Was he in close enough proximity? So reaching under his arm or touching his leg, all those things were available from that distance, appeared to be available. But what I focused on as a grappler and a wrestler and a jiu-jitsu guy was how fast can someone in a tabletop position, as you've heard it described, actually spin and become flat on their back such that they're actually facing the officer. And that happens in, I think one officer said, a second and a half. It's actually much faster, and that can happen in half a second or faster. So in my experience training grappling and training officers in that tabletop position, or myself, you can actually turn and spin and face that officer faster than they can do anything to stop it. We heard, I think, quite a bit of testimony on action versus reaction. That's what that's describing. Once that suspect decides to start to turn, it's going to be too late for the officer to then engage an amount of force, a quality of force to actually stop him from doing it. So officers are not trained, and nor did I think they were trained from this testimony, specific to this case, to wait until someone points a gun at them, points a taser at them, or begins the assault against them. Is it reasonable for them to believe that if they don't do something right now, that they are in an imminent threat of death or serious bodily injury? And based on those four components and my analysis of this case, I didn't see this as a close case. As tragic as it is, I think any reasonable officer in Officer Schurr's position could have believed that that was necessary.
How do police officers, or how are they usually trained to perceive a threat posed by someone in possession of a taser during a close quarters struggle?
Yeah, it's what I just mentioned, and we heard that testimony, I think, as well, that officers are trained when someone actively takes your taser, you are trained to believe they intend to use it against you. And these are just reasonable inferences. So I got to make this very clear. A threat assessment and a response are just educated guesses by the officer. They don't know what's about to happen. The meaning they assign to all of this totality of the circumstances is based on their training, education, experience, and reasonable inferences, which is why if they don't have training, education, or experience to talk about any model policy they've never heard of, we don't hold it against them. We evaluate them based on their training, their education, their experience, and the reasonable inferences they drew from it. And so based on that, when he was evaluating the ability to turn and use the weapon, I found it was consistent with his earlier testimony and his personal training.
And is it consistent with standard police training or generally accepted police practices to use deadly force when facing an imminent threat of a taser being used against you?
Yes.
Why? Is there anything in addition to what you've already said?
Well, I think we So when we're looking at an individual officer's decision, the question is, is it lawful for them to use a quality of force to stop the threat immediately? And if it's a threat of death or serious bodily injury, what is the quality of force that will immediately stop it? Hitting him in the head with a flashlight, I can tell you from experience, does not immediately stop a threat. Pepper spray is not going to stop this threat. He had to choose a quality of force that would immediately and decisively stop the threat. The question is that reasonable? And I think you asked, is that something I consistently see across the country? I don't like generally accepted police practices as a standard or as an evaluated model, but if you're asking me, do I consistently see across the country? I have personally, as a police practice expert and trainer, talked to hundreds of officers and asked them specifically, how are you guys trained if someone takes your taser, and it almost to a person with very little exception, it's we escalate to deadly force, escalate to deadly force. If someone disarms you of a taser, you escalate to deadly force. Now, you will hear a lot of people say, well, it's under the totality of the circumstances, lots of things to consider. To me, in this setting, that's almost a cop-out. It's like, okay, well, what were the circumstances? Let's evaluate them, and then let's decide with those circumstances, was it reasonable? So to answer the question, was it reasonable for an officer to believe that deadly force would be necessary to immediately and decisively stop the threat? That is something I see consistently across the country.
And once an officer makes a decision to use deadly force, do they need to try lower levels of force?
No, and very clearly the courts have said repeatedly officers are not required to try lower levels of force and hope for the best, particularly at a deadly force encounter. The question is, are they facing a threat of death or serious bodily injury? Is it reasonable for them to believe that? And then what quality of force is necessary to immediately and decisively stop that threat?
And what are, I know you kind of said that you base a lot of this on people you've trained across the country. Is there anything else that you base this opinion on? Have you relied on anything or any of the testimony that you've heard in this case that would be consistent with that?
Well, I mean, if the question is, was it reasonable for an officer in Officer Schurr's position with his knowledge and training and understanding of his own policies, we heard, I also would rely on the trainers of the agency that trained him and the policies that he was being subjected to determine whether or not his belief was reasonable. And so I also considered that.
Now I want to move on to the reasonableness of the foot pursuit and arrest attempt. You heard Professor Stoughton and Mr. Bloomfield criticize Officer Schurr for initiating a foot pursuit. Based on your review of this case and the Grand Rapids policies, procedures, the culture, was the pursuit within the standard of law enforcement agencies across the country? Yeah,
there's again, I will tell you, there's not a concept of generally accepted police practices that you can hold an officer against. If you're asking what we see from my perspective, having looked at jurisdictions across the country, you're going to see policies that are silent on the issue. They tell the officers, they address the officer in training. They address the issue of single officer pursuit or double officer pursuit based on just be aware of the risks that are involved in that and then make a good decision or make a decision. But there are a lot of agencies that have solo officer foot pursuits and encourage them, actually award their officers for engaging in them. Because if you understand what's happening, when you have a policy that says we only want officers to run with 2 officers, or we don't want you to do a solo officer pursuit, all that policy is doing is saying in our jurisdiction we're trying to balance the risk against the officer with the risk to the community. And an agency that says we don't want solo officers to pursue a suspect are basically saying we're going to prioritize officer safety over community safety in this moment. We're going to let the guy go and let the community deal with the safety concerns because we're prioritizing officer safety. Other agencies are like, no, our officers are supposed to assume risk so that the community doesn't have to. So if someone takes off running, of course it's dangerous. And that's what we pay officers to do, is to confront dangerous criminals and to actually go and arrest people. And so in those jurisdictions, they might prioritize community safety and crime prevention over officer safety. So you're gonna see them across the country taking different approaches, and each approach is really based on how that individual agency and jurisdiction wants to prioritize at least those 2 competing interests.
And in your view, was the foot pursuit and physical arrest attempt reasonable and aligned with how a Grand Rapids police officer would approach law enforcement?
Yeah, based on the testimony, there's no prohibition on an officer doing that, and you see that all across the country. There's plenty of agencies that officers still chase bad guys.
And do officers receive training to balance the risks of foot pursuits against their duty to apprehend fleeing suspects?
Yes.
And what are some of the things that you see?
Yeah, so what is understood in law enforcement training and tactics is tactics are discretionary. There's not a single tactical solution, there's just tactical options. And when an officer is facing a tactical scenario, they have to make their decisions based on risk, benefits, and trade-offs. And they're the ones that do it in real time based on some things just like their confidence level. Are they tired that day? Are they injured that day? The officer gets to decide because there are so many variables, and I know this is true in Grand Rapids. They consider there are so many variables, they're not going to write a policy on foot pursuits because they need the individual officers in that moment to make those decisions. And so when you look at the types of things that officers consider in that risk, benefits, and trade-offs, you do look at, well, how tired am I? How far is my nearest backup? How, am I actually going to catch the guy? Is he bigger, stronger, faster than me? What do I know about the area relative to crime? What time of day is it? There are so many variables that go into that quick decision that a lot of places don't have a specific policy. And here's what's really important. All of these considerations and the totality of the circumstances of every decision, right? You keep hearing that. Do I chase or not? Well, it depends on the totality of circumstances. Understand the totality of circumstances are things that we consider in a classroom setting and we talk about them, and then we go into a training room and we operationalize them, we implement them, we do it in training so that they become aware of them. Once you're out on the street, you're not doing a math problem where you're counting the number of people and looking at the time of day. You're looking at it very quickly and saying, I've seen this before, and you make a decision. That's the heuristic decision, a rule of thumb decision, right? So we don't ask, and the courts don't require this, for officers to engage in this sort of library scholar approach to the totality of circumstances in that moment. The totality of circumstances are things we incorporate in training and in lecture, and then we look at after the fact in the evaluation. But in the moment, we expect in a critical incident, this is also in Stoughton's books, I don't think he would disagree with this, that officers are not expected to engage in slow, deliberate, rational decision-making during a critical incident. They're expected to engage in what we call fast and frugal, system one, fast, heuristic decision-making. Why that works for cops is because all those totality of circumstances are things that we put in training. And so you heard their trainer say we try to develop realistic training so that when they're on the street, I think he said I don't think he said automatic, but it's conditioned, it's automatic. Because you do not have time to do that math problem in real time, in many cases. And I think you asked that question, we'll come back to it later, but there are times when you can do slow, deliberate, rational decision-making. I think one of the experts talked about that. And there are times where that's just unrealistic to expect of any human.
And is talking about some of these tactics, are officers trained to follow a single tactical response?
No, like I mentioned, it's risk benefits trade-offs. There's tactical options. There's not tactical solutions. Sometimes you're actually encouraged to engage in agile thinking and thinking outside the box. And you're looking at a novel situation, and you come up with some weird tactic, and you go, "Hey, that actually worked." Tactics are basically feedback loops. You try them, you get feedback. You might alter and try something different. But this is happening in real time, and it's happening very quickly. And it's really important to understand that tactics, almost after any event, we could always go back in hindsight and say, oh, I might have done that different, I might have done that better. Officers are not required to try the optimal solutions. They're required to use a reasonable solution. After the fact, it is widely understood in the tactics world, you can always improve it. And using this court as an example, the attorneys will go back after this and do an after-action review and say, I shouldn't have asked that question, or maybe I was a little bit too aggressive with that witness, and they say, I probably should have handled that one a little different. Every single real-time decision-making event, which is what's happening here in real time, requires you to do risk, benefit, and trade-offs very quickly. The difference is an officer involved in a critical incident, the consequences are much greater than maybe in a court.
And do officers sometimes have to assume personal risk to prevent exposing the public to danger?
Yes, that's
others?
what we expect of police officers, and that's what they're hired and equipped and trained to do, is to assume the risk on behalf of the community.
And when someone suggests just to let the suspect go, what are the implications of that approach?
That you are prioritizing officer safety over public safety. You are predicting that if you let the guy go, that there will be no harm, but the officer will certainly be safer. The problem with that, what cops know, as we say, what officers know based on their experience, is that suspects who are let go does not mean the next time you come across them, they're not going to be more violent or armed or barricaded. We have case after case across the country where suspects are let go and the next day officers are killed going to serve the warrant. So when you hear this creative approach, is the most generous way I could say it, that you just wave goodbye and let the guy go and you can get him another day, keep in mind that they are only imagining that getting him another day is going to be safer. There's no guarantee of that. And we have officers recently in Syracuse, they let a guy go to get a warrant, served the next day, 3 officers were shot.
Object in terms of what, other instances, we don't know the facts, we don't know the circumstances, so I think that's irrelevant.
Your Honor, this is directly relevant. These are examples of things that police officers are trained to look for. As Mr. Becker pointed out to Officer Schurr, there was an example of a Seattle Police Department shooting within their training.
Within the context of the expert, he can only apply the facts in this particular case in forming an opinion. So I'm going to sustain the objection with respect to this witness, bringing up examples.
Based on your review of Grand Rapids policies and training, I believe in your, did you create a report in this case?
I did, yes, ma'am.
And I believe you pointed this out in your report. Does Grand Rapids have a policy that emphasizes confronting an individual or confronting someone who's running away, or rather than avoiding it?
Well, they do. And if I have a copy of my report. If I can read what it is in their policy specifically, if I can refer to my report.
Does he have permission to refer to his report? I think it's on, and actually I think I have it here. It's Defendant's Exhibit E2. Or, sorry, it's the Manual of Conduct. It's E7, I think, Bob?
He said he needed to refer to his report, which he has in front of him.
Oh, okay.
To help him answer the question, I believe.
Okay.
Yes, ma'am.
Yeah,
So,
sorry.
So the answer to the question is yes. In Grand Rapids written directives, as I detail here, the Manual of Conduct, paragraph 12.1 B through F, employees shall professionally and completely perform their assigned duties and the responsibilities of their positions. Employees shall perform their duties in a manner that is compliant with the highest standards of efficiency and the goals of the department. Unsatisfactory performance may be demonstrated by unwillingness or inability to perform assigned tasks, failure to conform to work standards established for your rank, grade, or position, failure to take appropriate action on the occasion of a criminal act, disorder, or other condition requiring or deserving of police response, the neglect of your duty, or the display of cowardice.
And what did you interpret that to mean in the context of this analysis? Or how did that apply
Well,
here?
when Grand Rapids police officers are making decisions on whether they pursue or not pursue a criminal, or whether a criminal has decided they want to be arrested or not to be arrested, that they have this guidance that they are actually being encouraged to take appropriate action on occasion of a criminal act. They're being encouraged to actually enforce the law and to not shirk from their responsibility to act just because it's dangerous to them.
And is this consistent with standard police practices in Grand Rapids or anywhere in the country?
Yeah, so whenever I do a report or review of a case like this, it's one of the first things I look for, because it's very consistent now, particularly, it's very consistent now in these types of cases where we're seeing things like, just let the guy go, just let the guy go, from some experts. And so we're constantly having to go to the policy of the agency and say, that is absolutely inconsistent with the expectations of the agency itself who trained this officer.
And I know there's been this generally accepted police practices term that's been thrown around. I and I guess we'll talk about that in a little bit, but is it consistent that a police officer's tactics, if a police officer's tactics are imperfect, that they lose the right to self-defense?
No, nowhere in the country are officers been trained that if their tactics are suboptimal or imperfect or don't comply with some concept of generally accepted police practice, that they lose the right to defend themselves or that they lose their law enforcement authority.
And in your opinion, does choosing not to engage in a threat shift the risk from the officer to the public and to other officers who may have to confront the suspect in the future?
Right, so that's what I mentioned earlier, that when you stop, when you pull back for officer safety, for safety yourself, you're basically deferring the danger to the next person who has to confront this person and actually arrest them.
And in this case, was Officer Schurr's decision to pursue the suspect a reflection of that duty to assume the risk as a police officer?
Yeah, I don't know what he was thinking, but what I saw was consistent with an officer who was assuming personal risk rather than letting the guy go.
And throughout this trial, did you hear Professor Stoughton and possibly Mr. Bloomfield say that Officer Schurr's decision to deploy his taser at a close range was inconsistent with law enforcement training?
Yes, I did.
Do you agree with that?
No, and I think we heard plenty of testimony at this point that it's a close-range cartridge. It's designed to be used in close quarters. There's no prohibition on using it there. If it's used and it doesn't work immediately, there's a third point of contact. I have not ever heard that it's not. I think part of the argument was that he stood too close and allowed him to take it. And again, that's shifting consequences of the suspect's behavior to the officer. An officer can stand where he needs to stand. It would be tantamount to saying if an officer gets punched in the face, he shouldn't have been standing so close, and therefore he's responsible. That's the logic behind that. Deployment in close quarters was unreasonable because it allowed him to deflect and allowed him to take his gun. It's just a use of force. That's what it looks like. They're imperfect and they're ugly, and after the fact, you might have wished you stepped back or you might have wished you stepped closer, but there was nothing that made that unreasonable, even according to the Taser guidelines.
And the suggestion from some of the opposing experts suggests that the officer should have disengaged at that point. Are officers trained to disengage when a suspect is attempting to disarm them?
No, and what I noticed about that is as long as Officer Schurr was fighting for that Taser, then he was not facing a risk of death or serious bodily injury so long as he maintained possession of that Taser. He was fighting to avoid, I'll say he was fighting, I don't know why he was doing it. What I saw in the video and what I heard in his testimony was consistent with an officer who is fighting to maintain possession of that Taser precisely so he doesn't have to escalate to deadly force. He's fighting to not have to shoot this guy because, as we heard, once he gains sole possession of that firearm, we go back to intent, ability, means, and opportunity. Right now, if you can infer intent, ability, and opportunity, the only thing he didn't have was the means. And Officer Schurr fighting to prevent him from accessing that means meant he didn't have to shoot him.
And based on your review, was Officer Schurr's attempt to retain his Taser and get it back consistent with a reasonable officer's effort to avoid having to resort to deadly force?
Yes, it was.
Have you ever been tased?
I have.
Can you tell us about that? How did it feel?
The experience of being tased with probes was, for me, I challenged the guys. We all did this. You're going to tase. I've been tased multiple times, and I say, if I get to you, I get to hit you, right? It gives you that mindset of I'm really going to try hard. And I couldn't move. I got tased. I couldn't move. You're just stuck. You can still see, but I was totally immobilized, and I had people catch me. That was not the worst experience. It hurt. It stopped me. I couldn't defend myself for sure. The worst one was I was grappling, not in a fight, was grappling almost in a training scenario, when another officer drive-stunned me on top of the head to break up the grappling match. And I had that experience, and it was it was brutal. You heard from Dr. Kroll, it's the first time I heard that explained. Everything stopped. My eyes slammed shut. There was electricity that I saw. They told me it wasn't actual electricity, but everything stopped. I could not think of anything. My hands went straight up. The benefit was he just did it and stopped. He didn't hold it on there. But it felt like a stake was being driven into the top of my head, and there was nothing else important in the world other than to make that pain go away. And it made it worse, as Dr. Kroll pointed out, because I didn't know what it was, I wasn't expecting it, and it was a pain like I'd never experienced before.
And once you felt that pain, what happened? What happened? Were you able to do anything else at that moment?
During that pain, no. Until it was done, there was nothing else I cared to do other than make that thing go away.
Did it feel like someone pushing your head with their thumb?
No.
We talked a little bit about this term, but can you explain the term generally accepted police practice in the profession?
Yeah, I can tell you what it's not. The generally accepted police practice are not a national standard. There were certain, if you're looking at things that we see consistently across the country, yes, there are certain things that are consistent, but that's not a standard by which we hold officers accountable to. They're generally accepted police practices are just things you might see consistently. When you heard about, for example, PERF and IACP and DOJ consent decrees and Lexipol, all of these organizations might have sort of model policies, sort of maybe procedural policies, and some of it's going to overlap. And all that stuff that overlaps, you can say, yeah, this is pretty consistent across the country. These are things you see frequently. What is critically important is that those organizations frequently do not agree on what those practices are. Some of those organizations, like the Police Executive Research Forum, their whole purpose is to elevate policing beyond the U.S. legal standard, beyond the constitutional standard. They want it to be harder for police, and that's their stated purpose. And so they're going to make certain recommendations that are consistent with that. IACP is probably the largest body of model policies, and they're trying to be able to write policies and considerations for the broadest range of police. And they're very attuned, because I'm on their legal officers section. IACP is very attuned to the cultural and political pressures that are on police, but they're also very dedicated to focusing on operational and tactical realities. And so if you look at history, you're going to find that what was being told to you are generally accepted practices. Those very organizations have had very strenuous debates about what is and isn't an acceptable or generally accepted police practice, or what the standard should be. DOJ civil rights, you heard this little idea about generally accepted practices will percolate up from the industry and that these organizations merely reflect that. That is not how that works. Those organizations some of them are activist organizations, some of them are political organizations, some of them are educational organizations and associations, professional associations, and they all have different priorities. What they're trying to do is, from the top down, influence the industry. DOJ consent decrees, for example, they're the opposite of generally accepted police practices. They're actually trying to get organizations to adopt certain standards under threat of litigation. These are standards that aren't generally accepted by police, but that the DOJ civil rights consent decrees can force them on organizations under threat of litigation. So if you're looking at generally accepted police practice, the only thing you really need to take away is they are not national standards, and they are not a standard by which you would judge an individual officer's performance who has never even heard of these standards.
And did you hear Professor Stoughton's definition of what he believes generally accepted police practices are?
I did.
And without going into all the weeds of that debate, do you agree with them?
No.
Why not?
Again, what he was imagining is that all of these various international organizations and associations somehow has some consistency among them that create a national standard. But each of those organizations have documents within the organizations that specifically say these are not intended to create a national standard. Local agencies are only to use these for consideration in developing their own policies.
And I think you heard or you saw the testimony of Captain Siver.
I did.
Earlier in the week. And Mr. Becker had questioned him about the IACP considerations on foot pursuits. Do you remember
Yes.
that?
Yes.
And I believe, is this the document you showed? Okay, so this is the foot pursuits July 2019 IACP considerations packet. On this, it talks about the considerations, concepts, and issues, and need to know. Do you know what these terms mean from the IACP?
Well, they have definition sections, and I'm happy to read them, but generally speaking, a model policy is a starting point. It's a framework that people can look at. Essentially, the way I look at a model policy is that you can go home and cook yourself a meal, and you can do it from scratch, or you can go to a buffet who's already cooked the meals, and you get to pick from the buffet which ones you want. So a model policy is sort of that. It's what we did at Lexipol. We create a starting point for you. It's supposed to be more efficient. Ideally, it reflects various, the federal law, your local laws. But when we do a model policy, by the way, model policies do not ever automatically transition into a local policy. There's a process for that. But it's like just an off-the-shelf convenience. That's a model policy. What that is a considerations paper. It is by definition not a policy. It's just interesting things that smart people have thought about, and they're like, hey, as you guys are developing your policies, here's things we think you should think about as well. Here's things we think you should consider.
And just looking at this document, it says under considerations offered as an alternative to the bright line directives found in model policy, instead of providing exact policy language, the considerations document outlines items that agencies should address and provides options that agencies should examine when developing their own policies on the topic. Is that your understanding of what that means?
Yes.
And how do you train officers or agencies to create their policies? How do agencies look at these types of consideration papers when creating their own local policy?
Well, I can tell you what's a consistent across either CALIA, which we heard a little bit about, or IACP, or DMS5, or Lexipol. I'll use Lexipol because it's one I'm most familiar with. When you take a model policy, Lexipol is not going to defend the policy in court. What we do is we call air gapping it, because we understand when we write the model policy, ultimately the local jurisdiction is the one who has to own those decisions. And so they're going to take our model policy, and what we would encourage them to do is work with their senior law enforcement officials, their prosecutor's office, their legal advisors. We're going to ask them to talk to their politicians. We're going to ask them to talk to their officers. All of those stakeholders are going to become part of what in this model policy do we think reflects our culture and our capabilities and our resources, and what do we just absolutely reject? We don't like that at all. And there's plenty of examples within each policy of things that they can choose from. So some people don't like the carotid neck restraint. They just think it looks bad, and so they don't want to have it in their policy. They'll say, we'll keep that at deadly force. Other ones like, nope, it's incredibly safe. We're going to put it down there with pepper spray. Fine, those are their choices to make. So when we look at this idea of the stakeholders meeting to decide what in the model policy do we like, what are we going to incorporate, we expect it to involve their legal advisors, we expect it to involve their police officers. Once they've done that, we also would like it to include their community members. And so you'll have community listening groups, or you're going to present these policies. I recently did this in Bakersfield, California. So you'll have the ACLU there, you'll have community members, you have your local police, and then you'll have someone like me to come in and talk about what are generally understood concepts and concerns about use of force investigations or use of force in practice. And then in those listening groups, the community then gets to say, we like that or we don't like that. That's where you might see a community says, we don't want you chasing bad guys. We don't want you chasing them through our cities. Other ones are like, we absolutely want you chasing them through our cities. And that's where those policies are ultimately shaped. Once the local government, right, whether it's the chief of police or through their politicians, however they decide to approve it, they decide how they want to craft it based on their resources, their risk assessments, their insurance requirements is a big part of it. They will then adopt it, and we call it air gapping it, because once they adopt it and they own it and they sign it, Lexipol's no longer on the hook for the decisions they made, because they made those decisions based on their local considerations.
And in evaluating Grand Rapids police officers' conduct, how would someone compare that to the national ideal? Would it be something that would be compared to these national standards or the department's policy and constitutional law?
Now, ultimately, when they're doing the crafting of it, when they're taking these model policies and they're bringing it down to their local, that's where those discussions are being had and those considerations. But once they've made their decisions, the binding policy, the binding expectations on the officer is what they're trained against. And again, we have a concept called operationalizing policy. We can't hold an officer accountable to their performance on the street simply because a piece of paper has words on it. What has to happen, once that piece of paper with words on it is approved by the local jurisdiction, it then has to get incorporated into training. Then they have to train against that policy. Sometimes they have lectures and then they put it in their training. And then when they get out on the street, it's become operationalized, so long it was good training. Then they know how to incorporate that policy. National standards or these national policies that haven't been incorporated, haven't even been approved by the local jurisdiction, certainly have not been operationalized. The officers may not even know about it. And this is something I have to remember, is I deal with this every day across the country looking at all these. A local police officer has a hard enough time just knowing their own policy and trying to conform with their own policy. I've not seen where local police departments with their own policies have suddenly decided to hold an officer accountable to a policy they've never even heard about, and certainly doesn't apply in their jurisdiction.
So when a department like Grand Rapids adopts a use of force policy reflecting its specific legal, political, and operational realities, I think you said, is that in line with, I guess, generally accepted police practices or standards across the country?
Yeah, so we like best practices or generally accepted police practices when it comes to processes and procedures. We don't like them with tactics. Like, tactics is too much variety. But if you're asking me, is it generally accepted as a policy development practice? It absolutely is, yes.
And just to reiterate, based on your understanding of the Grand Rapids Police Department policy, Michigan law, and the circumstances, is it your professional opinion that a person similarly situated with the knowledge of Officer Schurr could have reasonably believed that he was in fear of serious bodily injury or death after he was disarmed of his taser after fighting for over 2.5 minutes until he could not fight any longer?
Yes.
Thank you.
You want to take another break here, Honor? You said we were going to take 2:10 and it's already 10 to 4, so I didn't.
Take a break or
Less than an hour, so just.
yeah, I guess we'll take another 10-minute break like I promised. So we'll come back at 4. So meanwhile, please remember to leave your notes upside down in your chairs and not discuss the case with each other or with anyone else. Also, continue avoiding any news reports about this case in the media or on social media, and then we'll see you back at 4. Thank you. You may be seated. And recess for 10 minutes. Or 8 minutes. All rise, please. Thank you. You may be seated.
Welcome back. I'm Lauren Baker. The defense has continued to argue their case for the innocence of former Grand Rapids police officer Christopher Schurr. He's charged with second-degree murder in the killing of Patrick Lyoya. 2 witnesses have taken the stand since the defense opened up today's testimony, with Christopher Schurr himself taking the stand earlier today.
What have you been trained going all the way back to the MCLS Academy as far as action versus reaction? What have you been trained?
That action beats reaction.
And what does that mean here in that scenario for you?
If I had waited for him to point it at me, it would have been too late.
And What were you fearful of?
That he was going to use it on me and I was going to die.
Now, and you were in a proximity to each other that he could do that to you?
Yes.
With how you've been trained about that device?
Yes.
Under your training, Chris, are you required to wait to be seriously injured or killed before you can resort to deadly force?
No.
So what did you do next?
I shot him.
Why?
I believe that if I hadn't done it at that time, I wasn't going to go home.
Schurr spent hours on the stand testifying to both the defense and prosecution and was asked many questions directly by the jury. Take a listen to their questions and the responses.
First, is the safety on the taser an on-off switch, or does it need to be held in the on position?
Good question. It's called a safety switch. It's an on-off. It's like a light switch. So it was on. I switched it on. It actually is some tension. I don't know the amount of weight to turn it on or off, but once it's on, it's on. It takes actual decent amount of physical pressure to shut it off.
And next, does writing a statement or a police report require you to write in the moment of the incident or for accuracy of what happened?
I think I get what.
Is right in the moment.
Yeah, I would. All right, if I answer that, I think I know what they're. If I understand the question correctly, I feel like there's I guess what I've been trained to do, there's kind of a difference in some part of it you're using the video, and then parts they have you just kind of go more or less off your memory for different various portions.
And the next question, in the beginning of the video, when the subject assaulted you prior to running away, at that time, is it okay within GRPD policy to use the taser prior to the tackle or in place of the tackle?
So that's kind of a loaded. To answer that, the strike could potentially justify under GRPD policy the use of the taser. However, using it on a subject that's running away, causing them to lock up and fall, especially around concrete vehicles, they hit their head, they could die using it or applying it in that manner, if that answers that question. So typically we're not trained to use it on someone who's running.
Well, the question asked about prior to running away, so as you
Oh, prior, well,
were on concrete, so.
Well, I think he starts to run at that point. So
Well, the
I
question
think
is prior, in the beginning, when the subject assaulted you prior to running away, at that time, is it okay?
Oh, prior to running, actually physically running. I would say yes, but the amount of time it takes me to get my radio out, he's already running at that point. So then we're in that same situation that I was discussing, if that makes sense. I think it would be petty to deploy a taser for what he did. That, for me, that's my opinion, based on just that information.
And next, did you feel at any time prior to you presenting and deploying your taser that the subject was trying to grab or obtain the taser or any other weapons on your belt?
Was the question prior to?
Did you feel at any time prior to you presenting and deploying your taser, the subject was trying to grab or obtain the taser or any other weapons on your belt?
Prior to deploying the taser, I didn't feel as though he was trying to grab any weapons.
Next, do you recall being able to smell alcohol on Mr. Lyoya during your first interactions?
No. The entire goal was to get the Taser back. I couldn't get it back. The only thing I could potentially get my fingertips on was the safety at that point.
I know I asked about alcohol during your first interaction, but at any point did you notice he was under the influence?
I didn't smell it or notice it in those moments. Based on his actions, I would believe it, but I wouldn't just say because of him not responding to some of the tactics automatically means that he was under the influence. So I guess the answer is no.
Next, when you write a statement or a police report, what is the process?
Depends on the report. If it's a more involved report, we'll review video as much as we can and then type it, and it might go back and forth.
Do you require running through new scenarios each time a new model Taser is introduced?
You definitely do different you do scenarios when you get a new Taser, for sure. However, when it might be the same scenario, when we switched to the new model, the bigger thing was the effectiveness at close range because of the design of the cartridges itself. So, and we didn't have to worry, the way the cartridges were designed were better for close, we didn't have to, I don't want to get into the actual design because I can't remember the original Taser. I hardly remember the one that I used in this, but the big thing was it was more effective at close range and to train to use it in that manner.
Next is, why do you shoot Mr. Lyoya in the head?
I wouldn't say that I was necessarily aiming per se. I only had essentially a viewpoint of his upper back and head area. I deployed my handgun and fired it in that direction. It ended up striking his head.
Mr. Dodge, did you have any follow-up questions from any of those?
I do not, Your Honor.
Mr. Becker, how about you?
I'm done, Your Honor.
I don't see any other hands. Oh, there's one hand raised on the jury. Next question is, when is running a license plate allowed? Is driving too slow reason enough?
To my knowledge, we can just drive around and run license plates whenever we want. And to answer just driving too slow, I guess potentially driving too slow depending on the speed limit you're in. I guess if you are exceedingly below the speed limit, yes, that is a traffic violation. That wasn't necessarily what I was stopping him for that day.
Today marked the first time in 3 years that Schurr will have that he actually spoke directly about this incident. We want to take a moment to bring you back to the day of the incident and what happened to bring us to this moment.
8:11 a.m., April 4th, 2022. A Grand Rapids police officer pulls over a tan Nissan Altima near the intersection of Griggs and Nelson Southeast on the city's southeast side.
To the proceedings in the courtroom, let's take a listen in.
to make sure this, your testimony, For Science is a business. It's not, it's got science in the name, but it's a business.
Yes, sir.
And business is trying to make money as a business. It's not a nonprofit, right?
It is not a nonprofit.
One of the things being a business, it caters to law enforcement. I think I've seen you say that one of your largest influences in the law enforcement industry, right?
Absolutely.
Because that's who your constituents are. That's who you market to.
The answer, since I came on, that was actually something that was a problem when I first came on in 2018. The perception was we only really were marketing to police. One of my jobs as the Director of Consulting Communications was to expand that. And as a Director of Consulting, I've gone to great lengths to expand it beyond law enforcement to civilian, where a lot of our cases now are civilian cases and a lot of our audience are not police. But you're absolutely correct. Historically, before I came into the company, they had a reputation for really focusing on police training. And it's still a large part of what we do. We haven't expanded as much as we'd like yet, but you're absolutely right. It is still a large part of our audience.
Now, part of that being part of your audience, you yourself has described yourself as a cop with a law degree, right?
Yes.
And you're very proud of that. You want to be a cop.
I love being a cop, yes.
Love being a cop. You said cops are one of the good guys, so that's why you want to be a cop.
Say that again?
Cops are the good guys, so you want to be a cop.
Well, I give them the presumption of regularity, and absolutely, yes.
Sure. Well, that was one of my other questions, because you go on a number of websites. When you start, you give police officers a presumption of regularity, the benefit of the doubt, if you will.
Yeah, so when we start, we give them, especially in a case like this, we give them the presumption of innocence. That's the first thing. And then we give them also a presumption of irregularity, and then we start to look for deviations from that.
But if you start with a presumption of regularity, that's not unbiased, right?
No, I'm not unbiased, and the reason for that is because when we as a community hire our police officers, train our police officers, they get background investigations, they're then trained and put into these conditions, that my starting point just as a community member is that I can give them the benefit of the doubt. Now, in my job, I certainly see a lot of bad examples of policing, and so they can lose that benefit of the doubt. It's theirs to lose. But yeah, just as a community member, I do give police the benefit of the doubt.
Okay. And you also have stated that For Science has a reputation that there's not a cop out there that you would not defend, right?
Well,
those are your words.
Yeah, since I've been on, that's not our reputation anymore. We do a great job of trying to explain, even in court or at our conferences. My job specifically is to change that narrative since at least 2018, 2019. It's absolutely not true. There are plenty of cops. We don't defend cops, by the way. We just educate juries and evaluators. But there are a lot of police officers whose cases we review that we do not have anything to say that's going to be helpful to their case. And we make sure that the communities know that and that the jurors know that.
Now, part of the thing you put out, you have a website, For Science website, that you have articles you put up.
Yes, sir.
And you went on that website, you got 3 of the top articles for 2024, your own articles. Do you get to vote on that, or are your staff trying to kiss up to you a little bit?
No, the article selection on top articles are based on the number of readers and how many people push them out. There's no people involved. It's really a statistical analysis of how broadly the reach was on it. So there's no voting on it. Okay. I would vote for my articles, though, in fairness.
Sure. But those articles were, the first one was Homicidal Empathy, an Evolving Threat to Police Officers. That was what you wrote.
Right.
Next one was Officer-Created Jeopardy, a legal theory that threatens effective policing.
Absolutely.
The Expert Trap, protecting police from unreasonable expectations.
Yes, I think that was the Michigan.
So those were all yours. Those were all your articles. Those were what you wrote about: protecting police, threats to police, threatening police. Correct?
Yeah, and those concepts
that's
against police officers.
I didn't need that. I just correct. Didn't ask you to explain.
You want to rephrase it? I want to answer them, but go ahead.
Yeah. Well, that wasn't my question. My question was those were the 3 things you. The 3 articles that were there are all about threatening police, protecting police, how to save police, essentially. Correct?
Essentially, no. So if I can elaborate that, yes, it incorporates
I didn't
police.
want to elaborate. This is not your chance to just talk.
Objection, Your Honor.
I ask
You should be able to finish answering his question in the same way that Professor Stoughton was allowed to answer every single one of Mr. Verbulla's questions as a long narrative. So at least let him finish his answer, please.
He's going beyond my question. I'm asking a simple yes or no question, and he wants to pontificate. So,
essentially, no, is my answer.
Okay, so I didn't rule on the objection. So, I mean, I believe the witness should be allowed to complete his answer, but also not go into
One of the other articles in 2024, maximizing the officer's recollections before the big interview. That was one of the articles that was on Force Science in 2024, correct?
Yes.
Need to look at it? I can show it to you if you want to look at it.
Yeah, I'm assuming you're pulling these from the website?
Correct.
Yeah. This is what year? 2024,
Last year,
yeah.
2024.
I don't think I wrote that one though, but yes.
You did not write this one. But part of this, the big interview is officer-involved shootings. That's what the big interview is talking about, correct?
I would consider that a big interview, yes.
Sure. One of the things they talk about in the article is perhaps the optimal solution is to conduct face-to-face interviews as part of the attorney-client preparation phase, where nothing is generated during the unclean recollection process will be discoverable under the attorney-client privilege. So you're advocating, your article's out there saying police officers should interview their attorneys, go through it once before they do an interview with the fact finder. That's a fair statement?
That's not my article, sir.
Well, but you're the chief communications officer. Buck stops with you, right?
I am the editor, but I do not write every article that goes in there.
But aren't you responsible for what goes out on your website? You're saying you're not responsible for stuff like this?
I will not adopt every sentence that an author writes, particularly if I haven't read it. I may very well agree with the statement, but he's only providing me a small snippet, so I'm not going to tell you that I agree with everything. I don't even wrote that. Was it Geiselman or?
That was Greenman?
Greenman, yeah. So I can't adopt everything Greenman said. Oftentimes when we publish stuff, it's basically for the industry to consider, and they'll decide whether they agree with it or not. We're not endorsing everything we publish. We find it interesting for the audience, and the audience can read it and adopt it if they choose. Much of what goes out I do agree with, but without reading specifically every sentence, I don't know that I agree with everything Dr. Greenman said.
Well, this is another one on your website. It's from 2018, but it's still on your website. Veteran attorney cites 10 ways to lose police lawsuits.
Okay, this is before I worked there.
Before you worked there, but it's still on your website. I mean, you can't distance yourself from something you're the boss of, can you? And just say, I mean, you say you're trying to put good information out for police on your website, right?
Yes.
So, yeah, if you got bad information out there, you probably want to take it down, don't you?
No.
No.
You want me to explain that?
No, not really. So you talked about Lexipol. Lexipol is Bruce Pratt. Bruce Pratt, was that the CEO?
No.
Okay. He was not the former CEO and co-founder of Lexipol.
He was a co-founder of Lexipol. He's an attorney out in California.
Okay.
Yes.
But did you know him? Because you said you worked for Lexipol, right?
I know Bruce Pratt, yes.
Okay. So you worked with him?
He did not work for the company, but when I worked there.
All right. And one of the articles in this article, he talks about how to save police from lawsuits, and is how to clean up injured suspects before photography.
Yes.
Okay. Bloody pictures of suspects injured by police don't help your case in civil court.
Correct. He said that, yes.
He said that, but this is a publication on your website that you're sending out there.
For Science?
Yes. It's. Do you not see? Is that the FS right there? For Science.
Oh,
take a
from
look
Chuck
at it.
Remsburg. Okay, that's Chuck who wrote that.
Okay. It's out there on your website. Focus closely on the actual injury. Get him to smile for the camera if you can. And don't include pictures of bloody gauze. That's on your website about how to handle people who are injured by police in incidents?
It apparently is.
Do you have a problem with that?
Thank you. In fact, that was the specific issue that Bruce Pratt and I talked about, and I would agree that that's absolutely inappropriate. It was one of the few conversations I had with Bruce Pratt. The reason these things are on our website is because if you look at Force Science News from the beginning of 2000, whenever it started, there's hundreds of articles there. And one of the things that we do like about it is almost an encyclopedia of looking where police was, what has evolved over time, what has stood the test of time. There are a lot of articles back there that we would look at now and say, yeah, that's not how we do things today. but we maintain that library to show an evolution of policing, and it's very effective for that. So there are a lot of articles that we could sit here all day and I could go, yeah, that's not one I would agree with. I don't think it reflects modern policing. However, we leave those in there because it is an amazing library to look at the history of policing through that time frame.
So you're saying 2018, veteran attorney cites 10 ways to lose police lawsuits. That was 2018. But in 2024, we have evolving threat to police that you wrote, legal theory that threatens effective policing, and protecting police. So where's the evolution there?
The evolution I'm talking about is a much broader from police practices and legal approaches and how the law changes over time, how technology changes over time. That's the evolution I'm talking about. You're looking at a small snippet of articles that I don't think I wrote and were probably before my time.
The 3 from 2024, that you wrote those, you admitted those. The 3 the last ones I mentioned were your articles. You wrote those, you admitted that.
My articles are great, yes. I'd adopt those.
Okay. Part of this, we've talked about it a little bit before, but Force Science is primarily law enforcement officers who are or former law enforcement officers or actual law enforcement officers that are actually employed as on staff, correct?
I don't know that's, we have 1, 2, 3, 4, maybe 4 of 8 people, or actually more than that, see 1, 2, 3, 4, 5. The answer to that's no.
Okay, I went on the website, we can pull it up if we need to.
Well, you
You've got five staff instructors, correct?
Oh, you want staff instructors or
Staff
employees?
instructors, 5, okay, let's go staff instructors. The people are instructing, 5 of you, right?
That sounds right.
Okay. Mr. Lewinsky, now he's not law enforcement.
Never police.
Never police, but the other 4 are. You and there's 2 other commanders, the other 4 are former police, correct?
It's likely. We definitely are looking for highly educated former police officers to help educate the population we're interested in, yes.
And then you have 19 partnering instructors. 9 are retired police, and 1 is a lawyer, Laura Scary. Scary. And her work was defending police officers in civil and criminal suits. Is that a fair statement?
You'd have to ask her what the bulk of her work is.
You don't know? I mean, you work with her, don't you? I mean, she's listed on the website as a staff instructor.
Yeah, to understand, I don't work with any of these instructors. I mostly teach them. I say I don't work. Nicole Flores and I teach quite a bit. The rest of them are off teaching classes. I'm the director of the consulting division. The classes I teach by myself or maybe with Nicole. Every now and then I might partner with one of them, but I'm not part of our what I call off-the-shelf training programs. So who's currently teaching, I'd have to look, and I might be surprised at who our new staff is as well. But if your point is, do we have a lot of former police officers, the answer is yes.
Now, even though Mr. Lewinsky is not a law enforcement officer, he was inducted to the National Law Enforcement Hall of Fame in 2023, wasn't he?
I think it was a Lifetime Trainer Award, yes.
Okay. You just gave a presentation at the National Law Enforcement Hall of Fame induction ceremony, didn't you?
Yes.
That was just a few weeks ago.
It was.
And that was in partnership with Virtra. I heard from, is that how you say it? I can't say that. I've tried to say it.
Virtra?
Virtra.
Yeah.
Okay. That's Lon Bartels. That's his organization.
Lon Bartel. That's who he works for. He was not part of that training.
All right. But you've trained with him in the past, though, haven't you?
Lon?
Yeah.
Yeah, as often as I can, yes.
As often as you can. How many times have you trained with him in the past?
Taught classes together, maybe 3 or 4.
Okay. Done other presentations, though, with him? I heard about the SHOT Show that you did with him?
That's one of them, yeah. What we try to do with Virtua is bring their simulator in. So we like to get the community into the simulator so that they can experience what police officers are. That's what Virtua does. So we bring them in as often as we can because they've got amazing technology.
So I guess if I understand you correctly, one of the things is the consulting group, you're the head of the consulting group for Force Science, right? Right. So one of the things you do, I've seen it on just about every podcast, you kind of give your plug for your podcast. Hey, if you've been involved in an incident, fill out a form, send it into here, we'll talk with you, make sure your attorney's present, and we'll go over your case. That's kind of what you do, correct?
Yeah, that's our pre-consult process.
Pre-consult process. And you want to make sure their attorney's present so you don't get subpoenaed, right?
It has nothing to do with the subpoena. It has to do with there is no attorney-client privilege between me and the officer or the civilian who's involved in the incident. So their attorney needs to be present so that they can protect that relationship and the disclosure. Otherwise, essentially, they're not able to tell us enough information that we can have an intelligent conversation. So as a protection for the people calling us, we want to make sure they know, hey, when you call us, make sure your attorney's with us. So that way, it's a privileged conversation.
So you can't get subpoenaed to whatever they tell you?
Well, I could still get subpoenaed, yes.
But you can't tell them anything. You can't tell anything if there's an attorney there, there's attorney-client privilege. If they're not there, you're free to talk to anybody about what happened.
Right. Well, no, that's not true. We still have our own confidentiality. So we will, if there's no attorney-client privilege, we're still going to not disclose the contents. If we are subpoenaed and a judge tells us that we have to disclose it, of course we will. But we still have a professional confidentiality agreement that we're not going to tell people about those cases.
Now, in terms of that consulting, isn't it true that you've said 98% of the cases you see in Force Science are absolutely professionally well-done cases, officers not at fault?
Yeah, they fall within a reasonable range of options, yeah.
So 98% of the time, when somebody calls you, we want to consult with you, 98% of the time, the police officer is correct?
Overwhelmingly, police officers across the country are correct in their decision-making. I don't think you'll find statistics that disagree with that.
That's almost 100% success rate for any profession. That doesn't strike you as a little bit odd?
No. I mean, 98%, I don't have an exact percentage, but I'm telling you,
those
on
were
the
your
cases
words.
we see, right?
But I'm just quoting your words. It was on one of your podcasts, remember, Law Enforcement Today, choir practice, some guys, you had a bunch of bourbon in the background, two guys. Those were your words. 98% of the cases we see are absolutely professionally well-done cases. Those are your words.
Yeah, that sounds about right.
What kind of put you on the map was a 2000 article in Police Marksman, why the subject is shot in the back. That was kind of one of your big articles. That kind of put you on the map, didn't it?
Not me, no.
Well, okay, you're correct, but Mr. Lewinsky, your founder, that was one of his big
Bill
research.
wrote that.
Okay, but that was one of that kind of got you on the map, didn't it?
I think the concepts behind it certainly did.
You're aware you're heavily criticized in a number of different courts for science, isn't it?
I'm not.
You're not, but Force Science is. They got a case from Federal District Court in Florida. Force Science is widely regarded as a purveyor of unreliable pseudoscientific analysis engineered to justify officers' use of force. Its studies virtually are all non-peer-reviewed, and none of them have been published in scientific journals.
Yeah, that's absolutely not true, and anybody who tried to present that to a court would be in violation of an ethical duty of candor to the court. I'm sure you've looked and seen that there's over 30 peer-reviewed studies on our website in some of the highest rated journals in the industries. So whoever advanced that position to the court was essentially lying to the court.
It was a court's opinion. You gotta take a look at it.
I don't need to, I've seen it.
He already said it wasn't him, so what's the relevance for this?
That's actually, I'm sorry, go, yes, ma'am.
No, that's fine, we'll move along. You talk about going to universities, Cumberland University, to train kids, train the kids at the universities, correct?
There were kids there. That one was actually open to community and politicians and law enforcement as well as the students.
But you've had, this is always a bad thing, and we're gonna bring up Ohio State University in Michigan, but Ohio State canceled trainings because some of the classes where attendees could learn how threatening suspects can be shot in the back by a well-trained officer who made a valid, lawful shooting decision. So Ohio State canceled the presentation there, didn't they?
They did.
You've been criticizing the New York Times and other mainstream media, but you're okay with that because that means you're over the target, doesn't it?
The New York Times article was before I was there, it was 2015. It was basically an opinion piece. The author was given an affidavit to demonstrate that what he was putting in the opinion was incorrect. His response to us was it doesn't have to be correct, it's an opinion piece. There was a lot of fabrications in the opinion piece. We sort of let it go. And if you want, I had to actually research this because it was well before my time. The New York Times opinion piece was ultimately created by people who oppose us in court. So if we're effective in court in educating juries in a way that's inconsistent with their theory of liability, they're going to write opinion pieces that are unfavorable to us, yes.
And one of the things you do is you use this testimony to go out and then talk to other police officers. You testify in court and then you give presentations about what happened in court, don't you?
We do. That's a feedback loop so we can get lessons learned and kind of understand what was important to the jurors or what sort of arguments the opposing sides were making so we can sort of educate the industry.
So you did talk in Michigan, the Police Officers Association of Michigan, October 10th of 2024. You talked about officer facing 48 years, six others charged, and you talked about your experience in Colorado when you testified for a police officer, correct?
I don't know that, was that a presentation?
Well, that's what I got. It's a webinar, highly anticipated webinar.
Oh, this was at Caliber Press. That was not in Michigan.
Well, it's to the Police Officer Association of Michigan, but
They were Caliber Press is one of the largest police training organizations. They wanted to do a webinar to discuss the facts of the case that they were interested in, and then found out we were involved with, and so they hosted a webinar. It looks like they were advertising that webinar.
But you talked at it.
I was on that.
You were on it. You were the star person. It's Vaughn and Jim will dive. Jim Glennon. Vaughn and Jim will dive deep into the tactical and legal implications of the case. So you talked about it. You went to the police on a webinar and spoke about it, right?
Yeah, this was a high-profile national case where Caliber Press itself didn't understand the facts of the case, so they brought in somebody who was familiar with the facts. I got permission from the defense team to discuss the case as part of educating the community on what actually occurred in that case, because the media and the facts that were being distributed looked nothing like the reality that the officers were experiencing. And so that was one of the mechanisms by which we could educate the community on the reality of that particular incident.
It's also one of the ways you can kind of promote force science, right?
Yeah, everything we do that has force science's name behind it is a promotion for sure.
Well, not only that, but when you go, just about every time I've watched your podcast, one of the plugs is after you say we're consulting, you advertise, hey, come get certified as a force science analysis, don't you?
I don't know that I do that enough, actually. My marketing guys tell me, hey, don't forget to tell people about our training classes. So oftentimes when I do a lot of public speaking, I try to remember to give those advertisements, those plugs for the training that's going on. We think we have a very good product that's important to the community and to the attorneys, and we want to make sure they're aware that those products exist so that they can take advantage of them.
And $1,600 a person, that's one of the ways you pay your bills as a business, isn't it?
Yes, and that's incredibly low. It's a week-long class. It's a good investment for the individual officers for sure, but it's actually probably worth quite a bit more than that.
And in terms of that, how many of those trainings do you do a year then?
I don't know.
You don't know?
I don't know.
Going into those trainings, I did find an article about somebody was saying how wonderful your training was. It was on force science, but you had Laura Scary, an expert in police litigation and management. Her expertise reflected insights that can only come from representing over 100 police officers in moments immediately following their critical incidents. Why do you need a labor attorney representing something that's force science that's supposed to be teaching about, psychological behavior, psychological factors, behavior, and memory?
Yeah, so Laura Scary is an operational attorney as well. So when an officer is involved in a critical incident, she's the attorney who actually shows up to the scene. And so she's very familiar with the human performance issues in the immediate aftermath of shootings, and also the legal issues. So what she's trying to do when we're teaching investigators and those who evaluate cases, what they can expect, a lot of people have never done these before, what they can expect in the immediate aftermath of a shooting, particularly in relation to the officers that were involved. Laura Scary is an incredible resource for that purpose.
You're not a big fan of progressive police reform, are you?
I mean, there's some aspects of progressive police reform that I think are fantastic, and there are some that I think are either beyond human performance capability or they just reflect a very different priority than traditional law and order interests.
Okay. This is one of the articles you wrote on that, isn't it? 2021, progressive police reform.
Yes.
Okay. In this article that you wrote, you really don't like body cameras, do you?
I think body cameras are amazing tools.
You wrote, if you believe that police are racist, abusive, and corrupt, then it makes sense to mandate body cameras and enact policies that prevent pretext car stops, restrict consent searches, and limit investigatory stops. That doesn't sound like it's an amazing tool to me if you think the way you're mandating them is because their police are racist, abusive, and corrupt.
Will you read that again? I don't know
Sure.
what you're talking about, the body cam. You can just read it, that's fine.
I want to make sure. Go ahead. You read it. Top paragraph highlighted.
I think you need to read the entire article. In fact, I would encourage you to.
I've read the entire article, but that's your line you wrote. It makes, if you believe that police are racist, abusive, and corrupt, then it makes sense to mandate body cameras. That's your sentence you wrote. Correct?
I wrote that.
Okay. You also wrote that if you believe that police profession is illegitimate and untrustworthy, then it makes sense to construct and empower layers of civilian oversight. So you don't like civilian oversight of police, do you?
No, I do like, well, civilian oversight, yeah, I do like civilian oversight and political oversight of the police. Would you like me to read the entire article? It'd be great.
No, not really.
I suspect not.
We just need that one sentence. I mean, I don't know how you can put it in a better context, but no.
Have me read it and it'll be a better
Sure.
context.
Well, you're okay with civilian oversight of police?
Yes, I think civilian oversight, one of the things we learned about civilian oversight, there was a risk, or there was a belief that when you bring civilians in to evaluate police, the first thing you have to do is get them to see the world through the lens of the police officer. And so that required training. It required them to actually go through what police officers go through the simulators, and to understand the law. And then we put them in a sim to understand the reality of it so they could feel it. Then they could actually engage in honest accountability. Civilian oversight, people got nervous because they thought civilians were going to be harder on the police. What had ended up happening is civilian oversight actually was a lot more liberal with police performance than their actual police officers were. And so any concerns about civilian oversight really came down to, are the civilians who are conducting oversight doing it through the lens of a reasonable officer, or are they coming in to conduct civilian oversight and actually intentionally not allowing the officer's view? Civilian oversight in the progressive reform area, there were some examples of it where they would say, if you want to belong to the civilian oversight board, you cannot have been a former police officer, you cannot be related to a police officer, and you could not have gone through specialized training for police officers. And so when we started to see that, we would push back on that kind of reform effort, because it was actually having people, civilians, evaluate police without actually doing it through the lens of the officer, which is what the law required. So these are debates that are happening across the country. So to ask, do I like them? My answer would have to be, well, which one?
Well, you made sure that when you have a son that's a police officer, correct?
Well, to be,
it goes right to his statement about, so I got a quote regarding civilian police.
His son?
Well, it pertains to his son. You select, your comment, you selected a department where politics hadn't infected the agency or civilian leaders for him. Isn't that true?
I think she sustained the objection.
Well, I read the quote. She said.
I appreciate that.
Well, it's a different question. The quote is, you made sure that politics hadn't infected the agency or civilian leaders where your son became a police officer, right?
Objection, Your Honor. This is the same topic, so.
What?
It's the same topic, but.
About his son,
that
how is
wasn't
his
the
son
question.
relevant?
So, you asked a question, she objected, I sustained the objection, you asked another question.
Rephrased it.
And then he said, oh, you sustained, but he didn't mention son the second time. Then the third question, now here's the son again, so.
Well, this goes
You
to,
can ask the second question again, and then you can bootstrap that to make it relevant, but
Well,
whether or not his son is a police officer, I think is beyond.
correct. But
There is an
the thing is where he goes, why he chose where his son went. And that's what his quote was, that civilian review boards where civilians hadn't been infected.
Right, so the second way that you phrased the question was fine.
Okay. So you made sure that politics hadn't infected the agency or civilian leaders, correct?
Yes.
You have a problem with prosecutors who try and hold police officers accountable, don't you?
No.
No. Do you remember talking in once again, Betsy Brainer Smith? I think that's how you say her name, nationalpolice.org, NPA?
Yes.
Do you remember telling her you have a problem with prosecutors who charge police officers where you lost the gatekeepers? Progressive reform activists trying to hold officers accountable are doing it unjustly if they don't know what they're doing, or corruptly if they do. That was your quote. Do you remember that?
That's absolutely true, yes.
So that's so I'm a progressive reform activist prosecutor.
You asked me if you are? I don't know you, sir.
It's your mission right now to be here, right? You're the tip of the spear. You said that before, haven't you?
when I talk about, typically I talk about a consulting division, because what we do is we're going around and we're training a lot of investigators and evaluators on the types of issues to look for, the human performance issues that impact perception and cognition. And then what we do in the consultant division is we actually take all of that to real world cases. So when I talk about the tip of the spear, I'm talking about if our arguments aren't persuasive in court and they're not persuasive in agencies, then we have to do a feedback and go back to the trainers and say, look, these arguments aren't working, these things are not, we're not being persuasive in these areas.
Okay. Do you remember Eric Hine Academy, a guy from, I think he's from Holland, you talked on a podcast with him?
Yes.
Okay. Do you recall saying, my personal mission right now is to ensure those officers who are having juries, legislatures, their own chiefs, administrators, and prosecutors indict them in a court of public opinion and criminal cases without any knowledge of human performance. I want to be there with them. My job is to be there in that courtroom. That's what you said.
Right. So what we're saying, like we talked about earlier, like honest accountability versus corrupt or unjust accountability. The two standards are, if a prosecutor is trying to hold an officer accountable to a standard that is vague, uncertain, and the officer's never heard about, then that would be a standard by which an officer could not predict the lawfulness of their own performance. That would be unjust or corrupt accountability. If a prosecutor is attempting to hold an officer accountable to a standard that is beyond human performance capability, that no human could do, then that is also another example of what I said is, if they do it unknowingly, just because they don't have an understanding of human performance, then that's unjust. If they do it intentionally, then that's corrupt. My job and our job is to ensure that the triers of fact understand the reality of human performance in critical instances, so that we have honest accountability, not unjust or corrupt accountability. So we are 100% committed to honest accountability of police officers, and that is part of our mission statement.
Going to your actual report, one of the things you talk about, you kind of very similar to Professor Stoughton. You talk about when you look at a use of force event, there's got to be intent, means, ability, and opportunity. That's how you phrase it.
Correct.
All right. And intent means somebody wants to do it, right?
They're willing to. Yeah.
Willing to. Means they have a weapon system.
Right.
As I think you said it. Ability means physically upright and mobile. And opportunity is a position where the weapon system could actually reach you. That's
Right.
how you phrased it in one of your podcasts. You don't like, in terms of determining that, you don't like the American Law Institute, new standards where they talk about necessary. Officers struggle to understand necessary, proportional, and minimum force standards, right?
Right.
Okay. But one of the things you did in this case is you said Patrick had intent because he had disproportionate resistance, right? That was your statement, right? Disproportionate resistance. Patrick engaged in disproportionate resistance, ergo, the officer could assume he was going to use the taser on him.
Yeah, so when an officer's evaluating a suspect's conduct, remember it's based on training, education, experience, and reasonable inferences. I think the statement that he's making is when the officer sees somebody who is resisting at a level that is disproportionate to the suspected offense, that it is reasonable for that officer to believe that there's much more going on, and they have to prepare themselves for the fact that there might be warrants, there might be weapons, there might be undiscovered crimes. And so is it reasonable for an officer to believe when someone is fighting you, you think you pull them over for a turn signal violation, and they're fighting you at this level of aggressiveness, for example, that it's reasonable for an officer to infer there's something more serious going on that this guy's aware of that they've yet to figure out.
But that's what I'm saying. But for the officer, you don't like proportional use of force. So you can use it against the victim, Patrick, because he's disproportionately resisting, but an officer, proportional level of force, they don't know how to use that. That's crazy. How do you expect them to do that? That's your position, right?
No.
No. Well, as you said, officers struggle to understand necessary, proportional, and minimum force standards.
Right, so these are not standards that are typically involved in constitutional policing. These are not standards that officers are trained against when you talk about. In fact, Stoughton and his academic colleagues have written articles to try to incorporate these standards because the current standard doesn't. So they're advocating that necessity and proportionality and minimum force necessary. So if you imagine for a second, again, it is beyond human performance capabilities for a human to look at another human and know what is the minimum force necessary to arrest this person and overcome resistance that they've never felt. And yet we'll see that language sort of incorporated because it sounds great, right? But we wouldn't ask a firefighter to put out a fire with minimum water necessary. We don't ask wrestlers to pin somebody with minimum force or football players to tackle with minimum force because a human cannot possibly know what that is in advance. So this was the argument I was making and trying to point out that these vague standards that have not evolved through case law, officers don't know what they mean. And so we have these conversations. These are the academic debates we spend an awful lot of time. So, welcome to the debate. These are things that are not well settled. These are things that academics want to have to wrestle with, and they're wrestling with them in courts as we speak.
And so you don't like them. That was my point. You don't like minimum standards. You don't like proportional use of force, right? You don't like putting that standard on an officer.
I don't like any vague standard that doesn't allow an officer to predict the lawfulness of their own behavior. So if you tell an officer you can only use minimum force, and they would call me when these new standards for, again, a lot of the progressive reform efforts were coming after, they were coming fast. And so agencies would call and say, hey, we got this new policy, officers have to use minimum force or use only force that's proportional. What does that mean? And we would say, that has not been decided yet. We don't know. And so until those things are fleshed out, either defined in terms, this is what we discussed in Bakersfield with the ACLU, they were using terms that police officers had never heard before. And so, and I got them to agree that we cannot have standards that don't allow officers to predict the lawfulness of their own behavior. They're like, of course not. That's a due process violation. It's absence of notice sort of thing. If the officer doesn't know what's illegal, we can't hold them accountable for violating it. And so my objection was when we start adding all these new terms, and I've got a slide with like 15 different terms I've seen, officers don't know what to do with them. So that's what I was pushing back against. But in my academic capacity, those are just discussions we're having until those things get fleshed out more, either in courts or through legislation.
But it's okay for an officer to determine disproportionate resistance from a person.
Absolutely, yes.
One of the other things you said, the basis for why this was justified is that you even talked about it to the jury, MMA, right? You said, in real-world combat sports and law enforcement experience confirms that suspects can turn explosively from the prone position. In wrestling and mixed martial arts, MMA, fighters routinely explode from a prone position to reverse control over their opponent.
Yes.
Okay. So you're comparing Patrick to an MMA fighter. You get to react like that.
I've seen that in jiu-jitsu, not just MMA, with brand new kids who've never been trained before or adults who've never been trained. It's a human I'm comparing to another human.
So even though MMA fighters go through 3 hours of training every day, 2 hours a day, or 6 hours a day, that's a very different thing than Patrick, who's an African immigrant with his pants falling down and barefoot out on a grassy front yard, right?
Yeah, completely unrelated, yes.
One of the other things you talked about was his superhuman resistance. That was your words in the report, right?
Yes, I think I used the word superhuman as what it was perceived to feel like, because all of the efforts that the officer was putting into it was unable to overcome the resistance. So what that's often is like, it feels like it's superhuman resistance. Superhuman, it's not a legal term of art. It's a lot of resistance.
So you're taking that inferences from his statement, that suspect's superhuman resistance.
Yeah, it's a characterization of the level of resistance an officer in that position might have characterized it as.
So what Patrick did was beyond human, having a higher nature or greater powers than humans have. That's what you saw in the video?
If you're going to read that word literally, I suppose that's what the dictionary would say. That was not how I intended it,
You're
certainly.
a lawyer, right?
I am.
Lawyers use words, right?
We do.
And so words have meaning, right?
They do.
So you put in a report that a guy who stood up and walked across a yard was superhuman, right?
Well, the characterization of that force would feel like that.
He didn't have superhuman speed, though, did he? Because clearly he got caught.
He did not have superhuman speed.
But just superhuman strength to be able to stand up, right?
The literal definition of superhuman, I suppose if I go back and rewrite it based on this cross, I would use a different word just to avoid this, but the concept's the same, which is when you're trying everything you can to overcome the resistance and this guy's standing up, you're an adult male and another adult is standing up with you repeatedly and there's nothing you can do to stop it. I use the concept of it would feel like almost like superhuman strength in that moment. Like this is not consistent with my understanding of past practices on trying to control a human. But yes, the word superhuman was probably not the best choice of words.
Your Honor, I got maybe a few more. I don't know if you're going to stop now. I think I could wrap up here relatively within the next 5. Well, I can stop there. I don't want to get into a minute, so I can wait till Monday.
Quarter 2, so what we're going to do is stop here.
we want to meet in chambers again on God's schedule? Because now you're still continuing testimony and we still got to go over jury instructions too, so I don't know if you have time right now.